Because as long as you, like I started to keep saying it, as long as you just keep saying I'm a man, and I don't, and I don't believe any man or any woman in this court has jurisdiction or control over me, because that's all jurisdiction means. I don't believe any man or woman has any control or jurisdiction on me, because I don't believe I've ever harmed any man or woman in this courtroom. I don't believe I've injured any man's or woman's property, and I don't believe I lied to any man or woman, which is a breach of a contract. I don't believe I lied to anybody, so I don't think anybody has a claim that I've done anybody in this room wrong. Is anyone going to step forth with their claim? I'll be glad to compensate them. That's simple.
And it's exactly who you said, the prosecutor. Prosecutor's running the show. He's the one who's got the claim against you.
All right, the prosecutor must appear. The plaintiff must appear. Right, so if the prosecutor, it says the plaintiff is the state of Indiana, the state of Indiana must appear. So you can cross-examine, your accuser. If you could afford a process server, I know they're only $55. They're not a lot of money. If you could afford a process server, let them always serve the other side for you, because they do a fantastic job. They give the beautiful documents, man, and it's worth the $55. And I couldn't believe how professional it looked. And when it went before the court, they couldn't deny that other party definitely got the paperwork delivered, and they said we're authorized representatives to receive all legal documents. I was like, oh, yes. So that went right into the case. I was like, lovely. If you look at my case that I filed on my website, you'll see I used a process server, and you'll see the template that he used, and it's beautiful. Like when I went after the DHR, it says I'm an authorized representative of the DHR to accept all paperwork, legal documents, on behalf of the DHR. I was like, oh, my God, that's perfect. They've been served.
Hey, I just want to know, what would be the best way to get rid of, like, if you got an attorney, like a public defender, what would be the best way to get rid of him?
Why would you want to get rid of them? Why don't you don't get rid of them, man. They're a great asset, man. What you go to you tell the court, who's ever moving the case, whether it's the state or whatever, say you're going to take your attorney and you can make him a co-counsel.
Okay.
So that way he can't enter contracts without your consent. He's just going to sit there and be an advisor. It's like, look, you might not like any of the advice this guy gives you, but it's always nice to have somebody say, oh, what did he say? He said over the dictum. What did he say over the dictum? What does that mean? It's like, oh, the judge is just giving you an opinion from the bench. It's like, oh, okay. So like I said, if the guy says, we're going to hold this in abeyance, we'll be back in 2 weeks, you can look over your co-counsel and say, what's abeyance? It's like, well, they're just going to stay. They're just going to ask for a little time out. Nothing's going to change until we come back in 2 weeks. So having a public defender is not a bad thing, like I said, until you figure out what the hell's going on, because, that's the best, quickest answer I could give you, because I don't know the whole damn details of the case. But a public defender? No. You could accept a public defender just like anybody else who's on your team. 300 people show up in court behind you and they say, hey, we'll counsel you too. We'll help you through this. It's like, okay, you'll just sit there behind me, and when I need you, I'll let you know. But that's all. You put him back. He's like, okay, you just sit back behind me. When I need you, I'll let you know.
Yeah, the reason why I was asking that because I got arraignment coming up, so I was trying to see if the public defender's going to try to move.
You got to go on this guy's. You got to go on this guy's thing. I guarantee this guy Dennis from Pennsylvania got something on there that says how do you do an arraignment. I guarantee it. I've said how to enter into an arraignment 10,000
yeah, I know. Yeah, I know what you said, Carl, but with that public defender, you still do it.
What I'm saying, this guy Dennis in Pennsylvania, I guarantee he's got a 3-minute little thing or 5-minute little clip that says what does Carl say to do when you go into an arraignment. You're just basically looking for a claim. You're looking for an injured party. You're looking for damages. You're looking for anybody who wants to say that you've done something wrong. That's all you're doing. You're just going in there saying, I'm here to settle a debt. I'm here to settle any fucking claim. That's all I'm here to do. And you do it in writing. You don't do it with your mouth.
Right. I understand that, Carl, but when you got that public defender, can you still do that?
You're doing it in writing. Yes, you go over to the other side. You give the court notice that the public defender is going to be your co-counsel, that you don't require anybody to act in your behalf. You could do the job all on your own, but it would be, thank you for giving me this public defender, but now I'm going to reduce his or her role to that of a co-counsel.
So that goes for anybody. Anybody that's on probation, they automatically have jurisdiction over you. Period. Correct?
Oh yeah. Oh yeah.
So
And if you don't get, go back to the court of original jurisdiction and get that confession off, or out of the file, because you know what, you probably made a record of it. You probably had to say that you did wrong in open court.
They just said just to plead. That was it. I mean, I just plead.
Yeah, but they said to you, do you understand the nature of your crime? Do you understand the da-da? Do you understand the da-da-da? Do you understand your waiver in a trial? Do you understand the da-da? Has your counsel explained to you that you waive your right? Yeah. There you go. You did it in open court.
Right.
So you got to show that at that time that you had no understanding, that you were a complete idiot. Yeah. You had no capacity to contract because you had no idea, because you actually thought you did something wrong, and now that you've been made aware, you know what? I never harmed any man. I never injured anybody's property. I never breached any contract. What the hell was I thinking?
Right. Exactly.
That's all he's doing.
Right. Yeah. So
and just let them deal with it. And just let them deal with it. What do you think they're going to do? Say, oh, that's bullshit. You knew what you did was wrong. Oh, really? Why, do you think I did wrong? And they'll say, they can't say that they know you did wrong.
Right. I got you. All right, so I'm gonna go back to the original. So he said the prosecutor.
Because if they say, yeah, you did wrong, good. Put it in writing and sign it. Say, I, Dan, by having 10,816 kilos of cocaine in my trunk, was the wrong thing to do. Say it was wrong. I say, I'm not going to sign that. You already admitted it. It's like, oh, then if you're so wrong, and why don't you tell me it's wrong? Well, I'm not going to tell you it's wrong. You already told us it was wrong. You guys confess all the time, man. It's scary.
Yeah. And
you didn't do nothing wrong, but they led you to believe it was something wrong, and you just said, you know what? Okay, it's wrong, because why? This guy said it. Okay, not only did the guy say it, now tell him put it in writing and sign it.
Gotcha.
Right. They have you sign a confession.
Right.
They don't sign it. You do.
Right. Because I got full liability.
That's right. Is their name on it? No. You tell them, hey, you know what? If I did wrong, why don't you sign your name and say I did wrong, and then I'll sign my name after that. How's that? How about you put your name on there first?
When we go in there, we are just a piece of paper to them. That's it. Because it's a two-dimensional piece of paper that they're going after.
That's right. That's right. Yeah.
So that's it. So that's why you got to put it on paper to address it. So to address it, they're not going to listen to you. That's why when I handed, I didn't, but the sheriff came over, because I noticed something, and I don't know if other people noticed it. But do you know what happens when you get close to the bar? I mean, you get close right there to the gate
to
right
the bench.
there. You know what I'm saying?
To the bench or the gate? You mean the bench or the bar?
No, I'm going to say the dock. How about that? You know what I'm saying?
Sure.
That's the dock.
Yeah. That's
the dry dock. So if you get into the dry dock, or if you're in the dry dock, the only thing you got to do is just hold up a piece of paper, and guess who's running to come get it?
The bailiff or the sheriff, yeah.
That's right.
So the next question was, do you realize that we are of another or a foreign culture? Or leading up to something, and we did no wrong because we didn't realize that this was we do this stuff in our culture, but if it isn't good enough for you guys, well, I didn't know. We're of a foreign culture. How would we know? But the example.
A good example is if you come over from Italy or whatever, and you go meet the Queen, and all of a sudden you just rip out a monster burp right there in front of the Queen after she gives you something to eat in Italy, they'll say, oh, see, they love your meal. And the Queen will say, what the hell just happened? Don't you know the law? If you burp in the Queen's presence, it's off with your head. They say, oh, you got to beg forgiveness, man. I'm from Italy. I'm from a foreign culture. I don't understand your jurisdiction. I don't understand how you control these people over here. I don't understand that's the law of the land. I don't understand. So I'm going to have to please beg forgiveness, and I won't do that again, because there's no criminal intent. You didn't believe there was anything harm, wrong, or anything that you did. There was no injury. I didn't believe that there was a bad thing to do. In our culture, that's a wonderful thing to do. Give the finger to the Queen or burp. We just thought that was a accepted practice around the world. So go ahead. So that's what probably was leading to that one. The judge knew what I was doing. let's do a court scenario. Are you suffering for the acts of the policeman? He broke your arm and broke your legs. Are you suffering because of that? I said, what would you say? He said, yeah. I said, well, that means that you accepted it, you allowed it to happen, you had the ability to stop it, and you didn't do it. He said, what? And he looked in the law dictionary. He said, oh, my God, that's exactly what suffering means. I said, yes, next case. And you guys would curse me. Your grandkids would curse me. How could this effing judge rule against my dad? How could he rule against this good man? The policeman broke his legs. The judge asked him one question. Are you telling me that you're suffering due to the acts of the police? Yes. Okay, you allowed it to happen. Next case.
Right.
He said, no, I didn't. Dude, if you don't know the simple words that you're using in court, just a simple word, you could master all these effing words that I use. And if you, and one judge like me could come along and trick you and say, did you suffer by the acts of the policeman? Are you suffering because he beat you and broke your arms and twisted your legs into a pretzel? Is that what you're saying to the court? Yes. Okay, next case. And you're like,
right.
What, you effing judge, you black robe mother effing cursing mother effing monster, you damn your children for generations to come. I told you, man, I'm suffering because what the cops did to me. Good. Next case.
Well, there's not that many words that need to be learned, man. We just got to learn them.
Well, what I'm saying is, when the man opened up the Black's Law Dictionary, the first thing it said to allow, to permit. And the guy's like, oh, my God. He said, that's how you get rid of me? Dude, all this bullshit reading and writing you've been doing for 10, 20 years, I just fucking destroyed you in 3 seconds.
Right.
You don't think you're going to walk into court because you listen to 5 of my shows and watch the YouTube video of Billy Thornton. It ain't going to work. It's a lifestyle. It's a belief. It's like a cult or a religion. There's a faith that you have in this. It's not going to just work because I give you a couple of words to utter in court. It's not Harry Potter.
No, I
it's not
understand
going to work like that. The judge is going to test you and try you. And you got to be tough. And you got to be sincere. And you got to be real. When the judge asked Bali, do you want the witness to be called? Bali was going to yell, yes. I jerked that guy so fast I said, shut the fuck up, look at me, and do exactly what I say. You tell the judge, no. No, you don't want him called. You require of him to call him. There's a huge difference. And I am telling you that, Denny, I'm telling you, Denny, if the judge said to you, do you want me to call your witness? You'd say, yes, I want to call a witness. Oh, shit.
Never got
now
to
the judge could deny you. Because when you ask, do you want me to, that's like saying to Mommy, Mommy, I want a lollipop. She's going to say, go F off until after supper. I know I'm a man. I'm a man, and I want for nothing. I require of you, Judge, by authority and by right. You are my servant. Call the witness.
How would a man or woman from DMV to get them to say that they owe a debt?
DMV is easy because all they have to do is show that there's a contract between you. You just have to show them that you were not operating under the license at the time of the stop. That's the whole trick. You just get them to say, like, oh, do you believe that I was operating under the license at the time of the stop? And it's like, no, I was just a man going from point A to point B in my car, on my rocket sled, on my reindeers, on whatever you felt like transporting your body from point A to point B. You just felt like going from point A to point B. Don't even use the word travel. Just say, I use these reindeers to go from point A to point B. I use this car to go from point A to point B. I use this rocket sled to go from point A to point B. Did I cause anybody harm? Does anybody file a case or a claim against me? Have I caused any harm by doing such an act? And there you go. You just got to show them that they were in error when they filed their case, that their case was filed in error because you were not operating on the license at the time of the stop. That's all. You were just acting as a man going from point A to point B. And you just use that driver's license as a form of ID. That's all.
I got a question, man. A buddy of mine, he was at his home for New Year's, and the police knocked on his door, and he didn't answer the door, and they kicked it in, tasered him, and came in the house with like 10 or 15 cops and took him to jail. And I've been listening to your show for a while, and I just want to make sure that I'm doing the right steps and, getting this guy his remedy, because it definitely wasn't called for.
All right. So when they, what was the probable cause why they kicked in his door? What was their belief?
They said someone had called the police and said there was domestic violence, but the neighbor who was actually had her child in the house too, she met the cops at the door and she was like, "Please don't go in there. There's nothing going on in there." And they went in there. The kids were asleep. There was no arguing going on. It just was a false report. But
okay, what I'm saying, okay. She said it was domestic violence. Was it a public housing or was it was it a private? Was it public housing? Like a Section 8? No.
It was a straight up apartment. That was his property.
Okay, well then there is no such thing as domestic violence within a closed domicile. Domestic violence is not in public. Like you can't slap your kid in Walmart. That's domestic violence.
Okay.
When it's inside of a four closed walls. Read domestic authority doctrine. It's under Curs Juris Secundum. I think it's like Section 80. Okay. 84, something like that, but just look at, Corpus Juris Secundum, right? CJS, right? Okay, just read about domestic authority and the domestic authority doctrine and domestic violence. And it clearly says that, within your domicile, within your home, you can do whatever the hell you want to maintain.
They're not charging them with that, though. They're not even charging with that.
I'm saying that is the cause. I'm trying to say. Yeah. You said the reason was they used domestic violence. That's right. If he did it in a parking lot in front of the house, or if it's fine if he did it in Walmart. But they knew that was a house. So even if there was something going on in that house, they had no authority to go in that house without a warrant.
Check.
And then he has to accept the warrant.
Mm-hmm.
If he doesn't want to accept the warrant, he doesn't have to let him in.
Gotcha.
See what I'm saying?
I got you on that. So the process, when I know they're in the wrong, I understand that, and I'm definitely gonna look up the course of them. But what I'm trying to make sure that I'm doing right is they charged him with disobeying a lawful order and resisting arrest, and he's got a court date.
What was the lawful order?
Who knows? They're in his house. Who can, you know what I'm saying? Like, how you gonna give me a lawful order in my house?
What I'm saying is you guys got to start understanding what domestic violence is. There's no such thing as domestic violence inside of your house. Domestic violence is within their authority. Like I always say to people, Hillary Clinton gave a best example of that in Syria. The United States wanted to go into Syria so bad and just kill that king of Syria, just go in there and just wipe out the whole entire Syrian army and knock out everything in their path. But Hillary Clinton, since Russia was watching us really closely, she said, honestly, we can't interfere with somebody else's domestic authority. We're not invited to come in. Until we're invited to come in by the king, which obviously he's not going to invite us in because we want to take him out, obviously we can't cross the border. We can't cross the threshold. We can't go in there. Yes, he could kill all the women and children that he wants. He could kill and gas all the women and children he wants. He could kill all the women and children he wants because that's under his domestic authority. We can't violate the domestic authority doctrine. So believe me, the United States government knows what a threshold is and knows that you could kill women and children, and there's not a damn thing they could do about it. It's the law. It's that simple. So don't say to them, oh, well, I wouldn't open my door because you believe domestic violence is going on. Oh, so you believe this was a public building. You believe that you had some sort of authority and control over the affairs of state that operate within these four walls. Is that right? You also believe that I can't smoke dope, smoke crack, or grow fucking crystal meth in here if I want to? Is that what you believe as well? Really?
How about I reckon?
So Carl, let me ask you this, Carl. So in that situation, if they came knocking on your door and everything else, so are you saying that a person should just open the door and
no.
keep?
I do the same thing for them. If Jehovah, well, you know what I'm saying? I'd do the same thing if kids were knocking on my door for Halloween candy and I didn't have none. I just ignore it. It's just like
Exactly.
a kind of thing. So what? I don't see any benefit opening the door for the kids if I ain't got no candy. I don't see any benefit opening the door for a cop with a gun. I don't see any benefit if the guy wants to rob my house. I don't see any benefit opening my door for a robber.
Okay, let's ask this question in. Let's say you don't open your door and they just take it up on themselves and they just knock your door down in and then they taser you and then they take you to jail. So and then they make up these accusations. You just fight that a different way then, would you?
Yeah, I just make a claim that they trespassed. A claim of trespass.
Okay, that's what the call is getting to.
That's all I do. And
the statements of facts?
It'd be 2 sentences long. It'd be the claim of trespass. I made a claim of trespass. Bob trespassed. You know, Bob owes me $1 million. That's it. Bob knows what he did.
Mm-hmm.
Doesn't matter if he's Bob knows what he does. You don't say Officer Bob. You don't say Officer Bob. You don't say Sergeant Bob. You don't say Corporal Bob. You say Bob, a man. Kicked in my door.
They're giving me a runaround on trying to get the man's. I can't get the man's information. He didn't sign anything with his number on it. I've called the police station. They send me through the rigmarole. People on vacation and all of this. So
he's going to have to appear. The man who kicked in his door is obviously going to have to appear in court to press charges, ain't he?
Yeah.
There you go.
Okay. Then get him. Then okay. I was trying to be on top of it.
Well, no, you could do, obviously, you can talk to the prosecutor and say, don't I have the right to discovery? Don't I have the right to have a deposition or depose the officer? Just go for a deposition.
Go for a deposition.
Deposition. Then you want to know, because all the information that cop has, it has to be made available to you as well. So you want to deposition him or depose him, whatever you guys call it. You guys either call it deposition, disposition, or depose. Depose. So they're going to say either disposition, or depose.
All right, so file a claim after the disposition.
Yeah.
There you go. Then you got all the information on the guy.
In other words,
and that's to the county court. And that's to the county court with the JS-44 form and the 360 block and diversity, correct?
No, well, obviously I don't use the JS-44 form at all, man. Why would I want to use the JS-44 form? That's federal.
Okay.
Why are you going to the federal level? Why don't you just take it down to local county? No, I just take it to local mom and pop county courthouse. Make a 2-sentence claim. Whatever if Bob wasn't wearing a badge and he came kicking in your door, how hard of a lawsuit would it take you to write down, Bob kicked in my door, he owes me $1 million?
But where? Okay, you say go down to the county courthouse. There's no form or that I have to go through them to file? Okay.
No, one more time. If I kicked in your damn door, my name is Karl Lentz, how hard would it make you make a lawsuit? Karl Lentz kicked in my damn door, he owes me $1 million.
Not hard at all.
What kind of form would you need to do that?
I'm just trying to cover all bases.
You wouldn't need any damn thing. You just go in there and you just say, Karl Lentz kicked in my damn door.
And then I hit him with the process.
And
then I get the process. Then I get the process server.
Yeah, you better believe it. You pay the $55 to get a process server. Bali had a great time with his process server the other day. Bali had to pay $80, which is $136 in American money. I said, wow, that's a lot. He said, but it was worth it. I said, why? He said, because when he handed it to Barry Ross, the cop, he said Barry Ross refused service. So he said the process server said, fine. He says, I'm still going to fill out my affidavit with the court that you've been served, and I'm laying it at your feet, and you can do whatever you want with it. So it's funny. He said Barry Ross picked up the cop picked up the paperwork and threw it all over, opened it up, ripped it up, and threw it all over his yard.
Hey Carl.
What's great about that is now he's been served. He's got 21 days to answer, and it's done. Now, if he wants to put the pieces of paper together and try to read what he wrote, that's fine. If not, he's still only got 21 days.
So I don't sue the other cops that came in the house or the police department or anything?
You could sue every single man. You can't sue a police department. You can sue the man who walked in the door. You can sue another man. You can sue another man. You can sue another man. Any man that you've seen in there, there's no such thing as men. You could sue whatever man and another man and another man.
And we got a process server each one of those guys.
Each one.
Yeah, each man. Right, each man. If you believe, I'd just go after the one man.
Okay.
I'd just pick one man and go after that one man and let him say he didn't do it. The other guy did it.
Yeah.
Because they're all covered, man, for at least $1 to $1.2 million each man. So just go after one man.
Okay.
That's what I would do. Just if you go after one man, and that doesn't work, guess what? You got 9 other chances in court to get it right.
And caller, what is your name, caller?
Say again?
What is your name?
My name is Chris.
Chris?
Yeah.
Okay,
Well,
Chris.
I'm calling out.
What I'm saying, Chris, like say there's 10 guys that came kicking in his door, okay? You go after one guy at a time. Obviously, if you mess up on that one, you got 9 more guys to go after, 9 more chances to try to get your shit tight in court.
Mm-hmm.
See what I'm saying?
Mm-hmm.
You don't want to put all the eggs in one basket.
Okay. And how would I go about helping him? Because I've been giving him this information, but you know what I'm saying, he's going to get involved in it, but I also want to be there to help him out.
You be his next friend. See, in England, the judge called me a McKinsey friend. I don't know what a McKinsey friend was, but somebody explained to the clerk lady said it's the same thing. In the United States, it's called a next friend. But in the UK, it's called a McKinsey friend. They let you come up there and they let you talk. He goes to guys confident. But here in the United States, we call him a next friend. Like I'm his next friend. That just means that you're going to talk because the other guy can't talk for himself. And then you can run a common law court, dude. You just explaining, exactly what you're doing. And if the other side doesn't bother, like I said, until you go into the courtroom, it's too late for the other side to object. It's too late. You've got to read the rules. I'm sorry you didn't read the rules. The rules are that I'm bringing in the next friend. In the common law, we could do that. We could bring people in to talk for us.
And you say the rules. What do you? And is that like a list of rules or?
Nope. It's the customs of the people. It's the customs of the people.
So that's whatever.
You say where I come from. This is how we roll.
And
if
one
you can't speak, I'll speak. There you go.
Yeah.
And Chris, one way of finding that out, Chris, is to go back and listen to a couple of his shows, several of his shows, and explain the process of having your own court. And your question helped quite a few people out on the chat because they was wanting to know something similar to the same thing by being roughhoused by in these different agencies and everything that we have to do just that. But the process is, you let them run their process. You really, if you listen to Karl's shows, he'll really tell you how you set them up by you. They're going to go with their court and everything else. And when you get ready to file your claim, you're going to have everything you need in that case file when you file your claim against that complaint that they did to him, because whatever charges and everything else they filed against him and everything else, well, you're going to be able to find out who that person was, who's bringing the claim against him. And when you do that, you're going to bring that into your, who's bringing the complaint, who's bringing a complaint against him, you're going to be able to file that claim, which would be against whatever man that is that wrote the report or whatever. And you'll be able to find that on.
You see that lawsuit I did in the United States. You see what I did in that federal court down there. I put all those notices, and when I was putting the notices in, I was giving everybody the rules.
Okay.
The rules by giving them all those notices. It's like, this is what I consider jurisdiction. This is what I consider the venue. This is what I consider, the plaintiff. This is what I consider a claimant. This is what I consider a defendant. This is what I consider a respondent. I'm giving them notice, so nobody can say they didn't know the rules. I gave them the damn rules through the notices. Now, nobody objected to those notices.
And one of the notices that you gave was that any reference to being a defendant was going to be a contempt of court. And
well,
that was one of the rules of the court.
You're right. Don't call me a plaintiff anymore. I'm not a plaintiff.
A plaintiff, yeah.
I'm a claimant. Right. Any more reference to me, if anybody ever refers to me as a plaintiff, will be in contempt of my court. Because my court, the only thing that's defined is a claimant. Now, you can't call me a squibble. Why? Because squibbles aren't defined in my court. There's no such thing as a squibble or a plaintiff. I never heard of such a silly thing. What the hell's a plaintiff? How do I know? Plaintiff is a French fucking nagging woman. And that's actually what I put in the notice. I said plaintiff. Here's the definition of plaintiff in Webster's dictionary. When nagging, complaining French woman. Old lady. I'm not an old, complaining, haggard old lady. Stop calling me that. How would you like me to call you that, Judge? How would you like me to call you a nagging old hag? I don't think you'd appreciate it, so stop calling me that. I'm not a plaintiff. I'm not wretched. I'm not old, and I'm not miserable. That's what plaintiff literally means in French. Miserable, haggard, wretched. I'm not miserable, I'm not haggard, and I'm not wretched. Stop calling me names. Or you're going to be in contempt. It's just like saying to the judge, calling him dickhead all the time or fuckface. You can't do that. You're going to be held in contempt of court. You can't call them names. Don't call me names. You see how simple?
That's simple right there. So you suggested in your other calls to call the prosecutor and try to inform him that he was going down the wrong path by pursuing this and giving him fair notice. Yeah. But I've seen it. It's very difficult to get in contact with the actual prosecutor, especially being at this early stage of it.
No, it's real easy, man. Huh. There's a county prosecutor or there's got to be a state prosecutor. You just go to the head guy. You don't go to the low guy in a totem pole. If it's a state, if the state's going to have charges against them, obviously the state attorney general is the person that you send it to. You say, I believe that there's a state prosecutor, assistant state attorney general, who's going to be prosecuting this case in whatever court, Cook County Court. So I believe that he's moving in error. I'm giving you a fair warning, for him to cease and desist, or I'm going to have to file a claim of my own. Whatever. I'm just giving you a rough guess. I have no clue what your actual case is about.
You go to court, and there's literally over 100 people there that are there for traffic violations, either camera tickets or whatever. And then they play a video. An audio, actually, they play an audio CD or whatever it is, and they basically say that you can't speak or defend your case.
Hey. You want to know an easy way to do that?
Oh.
The day that you got the ticket, the very next day, you were supposed to be returning the ticket back to the person who's going to prosecute the case. You're not supposed to wait for arraignment. As soon as I got my ticket, way back in 2007 was the last time I got a ticket. I got it on a Sunday. Monday morning, I was at the prosecutor's office handing it back to him saying, I believe that this was issued in error. I believe that the man believed at that moment in time that I was going from point A to point B under some sort of a license. He's in error. Would you like to take this back, or would you like to pursue me into court? There you go. That's way before the arraignment.
Yeah.
What did he say?
What happens when you've had it for more than 3 days?
What I'm saying is the day you get the ticket, the next morning you better be at that prosecutor's explaining to him that this ticket was issued in error.
How would you know?
You don't wait 30 days. You don't wait 30 days.
Right.
The very next day, you better be standing in that man's office at 9:01 when they open up that door and say that this ticket was issued in error and I'd like to return it. If not, then I'm going to have to make a claim against you.
How would you know who the prosecutor is?
Well, how do you know who's prosecuting the case?
You ask the cop when he's giving you the ticket, are you going to prosecute this? Or you got a county prosecutor, state prosecutor. Who's going to do it? Where's his office? How do you think I found out? I asked the man a simple question. Like Magna Carta, and it's like, which version of the Magna Carta? There's 7 of them. Which one are you referring to? The 1215 one that was overturned basically within 2 months was considered a void document because the king signed it with a knife on his throat. I said, you can't have somebody sign a contract because a charter means a contract when you have your knife to your throat. I said, so you're trying to rely upon a contract that was signed by the king with a knife to his throat. I said, really? So, like I said, it just gets, like I said, then it was mind-numbing trying to do all the multi-jurisdictional synonyms and phrasings he was using. And actually what I wrote, I said, your tact is not so much an awkward array of multi-jurisdictional synonyms and phrasings as it's a mind-numbing conundrum. I said, when I read this stuff from certain people, you people are all over the freaking map. Said you're trying to use Queen's Bench stuff, then you're trying to use the Crown, and then you're trying to use Magna Carta, then you try to use the English Constitution. You know, which one do you want to use? Which one are you going with, and which one are you going to be able to support by bringing first-hand witnesses to the event of the signing? That that's exactly what Magna Carta 1215 said. Who are you going to bring to court to prove that somebody actually signed that thing and it wasn't signed at knife point? And that's truly what Section 60 or Section 31 means. Who are you going to bring forth? Nobody. So why are you wasting your time referring back to it in your court paperwork? I said, if you want to put it as an exhibit, that's fine. That's fine. You say, well, this is the way they used to do it way back then, and I don't think there's anything wrong with it. And believe me, if I get this in front of the jury, I think the jury will concur with what they agreed, what they found was a proper way of acting in 1215. I believe this will carry the day. To this day, I think it will carry the day. You know, they signed it 800 years ago, and you know what? Honestly, I think it'll still bode well today. I think it'll be fine. But you don't say, well, this is what it says in Magna Carta. Really? Were you there? Is that the original document? Where's the chain of custody since 1215? How many versions of that is there? Is that the original Magna Carta, or is it a copy of it? How many versions of them were written out back then? Because like when the United States had their Constitution, there was 13 versions. Every colony got a version. Every colony got a copy of the Constitution, and not one copy matches all the other copies word for word or by punctuation. None of them are all identical. They're all off just by a little bit. So which one is the true Constitution? So you don't worry about that nonsense. And you know, if you're a rich guy, you're a professor, and you got nothing better to do all your life is to sit there and argue which one is the true Constitution, well, go ahead and waste your life arguing about which one is the true Constitution. I don't give a rat's behind. All I know is it worked for them back then. That doesn't mean it has any kind of control over me now because somebody signed a contract for my benefit. Well, you know what? That's lovely. You signed a lovely contract for my benefit. Do I have to accept the benefit? No. And you can't force the benefit on me. So what's the purpose of the Constitution again? Just as a reference point. That one time in the past, somebody believed that this was the way to be. Okay. That's lovely. That's nice. But times change. People change. People aren't static. People aren't statues. You can't. I'm not rigid. I'm flexible. I'm I'm dynamic. I'm fluid. I'm ever changing. I'm not bound.
I don't know. He was chuckling. He says, "You want me to give you back your marijuana? Then I could just arrest you again." And I basically look at him. Well, we can do the pretzel thing here, but it's my property, and you took it. You can define it however you want, and that's all. And basically, the meeting ended kind of after that.
Yeah, because like that's what I'm basically trying to tell people. It's like basically what you say to them. It's like, I want my property. I want the restoration of my property. Unless, of course, you have a vested interest in it. Unless somehow you have a receipt and you prove that you bought some of this, or the county bought some of this, or you have a vested interest in it because I didn't pay taxes on it. You know, do you have a vested interest in this? Show me where the interest lies, and I'll be glad to compensate anybody with a vested interest. Just bring your claim forward. Just bring your claim that you have a vested interest in this property, and we'll work something out. Do you have any claim to this? How do you believe that you can rightfully claim this is yours? That's all. Right. How do you believe that it's yours? How do you believe it's more that it's yours than it's mine?
Well, they kept saying it was a controlled substance. And
yeah.
You can call it whatever you want.
You tell them I think I had it controlled very well. It was inside of a plastic bag inside of my car. It was well under control. You know, I had that thing totally under control. From the minute I bought it, to the minute that this man robbed me of my property, it was totally under my control. How was it under the control? Was it in the public? Was it causing a menace to the public? Was it out there in the public? No. It wasn't in the public, was it? No, it was under my control and under my authority and under my power. It wasn't out there in the public hurting anybody, was it? No, that was my baby. That's my property. What I'm saying is the state trooper, I asked him, I said, you do know what the word shall means? And he said, yeah, they warned us about like that word and people like you in the academy that, yes, we don't have, you can't do anything, but you shall do it, and shall is future tense. He says, yes, we've already been trained in the word shall. So thank God he admitted it, you know, that the academy teaches them that we can't order you as a man to do any damn thing with your property. And yes, okay, we can give you a ticket, but he's like, but how many of you people realize what the word shall means and we get away with it? It's like systemic. It's like, you know, it's a conspiracy to commit larceny. He admitted it to it. He was like, oh, my God. So it's like, you mean this is systemic? Everybody in the department, everybody who goes to the academy knows that the word shall means, you know, sometime in the future. He's like, yeah, they all know. But they still want us to write out tickets anyway. I said, well, that's just fucking like evil. If they know that it's not based on, you know, and your law clearly says, you know, and I said to him, I said, when he pulled me over, I said, I shall get it. He said, oh, thank you for reminding me that there's no tag on it. The sticker is old, that it went out on 2013, December. Thank you for letting me know, making me aware of it, and I shall get it re-registered. And the conversation with me and him should have ended right there. He should have said, okay, as long as you shall register it, yes, I shall register it. He should have ended it right there and said, good, I'm taking you on your word. Or he could have given me a warning ticket. But to actually give me a ticket in which he was going to charge me a debt, claim that I owe a debt? Ho, ho, ho. That was a mistake. Don't tell me I owe a debt, buddy. Because I don't have somebody else's vehicle registered when they don't even have to have it registered, when it's all advisory. Now you're going to fucking claim that I owe a debt? Ho, ho, ho. So he was a nice kid. I shook his hand. I said, good luck, God bless you, and have a safe day. Okay, now I kind of described to you what the word neglect means, and everybody neglects. I neglect my health. I neglect my work. I neglect my children. I neglect my responsibilities all the time because I got to go to sleep. You know, that's. I'm sorry, I can't be doing it. Why? I'm neglecting you. Why? Because I got to go to sleep, or I'm neglecting my health. Why? Because I think I ate too much table salt today. Oh, I neglected my health because I didn't eat 3 sides of vegetables today. Oh, well, I'm very, very neglectful. So what? To me, that's a lovely thing to be called. So you guys are being intimidated by words. You guys are being like in fear that somebody said that you're very neglectful. Oh, good. You know, I try to be neglectful as often as I can. You're not just flipping it around and say, so what makes you think that that's wrong? And do you know what the word abuse means? Nobody knows what the word abuse means. I wonder if anybody who's listening on the show right now could tell me what the word abuse means.
Doesn't that mean to cause harm to an individual?
Yeah, I guess that's what they taught you in school. Okay, but let's say I take a tree or a log, okay, and I chop this tree down, and I create a chair, okay. Now, and then I paint it with some sort of, you know, Krylon plastic paint, and you look at that chair, and I say to you, is that a wooden chair? Is that a plastic chair? Is that a steel chair? What kind of chair do you think that is? And you'd be like, I don't know. I was like, okay, I'll give you another one. Say there was a liquid container in my refrigerator and it was clear. And I say to you, well, I'll give you a hint. That clear liquid is wine. Now, is it peach wine, apple wine, grape wine? What kind of wine do you think that is? And you'd be like, I really don't know. Well, to abuse something means to take something from its original state and transform it into another object that you can no longer recognize it as in its original state. So I'd say, no, that's grape wine. It's like, but you can no longer see it as a grape, can you? Now it's just clear liquid. It's just, wine. Or that chair was an oak tree at one time, but you can't tell where it originally came from because I abused it. To abuse something is to take something and transform it into where you can no longer recognize it as its original object, as its original substance. So when they say when you abuse the child, so that's what I made a marmalade pie out of him. What did I do? Does he still not look like a child? Well, yes. Well, then how did I abuse him? How did I transform him from looking like a 3-year-old toddler? What does he look like now? A roast beef sandwich? What does he look like to you? Well, he still looks like a 3-year-old child. Well, then obviously I didn't abuse him. So what are you talking about? So see, that's what I'm saying. So you get these people have you terrified that you neglected the kid. Oh, I hope I did. Every now and then, you better believe I hope I did. And you know what? Honestly, I only want to spend about 5 minutes a day with the kid. The other 23 hours and 55 minutes, yeah, I'm definitely neglecting him. I'm not right up his ass. Why, you want me to be right up his ass? How's he going to learn? How's he going to grow? How's he going to function in society if he doesn't make mistakes? If he doesn't fall down? If he doesn't pick himself up and dust himself off? How's he going to accomplish anything? Oh, you mean you want me to just plug him into like a matrix kind of thing? You just want me to plug him into some sort of machine that's going to monitor him and make sure he's fine and functioning 24/7, 365 and has absolutely no needs, no wants, no desires, no hungers, no pains, no nothing. No stress, no nothing. You want me to just plug him into a machine somewhere? Is that what you would like? Well, yes, eventually we'd like all your children to be plugged up like that. Well, yeah, I know. But I'm sorry, until it's your property, don't tell me what to do unless you have a vested interest in it. A very simple placket that you guys are going to be able to just cut, copy, and paste and on your computer. And basically what it's going to be, it's just going to be a piece of paper that says, I wish to remain silent. It's going to say, I consent to no searches. And I want my lawyer present at this time. And you guys are just going to make it so.
What at this time?
I want my lawyer present at this time. And all I'm saying is going to make this little placket, and it's going to be free. I'm not going to charge nobody. You just got to
going to hand the top?
And just and just stick it and just
put it on the window.
Just put it on the window and say, I wish to remain silent. I do not consent to searches, and I require my lawyer to be present at this time. And that's it. So when he's asking you all this crazy stuff, it's just like, I wish to remain silent. I do not consent to. So he knows that
when he approaches you, you just got your window up, and he can sit there and read it. You put it in a pretty big font so he can read it, right?
And just let him read it.
And so he decides he's not going to go with that ordeal.
That's fine. Then if he decides to break your window and drag you out, you better have probable cause. You better have a damn good reason why he did what he did, right?
Well, you would think so, but
you didn't give him a reason, did you?
That's the old days. What do you do when they start taking and pulling a gun out on you and pointing it at you, and then they start calling for backup, and now you got 40, 11 of them pointing guns at you and yelling at the top of their lungs and drawing a crowd.
Well, the only good or bad about that is there's somebody on the internet that's been doing it, and it actually works. But this is only when it comes to simple things like DUI stops, registration stops, checkpoints, that kind of stuff, border patrol kind of things, when inside the U.S. border, stuff like that. So for that kind of thing, it works. For speeding, you're just going to have to do like the guy.
Grab the ticket and run.
No. The guy, what's his name? Jimmy Lynn did down in Texas. He did two of my styles. The one style he did was he was speeding. He loves to speed. The one time he got stopped in Texas, he just said to the one man who said license registration, he says, "Are you a man?" And the cop was like, "What?" He says, "Are you a man?" He's like, "Yes." He said, "Are you telling him?" It's like he said to him, "Are you a man?" Yes. And are you telling a man, are you interfering with a man's right to travel? Are you interfering with a man's right to go from point A to point B? And he said, license registration. And he said, "Are you a man?" And the cop said, yes. And it says, well, are you interfering with another man's right to go from point A to point B? He said it 3 times, and the cop just walked away.
Yeah, 3 times is supposed to be the magic number, right?
Well, like, I guess it was crystal clear, you know, to the cop. It's like, I'm not going to get nowhere with this guy. Am I a man? And I already admitted, yes, I'm a man. So it's like, oops. If the land is held in allodial, okay, it's yours. If there's an allodial title, that means somebody issued the title. Okay, now you can hold your land in allodial, but if you have an allodial title, it means somebody created that title. You guys, what you guys are doing is you're using too many words. First you said living woman. Why not just woman? Why not just allodial? Why do you guys have to keep adding multiple words? Because it diminishes the capacity of that word. We talked about this back in April extensively. The guy Greg from Chicago came on. He was talking about that. It's like, well, we just did something like simple, like I love you kind of thing. And then it's like, I love you more today than I did yesterday. So that, okay, so what? Then the next day you might love me less, or you might you're putting conditions on it. You guys got to talk in simple terms. You guys want to get the A+ and the gold star by saying allodial title and living woman or living, breathing soul entity Yahweh. Why don't you just say man?
No, I agree with you. I just, I'm glad you're pointing things out. That's what I need.
If you agree with me, okay, whether you agree with me or not, is regardless. I couldn't care less. I actually like people who disagree with me more.
No, but I wanted to ask you something though. When you say land is held in allodial, where do you, beyond God the Creator in the Bible, where do you support that evidence if you're going in to argue a point like that?
Who you going to, okay, you're going to argue a point. Who are you arguing with?
I don't want to argue with anyone. I just want to go in there and ask for my stuff back.
Everybody. I want to argue with everybody who's challenging my claim.
Okay.
To argue means to clear something up. See, you're listening to like Gordon Hall shows or Freeman Montana shows. Ma'am, this is really simple because people always say, oh, well, you're not going into court to create an argument, are you? I said, absolutely. I'm here to make it crystal clear because that's what argue means, to polish, to make shine, to make transparent, to see through, to make crystal clear. Of course I'm going into court to argue my case. Why am I going to court? To just agree with the other guy? If there's nothing in controversy, why are we in court? We settled it on the private side. Obviously we couldn't do it. So obviously now we're in court. So we're here to argue the case. Like I said, it's all these years of like Winston Churchill or Gordon Hall telling you people, oh, you don't want to go to court and argue. Really? That's the only reason why we're in court is because we couldn't settle it on the private side. Now we have to make our case present to the world. We got to bring it into an open forum and let the world decide whose case has got merit. We're arguing it. So somebody actually went to etymology.org or .com the other day when I was on the phone with him, and he actually said, wow, that's actually what it means in Latin, to make it clear, to make transparent, to see through it, to bring forth the facts or the truth. It's like, yes. Why would I not want to argue?
Okay, so then, Karl, this is my next question.
Well, I'm trying. Ma'am, before you ask me anything else, this is what I'm trying to get through to you people. All I'm trying to say is all these people that you listen to, these gurus who came before me, they were probably given tons of misinformation by attorneys who said, you know what? Oh, teach these people not to argue. Tell them not to argue because to argue is a bad, bad thing. Oh, and you don't want to argue. So then all you people are running around saying, we're not here to argue. We're not here to argue. Then the judge was like, okay, then I guess you just agree with the other side then.
No,
because you're not here to argue. If you're not here to argue, like all the Gordon Hall kind of people kept saying, oh, well, we're not here to argue, sir. It's like, then the judge looks at you, like if I was a judge, I said, you're out of your mind. Then what are you doing here? Well, if you're not here to argue, then I'm going to give the other side everything they want.
Yeah, no, we did not claim to be the living, or we didn't claim to be the fiction. The all-caps name. We asked her to identify, what it was, and nobody would.
Simple, ma'am. It's very simple. All you said is argue, okay? You said, I'm not going to court to argue. Okay, like I said, if you're that far behind, if you're behind that far behind, and you don't understand what a simple word like argue means, and you want to come on a show and start screaming up and down, well, this is what we got to do, this is what we got to do, and you say, well, you got to argue your case in court, you got to argue your facts, you got to argue your beliefs. You're like, oh no, I don't. It's like, okay, you know what? You need to go back to square one. And you need to learn.
No. I didn't mean it that way, Carl. The fact that what I claim to be my property is there is no argument because I created it from the ground up. There's no argument about it. That's my, you know, maybe you didn't hear the first part of the call when I was explaining.
Well, let me tell you this. The part that I came in, you said you're a living woman. Is there any other way a woman could come into court other than being alive?
Absolutely not. Maybe a dead.
Then why? What I'm trying to say is, you guys are using words that have been bounced around for the last 5, 10, 15 years by gurus.
Okay, I just want one question answered, if you could, please, just one. And it's something I've been hunting for because I have not found it. Where do I bring my claim? In the small claims court in the same state, or can I do it in my local state where I'm at now? And do I go to the small claims court here in my current state, not the same state?
You're not going to get it. You keep saying small claims court.
I don't know where to bring the claim.
Okay, no, ma'am. You keep saying small claims court.
Well, that's the only court that I know that I heard you talk about before.
I asked you a simple question. Did you keep saying small claims court?
Yes, I said it because that's what I heard you say probably on...
That's what I said, no, that's not what I said, ma'am. When people like you ask me, do I bring it to a small claims court? I don't say yes, bring it to a small claims court. It's like 1 penny worth arguing about in an open court to me is huge. I don't diminish the capacity of my claim by calling it small. This is what I'm saying that you're a major malfunction, ma'am. You're saying living woman, allodial title, small claims. For some reason, you can't just say woman, claims, allodial. You have to keep expanding on the word, and you're diminishing its strength and its capacity.
Small. There ain't nothing small as yours. What do you think?
Okay, well that's fine. So what court?
It's not fun, ma'am. If you don't understand these simple, basic concepts of how to use words, I can tell you everything on the planet Earth, and I'm telling you, as soon as you open your mouth and say something, you're going to lose the capacity to stand. You're going to undermine everything you're trying to do.
The police department is the complainant, and the Commonwealth attorney is the plaintiff.
Okay. So you tried to get in touch with both of them to see if either one of these parties had any facts, evidence that they were going to bring into the case. We were trying to get discovery. You wanted to know because, like I said, they basically asked you, why do you need this, right?
Yeah, and they said that they in cases like this, they don't allow the defendant to have any kind of written form, and also the prosecutor says that they only give evidence the day of the trial.
Okay. And like I said, so 99.9%, what I'm saying is 99% of the people here in Virginia would just accept that and say, oh, okay, that's the way it's done, and I guess we're going to find out when we get to the trial. So how did I tell you? I was like, okay, that's a great, lovely answer they gave you. I said, now, how do you explain it to them why you need the case file?
Well,
in case somebody else runs into this problem, I'm trying to show people what's the next thing to do. What did I tell you to do?
I told them that I needed to see the evidence in order to prepare a proper defense and also to obtain competent counsel.
That's exactly it.
And also I said I will not intercourse in a trial by ambush.
Yeah. So this is what I'm trying to say to these people is what if you get stonewalled by these pat answers that these people give you, it's like, well, we don't do this. You know, we don't give evidence, we don't give facts, we don't give a copy of the case file to the defendants until the day of the trial. You just say, well, wait a second, How am I to obtain competent legal counsel unless they know how to send a retaining fee? So he doesn't know if the domestic violence was like O.J. Simpson, where his wife's head was actually decapitated, or if it was a lamp and somebody got a boo-boo on his arm. So he's like, how, like the O.J. Simpson, domestic violence case lasted a year and a half. But most domestic violence cases last 20 minutes, if not long. So, but to hire competent counsel, he needs to know what he's getting into. He needs to know how long this has been going on, how many past incidents are there. He needs to know what you folks are going to present to the court so he could set a fee. He said, see, this is all I'm showing you folks. I'm just showing you folks. I'm not saying go buy a lawyer. I'm just saying when you get stonewalled, this is some of the nonsense that I'm saying that you could actually use to either delay the trial or to actually get the file ordered, from the court, from the guy in the black robe. He says, look, they turned their case, their claim, over to I, the guy in the black robe. I now have control and have jurisdiction over the DHR's or the state's claim or the prosecuting attorney's claim. I've got control over it now. So now the plaintiff, he's the one who initiates the court. So it's his rules, it's his game, and he's the one who summons everybody to appear in that building. But once he turns his claim over to either the jury or over to the person in the black robe, then it becomes their court. They get to decide the fate of the parties. No, it's no longer in the hands of the person who initiated the suit. It's out of their hands. So that's what I try to, because some people are going to say, well, wait a second, Carl, you said the claimant is the court. You said yes, until he surrenders his claim to the court. He was the court. Now he surrendered over to the court. So he courted his claim. He brought his court into the building, and now he turned it over for them to judge it. Like American Idol, he came into the building. Now he's putting on his tap dance act, and now he's going to go up against another guy who's tap dancing or doing something else, and the jury or the judge is going to decide who's better, whose case is he's going to try a suit on before the jury, and who's going to win, who's going to lose. And like I said, and once it's determined, you can't. Like I said, thank God for the Seventh Amendment, so I don't have to explain it to you people. Once the jury says up or down, there's no court in the United States that could retry the verdict, retry the hearing, the case. They can't retry it. You can't do it twice. It's done. You just move on with your life. It's just like a duel. You shot, you're dead, you ain't coming back. Just accept the fact you're in the ground and it's dead. And it's discharged. There's no more life to this thing. So this is very simple. That all we were trying to do was try to get the copy of the case file. Because honestly, these people are so freaking lazy nowadays, they don't even prepare a case file anymore when it comes to any kind of like domestic violence or children and stuff like that. They're so freaking lazy because they figure, you know what, you're either going to go buy a lawyer or they're going to have a court-appointed one. And a court-appointed one is just going to throw you under the bus and say, oh, don't worry about the facts and evidence. Look, they're just going to give you 6 months in parenting classes or 3 months in anger management. You know what, just do your classes, and, in 2 years, if you know more domestic violence charges against you, they'll expunge the record. And people just say, okay, fine. But this lady, Tyra, is not going to let them get away that easy. She actually wants to see how they're going to move their claim into the court. So go ahead, Tyra, and pick it up from where you said that you wanted competent counsel.
Right. Okay, so after the letter, I got the letter back on Friday from the Commonwealth attorney responding to what I told her I remembered about the conversation.
Well, what you did is you wrote to her. You didn't speak to her. You put it in writing.
No.
You left the note.
I put it in writing.
And you left the note on her desk, right, or something like that.
I gave it to the secretary and had him timestamp a copy of mine.
Right. So see, folks, even though she told the people, you spoke to the people, spoke to secretaries, or spoke to the police department, or whoever was the dispatch lady at the desk at the police department, she still put it in writing. Very simple. You just basically said that you require discovery, and the lady tried to tell you, well, we call it disclosure, not discovery, and she told you to go follow the rules, and then you came back and you called me and said, now what do we do, Carl? And then
So I put in what I call a notice to schedule and a notice to order full disclosure, and I that on the notice to order full disclosure, I put in brackets compared to motion for discovery.
Gordon Hall helped me with one part of it. He said to me, I said, look, if I'm suing them for a lot of money and they come at me and they say, look, we'll give you $1 million. What should I do? I said, I could use the $1 million. What do I do? And he gave me a great answer. So this is a great answer from Gordon Hall. He says, I conditionally accept your offer of $1 million, but that does not negate the fact that there's still an outstanding balance between us. So he said that way you could still take the money, but at least you have
You're leaving it open for the rest, yeah.
Right, because I've seen what happened in the case was called Rayleigh versus Maine. It was an Alabama case, and the game warden shot some man in the back. So he was found guilty, and I think he's either sitting in state prison or federal prison. So the widow of the man who got shot in the back, the game warden tried to say the man was going for a gun, but he was just going for his driver's license, like the game warden told him to give him. So he shot at the man in the back, and they had video cameras, so the game warden's in jail. But anyway, the widow, I'm not sure exactly how much she asked, but she asked for like $1 million. So then what happened was, you folks got to be really careful when you make a wish for, like, say, $1 million, because that's what they asked me. They said, what do you wish for a settlement? So the judges use those words. Wishes are very powerful. So when she was made an offer of, like, say, $500,000, she accepted. And as soon as she accepted, her $1 million claim to be made whole and complete was deemed to be fraud. Because if you say to be whole and complete, cost me will be $1 million, and then they come back with a counter offer, say $500,000, and you accept it, well, then your $1 million claim was a false claim, and then every part of your claim gets thrown out and dismissed. So I don't know if she ever got any money at all, but I'm warning you folks, when I read the case, I was like, holy cow, because if they gave me a lower offer and I accepted it, my whole entire claim would have been thrown out. And how I try to explain to people is like, say, National Geographic was giving somebody a $1 million prize for discovering the South Pole. Who's ever on the South Pole first, like, say, 100 years ago, gets $1 million. So if Admiral Byrd went down there and he said, well, I discovered the South Pole, I put a flag there, here's a photo, and give me my $1 million. What attorneys try to do to you in court is they try to play the word reasonable. So if he's like, come on, it was cold, it was 30 degrees below zero, come on, are you sure your compass really read zero? You know, come on. Maybe you were off by 1 millimeter. Come on, be reasonable to this jury now. Not be reasonable. Tell us the truth. Maybe you might have been off by maybe a micron, maybe a millimeter. And if he says yes, then he didn't hit the South Pole. So what you would have to do is like, no, that is my word, and I'm sticking to it unless a man could come forth and claim that my claim is a false claim, that I did not hit the South Pole, then my claim stands as true until somebody comes here before the National Geographic Society and says that I filed a false claim. Then you could sue me to get the $1 million back. But until then, I want every damn dime that you said is the prize to hit the South Pole. I hit it. Anybody else wants to claim I didn't? Bring your claim forward. But until then, I demand the money. So attorneys try to play this reasonable nonsense with you. So whenever you hear an attorney say reasonable, run like hell, because that's how they get you to say from it breaks your word, because your word is your bond. And if you move one iota off of your belief, and they could move you off your standing, they can knock you off your pedestal, your whole entire claim gets thrown out the window. So just stick to your guns, and when they say something, just say that's my word and I'm sticking to it. So like I said, my claim is going in, and like I said, I just printed out some orders, and the orders are really simple. Like I try to tell people, I said the one order is just say it is the order of court. When you say it is the order of court, court means me or the jury and the defendant. We're the court, not the judge or the clerks. It's the order of court. You don't hear the word this court. It's just court. That the state of Alabama's court case stylized as JU 2001-51832 is to be known to the world as void ab initio, and all of its subsequent orders are to have no force of operation. So that's how simple an order has to be. It doesn't have to be elaborate. It doesn't have to be huge. It's a nice, simple order. I'm just basically saying I want the world to look at this case as a false case, and that every subsequent order that came from this case is to be noticed as void, or known as. You don't want to use the word deemed, because deemed is a legalese word. And every single thing I write, there's not one legalese word in it. So when they try to come at me with legalese, like say, well, you're pro se. I say, no, I'm not pro se. I don't know what that means. Where can I find that in a common parlance? Where can I find that in a common term? I'm not pro se. I'm just a man. And if you try to diminish my standing, if you try to knock me off my pedestal as a man, I can't accept that. I'm just an aggrieved man. An aggrieved just means somebody who's lost his rights, and he wants his rights back. The attorney for the child said, yes, the state has the right to take the children into custody, and but, you know, there's certain obligations that the state must do once the child gets into custody. The attorney general for the state says no. The state of Alabama has no right to take any child within its borders into its custody. The only children that we have authority to control are within are the ones that have been adjudicated into our care. So it's like, holy cow, because like I said, I'd show law professors this thing. I said, does the state have the right to take your child into custody? And they'd say yes. And I hear so many people say, well, you got a birth certificate. So birth certificate means the state has the right. It's like, that, no. If you actually want it, I'm trying to get that. I think it's question number 54 or it's question number 53 of the lawsuit. And it was like, holy cow. It's like the state can only take a child based upon if it's already been adjudged to be in the state's control. So it's like, holy cow, because for years, everybody's lied to. Everybody's like, oh, the state can come in and take your child at any time. No, only if it's been judged before a court. So everybody's who's grabbing people's children is like, do you have a court order to grab my child? It's like, well, we won't let him come home from school. I said, yeah. I see that. Even let my kid come home from school. That's special, but do you have a court order? And they're like, well, no, we got to complain. I was like, no, that's not what I want to hear. Where's the order? So that's exactly what I did to the hospital. Where's the order? And they said, well, we just know who Social Services is, and they just told us to take the child into custody. I was like, holy cow. I said, you have no idea what you're doing. You can't just take people's children. And they're like, well, we do it all the time. I was like, holy cow. So like I said, if here it is. This was the question on the RC. This is the answer from them. Here's the exact answer from the state's answer to question number 53 in the RC. Okay, they changed to Hornsby. He was the Attorney General at that time. But Natchman was the one in 1997. The answer was the state of Alabama Department of Human Resources denies responsibility for minors within its borders, but accepts responsibility for children in its custody and care. See, so they're saying they're not responsible for minors within its border. They only accept responsibility for children in its care and custody. And then he went on to explain further that the child had to be judged to be in their custody and care. They can't just say, well, the child's in our custody and care. Because custody means security. Custody is just another word for security. That somebody put up security, and they put up their child as security, that they perform like under the terms and conditions of a contract. So when I read that, I showed that to all kinds of lawyers and law professors, and they were like, holy cow, no, I thought the state had the right to just take children. Like, no, they don't have the right. The only thing that they're responsible for is the children that are actually in their care. So they have no right to tell you what to do with your kid. And everybody always asks me this question, like, how are you going to get it in front of the jury and get the judge out of the picture? And I gave that to you a while back, where it says like Blackstone's commentary, and I always do volume 3, chapter 23, section 378 of the trial by jury. And you never say jury trial, you want a trial by jury. And it says, but in both these instances, the jury may, if they think proper, take upon themselves to determine at their own hazard the complicated question of fact and law, and without either special verdict or special case may find a verdict absolutely either for the plaintiff or the defendant. So you just say, look, I just want a common law court of record trial. The common law is the law of this land. There is no higher law in this land. And I explained that to you folks a while back, too. You actually Google the word land. Land means the people. And the common law court is the court of the people. So the land and the people, like I always say to people, you always seen that movie in like Excalibur, it was like King Arthur, the king and the land are one. That's true. The king and the land, the king and the people are equal on equal footing. They're equal sovereigns. So that law, it's never been outlawed. So anytime anybody gives me any guff with this stuff, any kind of lawyer, any kind of judge, I just say to them, they say, well, we don't do it like that anymore. I said, okay, can you show me where you wrote down in the law? because it's ridiculous, even if you do show me a statutory code. Can you just show me where it's outlawed? At a common law court of record has been outlawed in this country. So like I said, that's why I made the stylized, my summons different than their summons, because their summons says United States District Court. Now, I'm not summoning them to appear, so if you just if you just use everything that they give you to move your case to the court, the people are going to show up in the United States District Court. I don't want them to show up in the United States District Court. I want them to show up in a federal district court. We went down to the clerk of the court yesterday, and there was a man named Tim, and I don't remember the lady's name. And I asked him, I said, what's a court of record? And they said, oh, well, that's where we keep the records. And it's like, okay, do you know under Chorus Juris Secundum, I said, you realize in Volume 25, Section 344, what does this say? And I showed the man. He said, federal district courts are courts of record. I said, there you go. Pretty simple, huh? Yeah, this is a court of record. And he was like, okay. And it's like, okay, so what's a court of record? He said, well, that's where we keep the records. I said, is there any other way you want to describe this other than just this is where we keep the records? He's like, I said, just do your best. And this was the man who was the supervisor that brought it out. So I said, is it not true that a court of record has the power to fine or imprison for contempt? And he's like, look there. He's like, what? I said, it proceeds under the common law. It doesn't, not a statute or a code. He's like, looking at me. It's in the tribunals independent of the magistrate. And he's like, yeah. I said, well, those are the four elements of a court of record. And sometimes it has a seal, sometimes it doesn't. I said, I got that from Billy Thornton. So I said to the man, I said, you don't really know what a court of record is, huh? It moves under the common law. I said, have you ever seen a caption stylized like this? Because if you read my caption, it's like Karl Lentz versus Robert Benton. But the versus is missing. Why did I take the word versus out? Because he's not a defendant. What is he? He's a wrongdoer. So like I said, it just says a man, Karl Lentz, the aggrieved party prosecutor. And there's a black line between my name and his name. And it just says Robert Benton, chief magistrate, chairman of the DHR, a governor, a public servant, a human, a wrongdoer. So what I'm trying to say is I'm not fighting this man. I'm not fighting the governor. I'm stating a claim that I've been done wrong, and I want compensation. Now, if this man wants to come to court and say that I'm filing a false claim, let him come to court and say I'm filing a false claim. I'm not fighting this man. I'm not bringing a controversy into this court. I'm not bringing a controversy into the public. I'm saying I want compensation because I believe I've been done wrong by these people. Now, if they want to come and answer and say, well, Carl's wrong, I never did anything to him, I have no idea what he's talking about, let them come forward. But it's not plaintiff versus defendant. No, it's just prosecutor versus wrongdoer. I'm just prosecuting, which just means I'm the one who's moving my claim. I'm the one pursuing this matter. But like I said, if they want to, like I said, I just use wrongdoer instead of defendant. I just don't want to make it seem like I'm fighting anybody. It's like, no, I'm not fighting them. Honestly, I hope they don't answer. If you don't answer, then I'm just going to get a nearly decent judgment against you because you failed to tell your attorney what to do. So you can't ever come back and say, well, under the rules, the full judgment says that, since no testimony was taken on the ultimate affirmation in open court, I could come back again and I could appeal. And then by that time, all the money I had is spent. It's like, holy cow, here we go. So I don't want to do the full judgment with these people. I just want to do, like I said, a nearly set judgment against these people and get on my day. And I said, and I made my everything you do to the court. I don't do any of this judicial notice nonsense. I don't do any of this. All I do is notice. I just put the thing on the top of it, notice. I don't notice court. I don't judicial notice. You get rid of all these adjectives and you get rid of all these adverbs. You just make it a simple one word, notice. So like they say, are you a free man? It's like, no, I'm just a man. All I know is I'm a man. My mom told me I was a man. I believe her. Any other definition of that word, I have no clue where you're sourcing it from. And I'm not going to stand here for 11 more years trying to figure out what you mean by free man or sovereign man. And you're not going to diminish my capacity as a man because as far as I know, that the law of this land is the man created the government. The government answers to the man. The man does not answer to the government. And it's like, well, you a citizen, I'm not even going down that path with them. I said, look, what does me being a citizen have to say with they kidnapped my baby? Did you or did you not kidnap my baby? Well, are you a citizen? No. I'm the prosecutor here. I'm the one moving this court. I'm the one who's asking the questions here. Do you have a claim against me? No. Well, then you're moving under my rules. And this is what everybody always gets in trouble with, too. Everybody always plays defendant. But like I say to people, if you're a defendant, you have to move under their rules. So like I say to people, what's a case? Thank God I etymologize this stuff. Case means a casing, like a sausage. You put all the meat and the ingredients in a sausage case. So you're the one who determines what is best for your case. He's like, well, let's put a little bologna, pepperoni, provolone. Let's make a nice case. And you say, well, for this sausage to taste really good, you got to bake it at 350 degrees for 20 minutes. That's the rules. This is how it's going to play. This is how we're going to do it. So when people come in to court and they're the defendant, you're just a piece of their case. So when you try to say, well, I want to do it this way, they're like, no. That's not how the ingredients are mixed, and that's not the rules of how this is going to taste good. No. What you're going to have to do, people, is you're going to have to stop coming in as a defendant because you have to play under their rules. So what you have to do is like say, find out some things that they're missing. Like, is there a verified criminal complaint against me? No, great. So now I'm going to make a claim against you that you're saying a crime was committed or that a wrong was done, but you're not bringing the injured party before the court. So to move court, you have to have a plaintiff. It's an ancient rule. I don't know what it is off the top of my head, but the plaintiff must show up. The defendant doesn't have to show up, but the plaintiff must show up. His attorney could be there, but the plaintiff must be standing next to his attorney. The defendant could just have the attorney show up. The defendant doesn't have to appear. But it's an ancient rule. The plaintiff must show up because if you're claiming something like an old Bible thing, bearing false witness on your brother, and all of a sudden you're the moving party, and then you don't show up, it's like, wait a second, you wanted us to chop his head off. You filed a false claim, so now whatever you wished on your brother is going to come back on you. The plaintiff has to appear. Because if we find you file a false claim, whatever you wanted executed on your brother, whatever you demanded from your brother, we're going to demand it from you. And we might triple it, or we might quadruple it. So you better not be filing a false claim here. So that's what I always tell people. Never come in as a defendant, no matter who charges you with something, unless it's a man. I never help people when it comes to, if you injured your brother, if you injured your neighbor, a man or flesh and blood woman, I say, good luck. You compensate him whatever he wants you to do. If you ain't got money, tell him to come over and rake his leaves, mow his lawn, wash his windows. But you got to compensate him somehow because you done him wrong. But when it's the government or a county or a speeding ticket or something, it's like, oh, no. I'm filing a counterclaim against you. Why? Because you're not going to bring any injured party before this court. And since you're saying that somebody's been done wrong, and you better have the plaintiff. Because if you're not, you're filing a false claim. And I'm telling you, no plaintiff's going to show up. And I'll compensate the plaintiff now. Right now. You show me who the plaintiff is, and I'll give him money. But he's got to put his hand on the Bible and verify that I injured him. Well, the state says the state better put their hand on their Bible and they better verify it. Visa or MasterCard, they better put their hand on the Bible and verify it. She says, look what I got from the mail. She says, I owe them $15,000 for damages. So I took a look at it, and I said, this is extortion and fraud. So I just crumpled it up into an fireplace. Thank God she pulled it out. She says, no, Carl, you got to be serious. They're suing for $15,000. They said they're going to immediately seek court action against me. I said, one, they're missing the billing statement. I said, nothing comes out to 0000. I said, Mom was an IRS agent for 30 years. She explained that to you real quickly. Nothing comes out to all zeros. They said if they're off by 1 penny, that's extortion because they're asking for a debt to be paid that is not due. Even if it's off by 1 penny and they make a mistake by 1 penny, you could get them for extortion. And then she said, well, what do you mean by fraud? I said, it's fraud because there's no way in the world it comes up to $15,000 on a dot. So it's so funny. I said, look, stop crying. Just have a nice Christmas with your kids, and let me whip out something here in 2-3 sentences for you, okay? I said, by the time Christmas Day comes by, I'll have it all done. So she's like, wow, really? I said, yeah, now stop this silly crying. I said, it's just law. It's just a bill. Just go have fun. So I made a very simple thing. I just said to the law firm, it was a great big huge law firm here in Charlottesville, and big wigs, because these people are worth multi-million-dollar companies she rented from. It's PPM. It's a huge rental agency here in Virginia. And they came back with an itemized statement of the bill. And it was like $8,749.13. I was like, there you go. There's proof of extortion and fraud. So I sent them a letter. I should pull it off the computer real quick. But I basically was just saying, thank you for your timely response. Now, under Virginia Code, blah, 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 you committed extortion. Under Virginia Code, blah, 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 you committed fraud. Because the first bill you sent said $15,000. The second bill you said has $8,007. So that's absolute proof beyond extortion and fraud. Anytime you'd like to bring this matter before any court in this Virginia, we'd be more than glad to take this before a common law court of record here in Virginia in front of the jury. We'll show our exhibits, what we have, and we're going to file a cross-claim or a counterclaim against you for $60,000. So if there's any more correspondence that you'd like between us, you just let us know. And my sister never heard again from them for the next 4 or 5 years it's been. Okay, and what is the IRS coming after you saying? What are they saying to you?
They were saying that they have made assessments, which they can't, because they've now turned me into a small business general contractor.
Because that's what the 1090 is. That's what I was saying. That's for contractors. It didn't make any sense
and I'm not a contractor, and I'm not a small business.
So, like I said, what you need to do, the best thing for me, like I always tell people all the time, is like I say to them, look, I believe what you're doing is extortion. What I believe what you're doing is fraud. You notice the IRS. What I believe what you're doing to me is extortion. You're trying to claim that I owe a debt, which I do not believe I owe. And now if some man's going to come forward into open court under oath of affirmation and swear on a stack of Bibles that I owe money, I will work a settlement with that man. But until that point, you know what, honestly, I believe that you're trying to commit extortion. And I believe what you're doing is fraud. And if you don't cease and desist immediately, well, I'm going to submit a case against you in the common law court of record because you're causing me stress. And if you don't, if I get another notice like this, anytime any more correspondences come between me and you, I am going to charge you $10,000 for every time I get a letter in the mail.
Okay, and now is that because 35 years ago I signed a W-4?
Nope. And any time you could just say, you know what, you're causing me harm. You're causing me injury. You're stressing me out. I don't wish to be stressed. I don't wish to be any aggravation from anybody. When my mailbox comes in, I better not see another damn letter from you. And this is what I would tell them. Exactly what I said. I don't know if you have to rewind it and do it again because Ann says I talk too much, but I just do what I just said. You just tell them that you're going to file a claim that you've been injured. You've been wronged because that's the biggest word in law is you've been wronged. That you believe that you're causing me stress and harm and you do not have a lawful claim to any of my property. And if some man wants to claim the right to my property, my money, let him come forth to a common law court of record, state his case in front of 12 judges, and maybe the 12 judges will find for that man. Because an attorney cannot speak under oath of affirmation in an open court and court of record. My sister, I'll give you a simple one. My sister did this to her ex-husband. She was getting divorced. My sister had no money because her husband hid all the assets. So he has a scuba shop and everything. Like he's got big bucks. So he had 3 attorneys plus a woman attorney. So she was smart to get a woman attorney to help defend him against a woman. So I wasn't able to get to New York, so I told my sister what to do on the phone, and she did great. What happened was when the judge started the court, I said to my sister, the judge is going to introduce the parties. So when you say to yourself, you say to the judge, say, I'm Karen Garner, and I'm here to present me and my case to the court. And the judge will say, okay, are you represented? And she said, just say, no, I'm here to present me and my case to the court. I've been aggrieved, and I'm here to request from the court to create a constructive trust. That only means it takes all his money and holds it in control of the judge, and the judge will dispense the money. A constructive trust is a really good one to do. So she said, okay, the judge said, I understand. So then the other side introduced themselves, and all the lawyers, my sister said, introduced themselves. And then so then my sister went first, and the judge said, okay, state your case. So she stated her case, and then the other side went, my ex-brother-in-law. And then the lady started to speak, and my sister said, I object. And the judge says, wait a second, you had your turn, now it's their turn. It's like, did my husband have a sex change? And they were like, what? I think I hear a woman talking. That's not my husband. And she was like, well, it is his attorney. It's like, ma'am, when I introduced myself to the court, did I say I was represented by an attorney? No. Did I say I was representing myself? No. I said I presented myself in the court, in the case of the court, right? She said to the judge, you know the rules, right? And she said, yeah, I know the rules. So she told the attorney to sit down. And the attorney lady's like, what? He paid me good bucks. She said, the judge said to the attorney lady, who was a lady judge, said, do you have any firsthand knowledge of the conversations or any of the events that transpired between that man and that woman during their marriage? And the lawyer lady said, no. So then the judge said, well, then you know the rules. You need to sit down, and he needs to speak. He needs to defend himself. So my sister just clobbered him because the attorneys aren't allowed to speak. in an open court unless they have first-hand knowledge to the events that happened. And Mr. Cherry, if you go back on Angela's calls, look for Mr. Cherry. Mr. Cherry shows you how to knock the attorneys out of the box in 2 seconds. And I was doing this years ago. And Mr. Cherry did it like a year or two ago on Angela's calls, and I said, it does work. You knock the attorneys right out of the picture. So if the IRS tries to come to the court with an attorney, you knock the IRS's attorneys right out of the picture. I say, wait a second, this is a common law court of record. I'm presenting my case of an injury. I've been harmed, I've been injured by something or somebody called the IRS. Now, their attorney can't speak. Only IRS could speak. Oh, IRS didn't appear? Oh, then I guess I win the judgment. And it's a NIL, nil, dissent judgment. The other side failed to speak. The other side failed to answer. The other side failed to tell the attorney what to do. I want my judgment, and I want it now. And it's over. So I hope that helped. But,
okay, cool.
You said state courts. Now, in Colorado, where I am at the moment, state courts are really, really crooked.
Right.
And most people say go to the federal court. Now, the federal district court claims that it is a court of record.
Every federal, if you could do it either way. It's either you could Google the number 25. I'll type it on the board if you're looking on the board right here.
No, I'm not.
Okay, well, it's Cors Juris Secundum. You've heard of that, right? CJS?
Yeah.
Okay, that's the second version of it. It's you can just look under Federal Courts, Section 744. Or you can look under Cors Juris, not the Secundum, the original one. That's volume 25 under Federal Courts, Cors Juris, volume 25, section 344. And it says, all federal district courts are courts of record, period. Simple. So don't go into something called the United States Tax Court, the United States Claim Court, the United States Any Court. No.
I would never touch the tax court.
You just go to the federal district court. Everybody knows where the federal district court is in their state. So if anybody says, well, no, we call the United States District Court, it's like, watch this. Let me call up the clerk of the court's office down there. Like, let me get this from her. Yeah, ma'am, is this the Federal District Court? Yes, it is, sir. Okay, there you go.
Actually, there are codes and statutes that say that it's district court with little letters of the United States, not that the federal district court is a territorial court.
Like I said, I gave a great example before. When I went to submit my lawsuit in 2009, they changed all the codes numbers around on me, so then I was actually saying I was a Vietnam vet not getting medical benefits. So they all of a sudden they took all the Title 36 codes and they switched it over to Vietnam vet codes, and all the children codes they switched over to Title 65. So they switched all the codes on me. So I was like, you know what? How do I get away from their code world? I learned the common law court of record by watching Billy Thornton. And I said, the only problem with Billy Thornton is he talks too much to the man in the black robe. He should just say, look, this is going to be done in 21 days. You're going to give me an answer. On day 22, I want your stamp of this court on this order. And it's done. The people know how to appeal it. If they don't want to appeal it, I'm going to sell this judgment in about 20 seconds. So that's the summons to appear. You have 21 days to answer, or this order is final. And even if then that's it. You just deal with the common law court of record. You get rid of all the. I hear poor people like you asking all the time, and all these. I mean, nice Mr. Constitution man. He's giving you all these codes. He's giving you all these Constitution stuff. He's giving you all these citations. But I said Barack Obama won. I told you guys a month ago. So when Barack Obama wins, he's going to put 2 more people on the Supreme Court, and every single thing that you used for the last 50 years of your life is going to be thrown out the window. So if you want to keep playing that the United States Supreme Court is the highest court of the government instead of the land, it's not the highest court of the land, it's the highest court of the United States government. The highest court of the land, and if you Google the word land, it says people, the people of the land. The highest court of the land of the people is the common law court of record. That's why I said, what's the characteristic of a federal court? Section 344, Cors Juris, volume 25. It says it right there. It said federal district courts are courts of record. End of the story. Why would I want to go into any other court other than a federal district court? And it's all low.
I don't know. They've changed they claim now that the United States and the United States of America are the same.
Well, that's what I'm saying is They changed it. You didn't change it. Like this just says, well, we don't believe there's a common law courts anymore. We don't do common law courts anymore. It's like, so when did we become me? We is what? Yeah. The judges and everybody here? That's fine. We is not me. When did the common law court outlaw? Can you show me? Because, like I said, you see that in traffic court all the time. They'll say something like, well, is there a reason why I can't establish a case in a common law court of record and move the state prosecutor or the county prosecutor who's trying to prosecute a false charge that I went of a crime that I drove too fast? Is there a reason why I can't drag him into a common law court of record and bring him into my case?
Well, they're trying to use municipal color of law.
Well, what they'll say is, well, we don't do the common law anymore. It's like, yeah, can you show me where the common law has been outlawed? Can you show me where it says somewhere that we do? Show me where it says that. Because I hear you saying that we don't do common law jury trials anymore. Can you show me where it's written down? It's like, okay. And it's like, well, there's that code. It's like, well, that's a code. That's not a law. Where is it outlawed? When did you throw away my Constitution? Because the Seventh Amendment says if this is worth more than $20, I have the right to move a common law court of record. And once the jury came down with a verdict, it can't be heard or retried by any other court in this land. Because that's what I say to people. Oh, that's a great thing to say to the judge. You say that to the judge. If the judge starts going off on you about stuff, say, Judge, if I lose, can I appeal this? And the judge says, yes, you can appeal it. Well, then I'm not on the court of record. Because in the common law court of record, under the Seventh Amendment, says once it's been tried by a jury in the common law court of record, it cannot be heard or retried by any other court in this land. So obviously, Judge, I'm in the wrong court. Because I
Which Constitution are you using? I mean, you're not a party to the Constitution.
That's right.
United States.
You're not a party to the Constitution, but the state and the federal government are. And the state and the federal government says that this is a contract between the governments, that we will not interfere with the rights of man. And if anybody interferes with the rights of man, the man has the right to come back and sue the government. The Constitution is just to protect our rights. It's just to make sure that the government doesn't interfere with our rights. That's all. We're not a party to it. I don't want to be a party to it. Because once you sign a contract, you relinquish certain rights to obtain privileges. So I don't want a privilege from anybody. My dad taught me this when I was a little kid. If you sign your name more than once and twice, you should be an honest man. It's an old saying. An honest man should be able to go through his entire life without ever signing his name. Because once you sign your name, you're relinquishing certain rights, and you're obligated to some other man. You're obligating yourself to somebody else. You're becoming like a slave. So everybody
okay, if you want to do something and you want to rescind all your signatures, you need to do you do it non-pro-tunc to birth?
Yeah.
Yeah.
You just don't want to access to you. Like I said, if the IRS is coming after you and they try to say, well, are you a U.S. citizen, what does that have to do with me getting a letter in the mailbox? And I'm telling you, it's causing me stress. What does that have to do with me having a driver's license? What does that have to do with me having a Social Security number? What does that have to do with anything? Because no man is going to ever stand across you in a court of record. It's always going to be an attorney. So the attorney's not allowed to speak in the common law court of record. I told you what my sister did when an attorney tried to speak. Right. And the judge told the attorney the rules. You know the rules. An attorney's not allowed to speak unless they have first-hand knowledge or witness something. So is that attorney going to say they have first-hand witness knowledge that you obtained the Social Security card sometime in your life? The attorney's going to be like, no. I have no idea if she's got a Social Security card or if she rescinded it or she revoked it. You guys are doing way too much paperwork. And like I said, I don't charge a dime to help anybody. So you got to be careful. All these people who are teaching you this stuff and they're charging you money, you know what? I always say, how is that relevant to the matter at hand? Where is my common law court of record? And the judge tries to talk to me and said, can I appeal whatever decision comes from this court today? He says, yes, then I'm not in a court of record because the Seventh Amendment says that if I'm in a common law court of record, I cannot appeal this. There is no retrial and there's no rehearing by any other court in this land. I want to go into a common law court of record, and I want to go there now, and I will only answer there. I'm not going to answer about Social Security cards. I'm not answering about tax returns. I'm not answering anything. Can I appeal it if I lose? Yes. Well, then I'm not under the Seventh Amendment. You're not obeying your oath of office. Your oath of office says that you have to protect my rights if I evoke the Constitution to say that I'm a man, and if it's worth more than $20, I have the right to move this before a court of record. Where's my court of record? You took an oath, right, sir? Yeah. And that's what I always tell people all the time. This poor guy said to me, I think Tom Murphy, said he's suing a judge in, tax court. I said, she's not a judge. She's an administrating hearing officer. She's under the administrative capacity. It's like she works for Coca-Cola. So if you work for Coca-Cola and Coca-Cola told you to come before an administrative hearing today in Coca-Cola Board of Directors, and you try to say, well, I have the right to carry a gun. I got the Second Amendment right to carry a gun. She'll look at you. It's like, sir, this is Coca-Cola. This is an administrative hearing. I don't know what the hell you're talking about. Constitutional right. You work for us. You know. So like I said, when you people are like, well, the United States citizen, well, you work for them. You're you're like an employee, so you'll start saying, well, I got this right. And you're talking to an administrating hearing officer. It's not a judge. She didn't have to take an oath of office to become a Coca-Cola hearing officer. She doesn't have to take an oath of office as she's an administrating hearing. So the easiest thing to say when any woman or any man who's wearing a black robe comes before you, say, if I lose, can I appeal this? And they said, yes. Then I must be in an administrative court. Because under the court of record, I can't appeal it. It's over. It's done. The Seventh Amendment is very simple. There's nothing... like I said, there's nothing fancy about the Seventh Amendment. It's like one sentence long. And like I said, I'm typing that right now because, like I said, it's very simple. And the easiest way to get this all done with all these judges is just say, can I appeal the decision of the court today? And he says, yes, I'm not on common law court of record. Here you go. The Seventh Amendment. In suits at common law, where the value in controversy shall exceed $20, the right of trial by jury shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any court of the United States other than rules of the common law. There you go. So it can't be re-examined in any court in the United States, so I don't know where they're going to retry it. It's a very simple, Seventh Amendment is simple, and the Ninth Amendment is even simpler. The Ninth Amendment just says whatever rights man has before this contract was written between the federal government and states, man still has those rights. Those rights never changed. So the Ninth Amendment is it's actually called a savings to suitor clause, and all that means is that it's an escape clause for a man who doesn't want to operate underneath that contract. So, like I said, it's the Ninth Amendment. Nobody talks about the Ninth Amendment, but the Ninth Amendment is the most powerful amendment that we have to drag everybody into a common law court of record. Because it's like, look, I had the right to drag everybody into a common law court of record before this Constitution was created. I had the right to go before a jury before the United States existed in 1776. I had this right to have a trial by jury for the last 10,000 years. Just because you guys made a new contract between the federal government and the states doesn't eliminate my rights, because it's very simple. See, the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. The people always had a right to go before their community for a trial. And you go back to Hammurabi, you go back 10,000 years, you go back to cavemen. They always had a right to have other people determine whether or not they'd done wrong to each other and determine what the punishment was going to be. Way antecedent to the Constitution being enacted. So what they're trying to say, well, now we have a Constitution, now we got to do it all this way. No, we don't. The people always got the right to do it the way we've always done it. Just because you guys came up with a new Constitution, it's 1793, doesn't mean we're going to forget about the old ways, how we always did things. And they said, okay, fine. Whatever rights you had, to have whatever trials you had prior to this Constitution, you know what? You still got that right to do that trial that way. So there you go. You always throw the Ninth Amendment at them. Well, it's really the Ninth Article. But like I said, you know, that's how you pin them in there. That's how you pin judges in the seats, if you say it correctly. The free use of all courts of record are not of record, those are nisi prius courts, is to be granted to the people. And like I said at the very beginning, it says every court of record is the king's court in his right of the crown and dignity, though his subjects have a benefit of it, and therefore no other court has the authority to fine or imprison. And so let's see, right here. The free use of the court, the free use of all courts of record and of not of record is granted to the people. So I actually pulled that out of Tomlin's Law Dictionary, 4th edition, page 320. So, yeah, so like I said, I don't care if you want to consider me a king, because in this country we're considered sovereign, so we're all considered on equal standing as the king. So if you want to call me the king, fine. You want to call me the people, that's fine. You want to call me the subject, that's fine, because the common law court of record is free to the king and his subjects. So call me a subject, I don't care. Call me a king, I don't care. As long as I'm getting in here for free, that's all I care about. I don't care how you define me like that. As long as I'm getting in here for free, that works for me. I'm not paying $350. Because like I said, I sent them a whole bunch of things like that today about, you know, I gotta get that to Angela.
Okay. Someone on the chat here is saying that they tried emailing you to the email address we typed into the chat, and it was returned as undeliverable. So would you spell it out for me? Are there 2 T's? It's Karl, KLDIRECT, TV 2.
There you go. I just typed it right there.
Okay, so there isn't 2 T's in there. It's only 1, so it's not. It's KLDIRECTV 2 at gmail.com. All right.
Right.
So the first one we typed in there is incorrect.
Right. So like I said, I just did a simple letter to the clerk today, and I said I write this for there are many of the land similarly situated who have listened to me a few times, who appear to be truly interested and have told me they are willing to follow along with this case and to witness the results. For I believe I have chosen a simple method to move my case through the court. I have chosen to appear before a federal district court in the capacity of a man aggrieved, making simple wishes and demands to order the restoration of my rights and to seek compensation of the declared wrongs. I said, that being said, I now present to this district court of the United States of Middle Alabama my case. I, a man, wish and respectfully demand of this court to 1, file my suit, 2, to give me a case action number, 3, to deliver and close summonses to the wrongdoers, 4, please time and file stamp my original copies of the suit and mail it back to my address. 5, it is my wish to not be charged a fee, and I do not want to diminish my standing to that of a pauper. I want my standing to remain that of a man aggrieved. I do not believe I have been presented a bill for services rendered. See, they didn't give me a bill. Why should I pay them $350? Nobody gave me a bill. And then I said, I do not believe at this time any officer of this court can claim I owe this court a debt. Why? Because you haven't done anything for me. And then 3, I do believe that this court was created for the use of man and those of mankind to settle contentious matters in a civil manner without a fee. And then I just went on to say, I declare I appear before this court to seek the restoration of my rights that are secured and protected by the United States Constitution. And as all of the officers of this court have bound themselves to the Constitution, I as a man call upon the officers of this court to perform their duties. That being said, if the officer of this court still maintains that I'm in error of my beliefs, I will accept their beliefs. Therefore, I have enclosed the $350 filing fee demanded of me from the clerk of the court. For this matter in controversy between I and the government of the state of Alabama has gone on for too many years. So please just take the $350 as I need this case to move now. For once this case is settled, everything will be returned. I said, if you wish to allow me to proceed fee-free, please return the $350. And that's the letter I sent to the clerk of the court today. Just basically saying to her, I believe. Now, if you believe I have a false belief, well, then just take the $350 and let's get the show on the road. That's how I worded it to them. And I talked to the head judge. His name was Keith Watkins. He was the very head judge of the federal district court. I went right to the top. As soon as the clerk of the court gave me a little bit of nonsense yesterday, I said, look, I read the United States Supreme Court decisions where somebody said that the clerk of the court would not allow them to file on demand, that the clerk of the court was giving him a hard time to move his case into the court. So the man sued him. It went all the way up to the Supreme Court. The Supreme Court said to the man, why did you not go to the head man of that court? Why did you just keep dicking around with the court clerks? If you went to the top man of that court and he did not interfere with your rights, you would have had standing to sue and we could have gave you $1 million. But since you only dicked around with the subordinate people and you never let the man on top of the court realize that you were filing a claim and your rights were being interfered with, you have no case. So that's what I did yesterday. I recorded them. Believe me, I videotaped myself talking to them on the phone. So I talked to 2 or 3 clerks of the court, and then I went straight up to the guy who's on, if you go to the Alabama website for the Federal District Court of Middle Alabama, it says Keith Watkins is the head chief magistrate, the head chief judge, the big Article 3 judge. I called up right to his secretary, and I started talking to a lady named Pat for about 20 minutes. And I said to her last night, I want to tell everybody in the talk show call that you were a really nice lady. So she talked to me for 20 minutes, and she says, you are talking to the head judge right now. I said, yes, I know, ma'am. You're his representative, and whatever I just said to you right now is going to go right to him. She said, that's correct. So this is an ex parte communication. She said, I'm starting to get uncomfortable with how this is going. So But she let me talk to her for 20 minutes. I said, that's okay. It's going to be in writing, and you'll have it by Monday. And that's the letter I sent them, that I do not believe that I have to pay the $350 fee, because I don't believe anybody could claim I owe them a debt. I don't think you people have done anything for me yet. Until I've seen something done, why should I pay for my meal until I've ate it, until it's been delivered to me? Why should I pay for something until you've actually done something for me? If you go back to Angela's talk show things, I don't remember what episode she did it on, but Mr. Cherry, like a black man from New York and New Jersey, he shows you how to knock the attorney from the county, the state, the DMV, from the IRS, from the Visa, right out of the picture. So then you're standing in an empty courtroom. Because sure, there's an attorney. They might have 100 attorneys there. The best case that I always tell people all the time, everybody remembers George Bush versus Al Gore in 2000 with the hanging chair in Florida, right? This was a very simple case. They went to the United States Supreme Court. The United Supreme Court had ruled on that thing in less than 5 minutes. Because Al Gore, even though, like I said, his daddy owned Occidental Oil and Al Gore's a billionaire and he was the standing vice president of the United States, he was the vice president at the time they went before the Supreme Court. And you say, oh, well, you have hanging chairs, and look, we got millions and millions of hanging chairs, so I really won the election. They drove up to the United States Supreme Court with tractor trailers full of hanging chairs. They had hundreds, thousands, millions of attorneys on Al Gore's side to present their case to the Supreme Court. The Supreme Court said, is there one man who's willing to stick his hand in the Bible before the Supreme Court that said that his right was interfered with to vote because of a hanging chair, and can that man pick out one ballot out of that tractor trailer and identify that ballot as his and prove that that is his hanging chair on that ballot? And the attorneys try to use up all this legalese stuff and millions of documents and all kinds of court cases and codes and citations. And Scalia just asked them, is there one man? Just find me some like black guy from Miami, a homeless guy, who wants to come here into the Supreme Court and claim that his right to vote was interfered with by a machine. Until you bring that man forward to the Supreme Court, Al Gore, you have no case. Now, you go back to Florida and let them do whatever they want to do. But I'm telling you right now, you have no standing before the Supreme Court of the United States, because there needs to be an injured party. So if you actually read the Al Gore versus George Bush case with the United States Supreme Court, there was no injured party. They had no case.
Well, you're saying that if the attorney doesn't have the principal there standing beside him willing to
that's right.
testify,
there has to be an injured party.
That I owe him the money.
That's right. He's going to have to swear that he's going to have to swear that his right to his property has been interfered with by your actions or your inactions. And there's nobody who's going to be able to say, my name is Suffolk County, and because she didn't pay me the money that she promised me, I couldn't buy my kid a G.I. Joe doll with a Kung Fu grip this Christmas, so she's injured me. Nobody's going to be able to do it. They don't have a case. So don't answer their case as a defendant. Go back and listen to this thing. Make your own case that they're filing a false claim against you because there's going to be no injured party who's going to stand in their court.
Do I put that into the to the same court?
No. Oh, yeah. You can put it in the same court because anybody in a
In other words, don't answer their claim.
Well, if they're claiming
do my own.
Well, if you do want to make an answer, say, I believe you're filing a false claim. And if you don't, you could say that you believe that they're filing a false claim against you. And, yes, they might have the codes, and, yes, they might have all kinds of stuff on the books that says this and that, but you still believe it's a false claim. You don't have to believe in Santa. You don't have to believe whatever they want to believe. You have your right to believe whatever you want. And this is what always gets people in trouble all the time. Thank God you asked me that question. Because I hear all these people saying, oh, well, they have no facts. They have no facts. They have no facts. Never argue the facts. When a policeman wants to say I did 900 miles an hour backwards down the street on my roof, tires squealing, okay, I believe you. You have the right to believe whatever you want. Those are your beliefs. Now, I have the right to believe that unless there's an injured party, you have no case. I don't use any of their codes. If you want to refer to their codes, use the letter CF. Like Cactus Frank. You got to learn what CF means. It's like not only do I believe what they did is wrong, but CF Title 42, Section 1983 says that they can't interfere with the rights of the citizens of the United States. Now, I'm not saying I'm a citizen of the United States, but they know that what they're doing as a public official, they can't even do it to the citizens of the United States. I'm not saying that, but I'm just comparing it to me as a man. They can't do what they did to me. So always compare what they did wrong to you to what the United States Supreme Court agrees is what's wrong, what the state statutes say is wrong, what the citation of the Bible says is wrong to you, but you always use CF. Like if you look at my lawsuit, you say, wow, he's got CF like everywhere. Compare that to United States Supreme Court ruling in Pulaski versus CIA. Look at that as compare that to Blackstone's commentary. Look at that compared to Alabama Code of 1975, Section 36.1, 3665. Compare that with. They are not allowed to do that, even under their own laws. It's not only my belief, it's their law that they're also in violation of. They're interfering with my right, and they're also in violation of their own law, of their own codes, of their own ordinances. They're in violation of their own nonsense that they write. I get them all the time in traffic court. It's so sweet. All I say to the judges, I look at the other two sides. I look at the cop and I look at the prosecutor. I said, we're here to discuss that I broke the law, right? Yeah, good. We're here because I broke the law, right? Good. The judge was like, we're here because I broke the law, right? Yeah, good. Wonderful. Let's go. So then they start reading the charges. That's a code that you're saying I violated. That's a code. I thought we were here to discuss that I broke the law. This is the law. I said, yeah. I throw them their own book. I said, what's the difference in your book? Like in the Code of Virginia, 1950, what's the difference between law and a code? So, that, like I said, they read the difference between a code and a law. I said, gotchas. Because you said we were here to discuss the fact that I broke the law. So, did you just make a false claim in court? Are all you folks just committing, just making false claims and saying that I broke the law? They're like, well, you know what I meant. I was like, no. You said that we're here to discuss the fact that I broke the law. I did not break the law. And I said, are you sure you people are going to be able to prove that I broke the law today? Really? Okay. I could prove in 2 seconds I didn't. So they start to read. I said, whoa, I object. I said, that's not the law. They said, yes, it is. I said, that's the code. I said, what does it say? The Code of Virginia. Where are you pulling that from? It's a code book. It's not the law. What's the difference between law and a code? Here you go. Is there anybody harmed or injured? No. That's a code then. One is the law, one is the code. I said, so, are you committing false claims in court? Are you guys committing perjury? You just feel like coming in court and saying whatever you feel like saying? You're lying? I thought you guys swore up and down that we were here to discuss the fact that I broke the law. Oh, I guess I didn't break the law, did I? Then I guess there's no reason for us to be here, is there? Oh, man, they hate it, man. I catch them with their own words. I brought them over to the common law side by just saying something simple. Are we here because I broke the law? Is that what you're claiming? Are you claiming I broke the law? Yeah. Well, the only problem is only a man can make a claim. So I guess we're over here on the common law side now. So who's here to make the claim? They're like, oh, geez, this guy got us like in 2 seconds or less. I said, yep, I'm done, sir. Anything else you need? I love it. I've been doing this for 20 years, 30 years. I don't know. I'm 50 years old now, so I've been doing this since I've been a little kid. Just getting him in and out of court so fast, it's scary. No 100 pages of paperwork. The fair warning thing I give everybody is, like I said, it's simple. I'll read it real quick because it's simple. I, and then you make your name, gave no entity the right to administrate my property. So it's like I, whatever your name is, Bob Johnson, gave no entity, known as the DHR, the right to administrate my property. So little old ladies like this, then they're trying to get their grandkids back from like CPS. So this is how I sent it to some lady. But you could use it for a car. You could use it for a tow truck, tow your car away. You could do it for anything. You just say, I, Bob Johnson, gave no entity the right to administrate my property. Number two, I say that, Baby Johnson is my property. This is what I was doing with little old ladies. I say that blank is my property. Number three, I say that no man or woman will make a claim saying my claim is untrue. Number four, I want my property returned to me. There you go. Number five, said properties to be totally under my control, post haste, within 3 days, whatever time limit you want to give them. And then number six, it just says, I will charge the wrongful holder of said property X amount of dollars for every, whatever you want to do, every minute, every day said property is not returned, starting on the 22nd day after they've received this summons and this suit, see attached claim. So it's simple. You just make it simple. You just say, I give nobody the right to administrate my property. Number two, I said that's my property. Number three, no man or woman is going to come in open court and claim that my claim is untrue. 4, I want my property returned to me. 5, I want it done in like 2 days or less. And 6, I'm going to start charging you money. 20, because you're supposed to give them 21 days to answer a lawsuit. So on day 22, I'm going to start charging you because within that 21 days, it gives them the opportunity to try to make a settlement with you on a private side.
And the 21 days gives them time to make a settlement.
Right. It gives them time to make a settlement with you on a private side. So then day 22, you're going to start charging. You'll see in court, and you're going to move it. You're going to move it before a trial by jury, and you're going to get it back.
Boy, I mean, they get tough down here. They're rough. I mean, they won't accept any paperwork or anything. I mean, that you can hardly even.
That's why you
can't believe nothing that these guys say.
Well, that's why you got to make it incredibly simple. There's a lot of good guys like Billy Thornton. He's a good guy, but he writes too much. He writes the law of the case. He writes 50 pages of law of the case. I say it's this way. Who's going to come and say that it's not this way? See, that's my law. I'm bringing the law into the court. This is my law. I say you can't do this to me. Now, who's going to come on the other side and says I can do this to you? Oh, you really think you can? Great, lovely. Let's get a jury and let the jury decide who's right, me or you. That's it. Not 50 pages of explaining Hale versus Hinkle, Bob versus Benton, U.S. versus Georgia. I don't care. That was them. I don't know what they were doing in that courtroom 100, 200 years ago. I don't really care. Now I know this is my courtroom. You did me wrong. You're saying you didn't do me wrong. Great, wonderful. Let's get in front of the jury tomorrow. Let's get this over.
Yeah, I don't trust the juries either. I'm sorry, but that's...
I've got the doctor even saying that there's a claim against them for doing me like that. That they hurt my neck and now my hands are numb because of it.
Right, but like I said...
You know what I mean?
Like I said, Angela, you said you don't like the jury, but what I'm saying, when it's against the government realizes that if you're moving into common law, the attorney for the government can't speak. So you're the only one addressing the jury. They can't produce any facts or evidence or move the court for any summary judgment. They can't do anything, the attorneys. Now, if you want to cite a case, that's Trinzi versus Pagliaro, 1964, where the United States Supreme Court ruled that an attorney cannot even notice the court, can't hand them any facts, can't present any evidence, can't motion the court, can't ask for a judgment. An attorney can't do anything in a common law court.
Yeah, I keep forgetting about that, and I have it posted on the homepage. It's the Richard Cornforth deal.
Right. Erwin Schiff's. On Erwin Schiff's thing, you got it on, too.
Yeah.
You entered a plea, that's not swearing. Nobody came before the court and swore it on upon the record. So as I said to Angela a while ago, somebody could come back 100 years from now and say, well, Karl never swore in open court under oath of affirmation, before a jury, and that's what I want to do. I want to swear I want to get into an open court. I don't want this to end on a piece of paper, because they could say, well, that judgment's void, because does Karl really exist? Is there a man really Karl Lentz? Did he ever make a physical appearance in Alabama? We've never seen this man. He's in Virginia. Just because he sent paperwork doesn't prove that he really exists. He needs to appear in open court and swear under oath of affirmation. So it's basically the same thing with you. That's why I say to people, listen to Richard Cornforth. His stuff is he drags on way too long.
It's just Cornforth, not Cornsforth. It's Cornforth.
No S? Okay. Yeah, I don't know.
No S.
Right. Yeah, that's a tough to find.
Well, this is basically the question. If I did the jurisdictional challenge in July of 2011, they basically sent back paperwork saying that we do have subject matter jurisdiction matter over you. Your paperwork is frivolous, and they poo-pooed me right out with the letters, and then they basically sent me a letter that I owe them $20, not $2,300, but $20, and they were going to put it towards the tax. So when they arrested me on Monday, in order to get out of jail, those fines that were paid, it had to be paid up in Shawano. So it was
a bail set at I think it was $2,300.
Wow.
Yeah.
Well, like I said, you listen to my older videos, the older things I did on Angela's show. It was like 188 or 189, and I made it very simple. I said, whenever you go before an arraignment, all you do is say, may I have a pen and paper, and you just write, is there a claim before the court? See, because you can't speak in an arraignment. If you speak in an arraignment, the judge will say, he could throw the book at you because he'll say you stuck your tongue at him or you had an attitude. So I don't say anything to a man in a black robe because I don't recognize that he even exists. I just address the court. I write on top, I say, notice, is there any man making a claim before this court? Is there a claim before this court? Will this claim be verified in this court at this time? So like I said, they have to say that there is a claim before the court. They have to answer you. They have to say, yes, there is a claim, or yes, there is a man. If not, that's why you're always moving under the common law. Because if you answer a code, if they say, well, we picked you up under Section 3030557D6, how do you plead? So plead to what? That dribble? I have no idea what the hell you just said. Oh, well, let me tell you what it means. No. I didn't write that code. I can't be held. It's like I didn't write that contract. I don't know what you're reading. I don't know how you're interpreting it. That's not my words. Those are your words. Don't tell me what they mean. And like I explained earlier on this call, the public law in this country is written by Congress. It gets sealed, enrolled, and vault in the Library of Congress. Nobody looks at it. The only people that look at it are the people who write the code book. So the code is written by some Canadians. So if you're saying to me that I'm in violation of a code that some Canadians wrote, I'm like, what? This is silly. All I'm here is the answer to the law. And all the law is in this country is common law. And all the law in this country is that I hurt a man. Is there a man or woman who's going to come forth with a claim that I caused them harm? Yes or no? That's this country. If you get tricked into going into France and answering under codes, well then, like I said, they just tricked you. Because like I said, your great-grandparents might not, like mine, didn't speak or read or write English. They didn't get tricked. When they went to court, they knew that there was a claim before the court that they did wrong. And they answered to the wrong. And that was it. It was over in 5 minutes. It didn't go on for, like you said, 9 months and appeals. There was none of this nonsense, 40, 50, 60 years ago. None of this nonsense existed. It's just a way for lawyers to make money and to make a huge legal industry to give them something to do, some money to make. So like, the whole thing is, like I said, learn what a void judgment is, say that nobody came into help, and don't let anybody tell you that there's any such thing as a statute of limitations, because statutes of limitations don't apply to man. Man is not bound by latches. They're bound because they're bound.
So you're basically saying I don't have just 30 days to file a claim.
That's ridiculous.
Basically what they did to me was they came and got me. They supposedly said that they had a warrant for this Shawano County and a warrant for Dodge County, but I never saw any of the warrants, and I know on firsthand that the one warrant for the county that I live in, which was for $300 from an attorney, which is a third-party debt collector, there was no signature or stamp from the judge. There was no judge's signature on it.
That's what I said to everybody, too. I said, when you ever look...
Almost like extortion. They basically paid the judgment of $2,300 and got me right out. I didn't even go in front of a judge or anything.
Okay, look at it this way. I'm suing the federal court for $1 gazillion, okay? They handed me 2 orders. One was like 7 pages long, one was 9 pages long. You know what I did? I didn't read them. Why? Why bother? Because it's all legalese. I don't speak legalese. So see, this is what I'm saying. You're reading all this stuff that they're writing back to you, and you're trying to figure it out. Me, I don't waste my time. To me, I'm just saying, is this common law? Yes or no? There's no order that could be handed down except from by a jury. So if I don't see a verdict from a jury, I don't see anything. So like I said, I'd laugh when these guys are sending me orders. I look at the last page just to see if the edge is actually signed by a man, and it's not. It's all rubber stamped. It's all stamped by the signature of the guy or the woman. But I don't bother reading this stuff in the middle because I'm not going to let it get me upset because it has nothing to do with me as the man. So to me, I say that, look, this is why we still have a common law country. Use it and just drag it over to the common law side. And like I said, when you have a claim, it's going to go above their complaint. So your claim is going to get heard first. So that's how it works in law. Whoever paperwork goes in last is the first thing heard in court. So they already have a complaint against you. or they already got a warrant, or they got whatever nonsense. Now you're going to come in and you're going to put a original claim. You're not going to file a counterclaim. You're not going to make a cross complaint. You're going to file an original claim and say, look, they're administrating my property without rights. They're trying to tell me what to do, and they have no right to do it. And they're going to say, well, we have a right under this code. No, you don't have rights under a code. You have a duty, obligation, or privileges under a code. You don't have rights. Only a man has rights. A code is not rights. A code is not law. So that's what I said, this is so simple, it's scary, and I hope people start to understand what I'm saying. Mm-hmm. That the government comes at you, they have no right to come after you. If you, man, you have to establish that fact. Like I said, my lawsuit is so simple. I, a man, claim, I've been harmed, I have rights, and they're secured and protected by the Constitution. And there you go, and that's it, I'm done. And, I don't have to give him my name. How many cases do you see, like anonymous versus anonymous, or John Doe versus John Doe? You don't have to give him your name if you don't want to. You just say, I'm a man. And then the jury will come down, and the jury will decide the matter. You have the right to move any claim or any complaint or any case against you. When it's a criminal complaint, it's the Sixth Amendment. And when it's a civil complaint or civil claim, it's the Seventh Amendment. So everybody has the right to a trial by jury. So like I said, you have to like I said, when you listen to Cornsforth, he'll tell you that no attorney will appear on the other side. And Clayton Sherry was on Angela's show, and he said the same thing. And this is what I tell people 100 times. If you go Google New York State, there has not been a foreclosure in New York State in over 4 years now, because Clayton Sherry and his group went before the New York Supreme Court, and they said that if any bank wants to try to foreclose on any more people in New York State, the attorneys are going to have to come forth under oath of affirmation in open court and swear that everything that the bank is saying is true. And every attorney is now going to be held liable for any false claims. If he can't prove it, and he's going to be disbarred, he's going to be held liable for damages. So that no attorney has brought forth a claim from a bank for foreclosure in New York State for like 3 or 4 years now. Because, once you folks start realizing an attorney can't speak in a common law court, they can't do it. They can't bring forth a claim. They can't say anything. Only the plaintiff can say anything. So you could just say the plaintiff never appeared. And rule number 1, in common law, the plaintiff must appear. The defendant doesn't have to appear, but the plaintiff must appear. Mm-hmm. No plaintiff appeared. Like I said, I don't know how much simpler it can make it. Like you said, you got to stop overthinking it. And that's what people are having a problem with. Like, they're actually reading what these courts are sending back to them. And it's like, no. Is this common law? This started going legalese. I only speak common law.
Well, like Rod Class says, you use their own laws against them.
That's what I said. That's what I say. I use their U.S. codes. I use that UScourts.gov website, and I use their own words against them. Exactly. That's exactly what I do.
Yeah.
Like I said, right. Like if that man Rod Class says there is no whatever anymore. It's like, you know what? That's your belief. As far as I'm concerned, the U.S. government just made this website this year. January 1st, and it clearly says that all federal courts are Article 3 courts. So, okay, I'm going to hold them to it. So I'm going to put it before them and say, what does your website say? And they'll say, we're all Article 3 courts. Yeah, what does your federal court website say? We're all Article 3 judges. Like if you go to the United States, a United States District Court website, it says that all the judges there are Article 3 judges. So I'm going to hold you to it. They're just going to try to drag you over to the administrative side. They're going to try to drag you to the citizens.
Yeah.
And you refuse to go. You're like, I'm not going. But like I said, the whole problem with the people when they're saying they're not going is because they start talking to the man in the black robe instead of just writing it and putting it on paper. That way you didn't say to anybody in the court. You just write on the top, notice. That means you're noticing the whole entire world. Not judicial notice, not executive speedy notice, just the word notice. Just say notice. Is there any man in this court who's making a claim? It's almost like you could turn around and look in the gallery and say, he forever speak, speak now, forever hold your peace. Is there any man who's going to make a claim before me in this court? Yes or no? You don't certify anything. It's a verifiable claim. See, certified just means that somebody else believes that that piece of paper exists. When you go down to a notary certifies the document, correct? Okay, yes. What happens is all you're asking the notary lady to do is say that this piece of paper existed on this day. She doesn't read the document. She couldn't care less what's on it. You can't bring her forth to the court to have her verify that anything on that document is true. Certified just means that there's another person that believes that piece of paper exists. Certified is a total joke and is a waste of time. What you need to do is have it verified. See, lawyers can only certify things. So if you read at the bottom of every lawsuit, it's like, I certify everything in here to be true, whatever. That's all nonsense. Yeah, or read everything that everybody cut copies and pastes. Every Title 42, 1983 complaint, you'll see everything at the bottom is certified by you pro se plaintiff people. You don't certify anything. Lawyers certify things. What you do is verify it, and you demand that the other side also, the only answer that you'll accept in court is a verifiable answer. And the other side can't verify their answer. They could only certify their answers. So in this land, to give testimony in open court, it has to be verifiable. It can't be certified. It's got to be verifiable. There's got to be a man who's willing to put his hand on a Bible and swear to it. That's verified. That's the difference between verified and certified. Verified is viva voce. It's by your voice, by your mouth. If it doesn't come viva voce, just Google viva voce, and you'll see what I'm talking about. And
I tried to pull that today. I asked the judge because they switched the prosecutor on me, and they still haven't. The prosecutor still hasn't had a meeting with me. So I ended up. I said maybe I can use this to have the do a catch-22 and have the prosecutor swear in. And I think you've made that comment. The prosecutor won't do it. So I asked the judge, "Can you swear us both in?" And the judge said, "No, we're not going to do that."
Well, you told him you said you need it for appellate review. Say both. Say, is it not true that for any evidence or facts to be presented to the court, it has to come through a verifiable witness? And he'll have to say, yes, that's true. So say before we start, just in case I need it for appellate review, I need to be sworn in so that way my testimony can be heard by the appeals. Because if you don't, the only testimony that the appellate court is going to hear is something that was verified under oath of affirmation. So if it's not verified under oath of affirmation, you have nothing to appeal.
Really?
Really? Yeah, it's just that simple. I mean, all you have to do it's a federal. If you actually like to play with federal rules, it's a federal rule of civil procedure, Rule 602. And it's just personal knowledge. So, like I said, the only thing you have to say anytime you ever step before any kind of court is just that you have to say to the judge, is it not true that for any statement to be deemed admissible evidence, it has to be under oath of affirmation? And the judge has to say yes. He has no other choice. To be admissible evidence, you have to. And then you say to the judge, therefore, before we proceed, you just say, it's my wish to be sworn in through affirmation. Therefore, there could be admissible evidence pressed upon the record in the event that it needs to go for an appellate review. And that's the only thing. The appellate court only reviews things that were sworn in under oath of affirmation testimony. If there's no testimony for the appellate court to review, there's no case for them to hear. So you say, therefore, before we proceed, it's my wish to be sworn in through affirmation, and then I wish the other side to do for the same. And in the event you need appellate review, and Angela sees that on, she put that on her Irwin Schiff site. That case that I'm referring to is that Transi versus Pagliaro, 1964, where it says that no attorney could present any facts or evidence or onto the record unless he has any firsthand knowledge, and that's that federal rule of evidence 602.
Well, it's the state of Florida against me in all capital letters. So I thought this should be an easy one to shake off. And
it is.
It's well, trust me, it's not looking good so far because the judge is in on it too.
Because the only problem is that you didn't file a claim, did you, against them?
Actually, you know what I did? I just I've been playing in the private. This time I filed a motion for a show cause hearing, a declaratory judgment in the nature of a writ of error quorum nobis and a demand for dismissal for failure to state a proper jurisdiction and venue. He didn't. It was like I didn't do a thing. He just ignored it.
Well, the big thing is, like I said, you don't ever motion a court or petition a court. That's begging the court. And once you motion a court, you're giving the court jurisdiction, because you can't order something to do something that doesn't exist. So you kind of look like you're an idiot to yourself. You know, like you're turning on yourself. It's like you're motioning a court. Motion a court for what? You notice the court that it lacks jurisdiction over you. You notice it. You give it notice. You don't motion the court that it has no jurisdiction. That sounds ridiculous. You're saying, okay, court, you exist, but I'm saying you don't exist and you don't have any control over me. Then why are you talking to the court then?
Guys, so I thought you said originally you weren't talking in court. Now you are?
You give the court notice. Now, when you see you got a notice on a bulletin board, what do? You put it in writing and you wrote the word notice on it. I believe that there's no man will come forth and claim that they have jurisdiction and control over me, because all jurisdiction means is control over you. Who's got the power to touch you and drag you in? Who did you cause harm? Because, like I said, it's very simple. Everybody knows the 10th Amendment says that whatever power isn't reserved with the federal government, the power is reserved then with the state and with the people. And power means to control over another person. So you have control over me when I'm stepping on your toes. If I'm stepping on your toes and you say, hey, buddy, you're stepping on my toes, back off, and I don't, well, then you have the power to control me, to control my actions. You have the power to push me off your feet. So you have jurisdiction and you have control and authority over me at that time, because it's necessary for your self-preservation. So you have the jurisdiction. All jurisdiction means is you have the power to drag me into a court before a jury. Do you have that power? Do you have that authority? Of course you do. If I've caused you harm and you could prove that harm and you're willing to prove it, and I won't settle the matter with you on a private side outside of the courtroom, you have to drag me in. So that way you get the marshals to drag me in or the sheriffs to drag me in to answer to your claim against me. So you have the authority over me, jurisdiction. That's all jurisdiction means. So you're challenging the judge. What man did I cause harm to that I was not willing to settle this matter on a private side, that you believe, or somebody believes in this building, that you have the right to summons me here, drag me in, and then force me to do something? Who's got that power over me? So the judge would have to say, well, he does. It's like, okay, so you're claiming I've done you harm? He'd be like, well, no. Well, then you don't have jurisdiction over me. Who's got the right to claim that I caused him harm? Let that man come forward and speak his piece. I'll settle any matter that I caused any harm to anybody. That's all jurisdiction means. You guys must be getting extremely confused with the word jurisdiction means. It just means who's got the right to control the power over your body.
Right. And when the supposedly going to your brother, the prosecutor, they've been avoiding me like the plague. So what do you do?
The prosecutor is not the person that you've caused harm to. What you need, if you're saying that the prosecutor is, that's like the prosecutor has to be prosecuting a claim. So you say to the prosecutor, whose claim are you prosecuting? Bring the person that I've caused harm. The prosecutor is more like the trustee. He's the one who's actually just performing a job for the person who made the claim, the trustor, the grantor. Right. So who made the claim? The prosecutor didn't make the claim. He's the trustee. He's acting on that claim. He's the worker. He has an EE at the end, like an employee. He is the trustee. He's the one who's moving the claim. The claim for who? Please bring the grantor, the trustor forward. You have to always come in as a prosecutor. You have to prosecute a claim the same time somebody's making a complaint. And a claim always trumps a complaint. So you have to come and you have to file a claim. You have to say that they administrating my property without any rights. I claim that he told me what to do with my car, and he had no right to tell me what to do with my car. And then he has to prove he had a right. The only problem is for public officers and state employees, they have no rights. Only man has rights. So they have duties and responsibilities and obligations that they have to uphold. So right off the bat, there's no doubt about it. It's like, does that policeman, do you have any rights? It's like, well, what? Do you have any rights to stop my car? No, that's a duty and obligation or some sort of authority. But in this country, rights supersede and trump everything. So do you have a right? Well, no, not in the capacity as a policeman. I have a duty. That's right. But me, as a man, I have a right. So did I have the right to travel in my car? Yes. Okay, in the pyramid structure of this society, what's on the top of the pyramid? Rights. What's under pyramids? Under rights? Duties, obligations, responsibilities, and privileges. Can somebody take away your privilege to be a cop? Yes. Can you no longer then stop people driving down the road? Well, then, right, I couldn't stop them. Why? Because it would be unlawful. Why? Because you didn't interfere with that man's rights, right? Yeah. So as a cop, you have a privilege to stop me, right? Yes. Okay. As a man, do I have the right to travel from point A to point B? Yes. Okay. So you had a duty, right? Yeah, well, I had a right. So what trumps what in this country? Privileges, or duties, or rights? I had a right, and you interfered with that right.
Okay, but do you use the Constitution?
No, you could refer back to the Constitution. You could say, I believe I have the right to travel, and not only do I believe that I have that right, the Ninth Amendment also secures and protects that right. You never rely upon somebody else's document. You can refer to it.
Okay, so wait a minute, Carl. So you're talking to a cop, and you ask the cop this question, and the cop comes back with, oh, are you one of them sovereign citizens? Then what do you say?
Well, when a cop gives me a ticket, I love taking tickets because to me that's.
No, it wasn't that. I asked you if the cop asked you, are you one of those sovereign citizens? What would you say?
I said the only thing I know is I'm a man. That's all I know is I'm a man. I said sovereign citizen. That I don't know, but what I do know is I'm a man.
Thank you.
And what I want. I don't get into theory with a policeman on the side of the highway. You know, when he, like I said, you know, believe me, the way I look, believe me, I put my wallet on top of my truck, put my hands around the outside mirror and tell him, handcuff me so we don't have any accidents. So being a big, goofy-looking biker guy my whole life, I know just to basically sit there and shut the hell up. Let him do his thing, and then I'll deal with it in paperwork. I'll handle it outside of the courthouse because I just, you know, I give everybody an itchy trigger finger when they see me. So I'm smart enough to just realize I'm a big, goofy-looking guy. So you know what? Don't give them a reason.
Yeah, really.
Women have a hard time because they guess they don't figure that a cop's going to put a bullet in their head. You know, but I just presume they're going to put a bullet in my head. So that's why I get along great with cops on traffic stops. And they just give me the tickets, and I bring it back down. I told you that story plenty of times. I said that you just bring it down within 72 hours, and you just say that this is some sort of a complaint. It's like, yeah. I said, well, I'll answer anybody's claim. Is anybody making a claim that I caused anybody wrong, that I caused a harm to anybody? Well, no, he's filing a complaint. I said, well, then I can't. At this time, I can't be bothered answering every time everybody makes a silly complaint against me. So at this time, I'm going to have to return these subpoenas or summonses or citations. And they always laugh at me. So, well, we'll see you in court in 30 days. I said, okay. I said, the only problem is I gave you fair warning, and you're going to lose. And when I've proved that you filed a false claim against me, I'm going to hold you liable. So they're like, yeah, well, good luck with that. We've never lost. And I'm like, okay. And then, like I said, when you take him into court, then you just file a claim that you tried to settle a matter with him on a private side, and he refused to. And that he's filing a false claim against you because no man is going to come forward and verify this claim that I caused him any harm. And when no man comes forward, it's like, there you go. What did I tell you? I told you no man was going to come forward. I said, and I always trick the judge and everybody when we first start this thing. They say, okay, everybody's here today. I said, yeah, I think we hear something about I broke the law. I think somebody said I broke the law. Did I break the law? Mr. Cop over there? Yeah. Okay, Mr. Prosecutor, did I break the law? Yeah. I said, is that what we hear about, Judge? That I broke the law? He's like, yeah. I said, okay. So then when they start talking, I said, no. I said, what are you talking about? That's Section 60101. That's some sort of violation of a code. We all agreed that I was here today because we would discuss the fact that I broke the law. Oh, you don't know the difference between a law and a code? Here, let me show you in your own book. This is the difference between a code and a law. And they're like, oh. I said, yeah. So everybody agreed when we first started that we were here to discuss the fact that I broke the law. So are you all lying now? Did I not break the law? You know, like, well, law is like any cause of harm that lost a man, any man going to come forward and state a claim? No.
So Karl, you're saying, is any man going to come forward to state a claim, and a cop can't come forward as a man to state a claim because he's acting in his capacity as a cop? Is that your catch-22?
Because only a man can make a claim in this country. The only thing that the state can do is make a complaint, file a complaint against you. They can't file claims against you. Why? Because you created the government. You created the office of the judge. You created the office of the sheriff. You created the office of the marshal. They can't make claims against the people. They can only file complaints against a person. Only man has the right to make a claim, and only man has rights in this country. God bless America.
Okay, so Karl, if I have an affidavit of obligation, and I put that in as my counterclaim, I turned the affidavit of obligation into a counterclaim.
The only problem is you don't have filing a counterclaim, because all they could do again is file a complaint. So you don't want to file a cross complaint or a counter complaint. You want to file a claim. So if you made a cross or if you made a counter, you'd be making a counter or cross complaint. If the state agency or government agency is bringing up something against your person, and if you file a counter, you'd be down on their level. You'd be in the complaint land instead of being on a claim land.
All right, I'm gonna email you again. See if you can't find it in your heart to send me an example of what you're talking about, please.
All right, yeah, it's pretty simple, man. I think, like I said, if you guys start understanding these little simple word tricks, this government's only can make complaints. They file complaints against you. Man can make a complaint if he's dumb, or he can make a claim, and only man can make a claim because only man has the rights to make a claim. You said you were able to get the case through the court clerk's office without paying a filing fee, you're saying?
Well, received is how she marked it. And then she went in the back and called and came back and was able to accept it without a fee, because that was something I wanted to test.
And how did she, okay. Did you give it to the court? See, you probably gave it to a clerk of a court. And
yes,
she
that's correct.
Right, she probably went back and spoke to the court clerk.
Mm-hmm. Yes.
Oh.
And I used the letter that you used, you know. And the one thing I did put in here is that we did previously file another case in a different court, which was the U.S. District Court located in this building, for which we already did pay fees regarding a similar matter of our house and land, misnamed real property at that time claim, which our final responses were not answered and remain on the court record unrebutted as the last instruments filed in that case. And then I referenced it. And that's where I was denied the trial by jury.
So when you stylized it on your caption, you know, where you put your name versus the other party's name?
I put us as claimants, a man, a woman, the aggrieved party, claimants. And then I named 3 individuals as human wrongdoer respondents. One, Timothy Mayopoulos, purported CEO and president of alleged Federal National Mortgage Association, and Gregory Wild, the alleged attorney of Tiffany and Bosco, and the Pat Schweiger, the purported realtor of the alleged Realty Central. And then I've added other wrongdoers, public servants, county employees, agents, state actors, unnamed at this point. I used your cover sheet. I put on the registered mail sticker in the upper right-hand corner because I wanted that to be the case number. She still put a file number on it.
That's okay. No, that's for your personal records. That's your case number for your personal records. That's the court clerk doesn't even recognize that or see that thing. And all she's doing, and like I said, when she gives it a case number, that's for their ease of their filing purposes. That's not your case number. You know, that's their case number. So they could recognize this. Because she takes the court clerk, all she does is assigns it a number, then she assigns it to a judge. That's her job. She looks on a dock and sees who's busy, who's not, and she just assigns that case. It's their way to, you know, schedule out the cases to the judges who are, you know, who are available. And so that case number really doesn't have any power or any authority to determine what's actually inside that paperwork. It's not controlling. It doesn't control what's in the document. It's just a number that the lady assigned. So there's no real great power to that.
Except when I looked at the docket, it's done as a civil rights case, and she specifically asked me if it was a civil rights case, and I said no, it wasn't.
Right. All right. Okay, so you noticed that it said civil rights case, right?
Well, that's in the document I got back today.
That's fine.
Yesterday.
Okay. But all you have to do is make a very simple notice to the court and say to the court clerk, I believe that somebody filed it in error. I was filing, you have me on the wrong side of the court. She'll understand what that means. And I need you to move me over to the common law side of the court. I'm moving this claim under the common law. Try that.
I did that, actually, in the initial letter.
I didn't say a letter. Did you give them notice?
Okay. So give them a notice now. Okay.
I say write a nice sweet letter to the lady. You can make it say, notice, Sally, I believe you're the court clerk, and you are in charge and liable for this matter. Some subordinate within your jurisdiction, your authority under your control, filed this claim in error. They placed it on the wrong side of the court. I would like it to be moved over to the common law tort claim side of the court. This is a common law claim. This is a claim of trespass. Can you please move it from this complaint side to the claim side of the court? And she'll understand the difference between a claim side and a complaint side. She's not dumb.
Okay, because I did point out that trespass upon claimant's rights and bad faith were the declaration of wrongs. I kept it simple with that. And
did you understand basically? Well, like I said, what's good is I'm going to save this show for you guys. And I basically just said it in 3 sentences and stop and wait for a response from the lady. Do not add anything else. Don't take anything away. Make it extremely simple and wait for the lady to respond. All these women, all these court clerks, they all understand they are personally liable for trespassing on anybody's civil, statute, common law, or constitutional rights. They are all indemnified. They all carry insurance, either private insurance or insurance provided to them through their employer. So don't have to go silly on them and say, well, I know you ain't got insurance, and I'm going to sue you, and you better do this, and you better just re-listen to what I said so I don't have to repeat myself, because thank God this stuff is recorded.
Okay.
And just keep it simple. So I hope that helps.
Okay, well, it's a man in this particular case, clerk of court. So, and he didn't sign this letter, but that's beside the point, I guess. So, notice to the court is what I need to do, that it's been filed in error on the wrong side of the court. We wish to move the claim over to the common law court of record.
Can you move it right? Can you move it over to, just say, can you move it over to the claim side of the court? Can you get it out of the complaint side of the court, and can you move it over to the claim side of the court? You don't even got to say. You don't even got to say common law. They'll know. And if they try to play dumb and they say, well, what do you mean by claim? Well, like, a personal injury claim, a trespass claim, a claim. And then they'll understand. Because if you look at thank God this is recorded. You folks would go to a JS-44 federal cover sheet for when you file claims or complaints. And when you look on a JS-44 form, you're going to see under the 300 sections, it says tort claims. And then, like I chose personal injury, I check box 360. Now you're going to go over to the 400 section, and it's going to say civil rights complaints. So then you could pick something out of the civil rights complaint side if you wish. That's a menu. You could pick, and they always choose you 440, which is kind of silly. But that's what they choose you, because you're trying to say that, well, because of my race, my religion, my gender, my sexual orientation, disabilities, somebody did me wrong. No, I think they just did me wrong. I don't think they did it in particular. They didn't directly attack me because I'm a man or a woman or I'm Jewish or I'm gay or I'm in a wheelchair. They didn't directly attack me because of those reasons. They just flat out trespassed on my rights, and they administrated my property without any consent, permission, or rights to do so. Is the claim personal injury?
Okay.
It's actually a personal harm, because personal injury means more to your actual tangible assets or property. So personal harm means to man. But that's okay. I'm not going to get into semantics right now. It'll take 3 hours to explain harm and injury. But I think you folks got the idea when you listen to this, and you'll get it. Make it very simple.
Right. Keep it simple is a good thing.
Yeah. Keep it simple.
Is there a particular category for trespass, or just stick with the personal harm injury thing?
If you look at a JS-44 form, you'll see it says personal injury, which is about as close as it gets. So I just said, you know what? Personal injury, that's fine. You know what? That works for me. This is just the ease of the clerk of courts to file it. That's all. They're directed towards the judge who might be proficient at. They're not supposed to navigate it, but they'll say, oh, there's a personal injury claim. Oh, Bob's really good at that. Oh, this is a civil rights complaint. Oh, Susie's really good at that. Oh, this is a maritime claim. Oh, Joe was really good at that. They're not supposed to steer it. It's supposed to be like a lottery, you know. It's supposed to be first come, first serve. But the court clerks are pretty sharp. They know what judges are good and proficient at something and which ones are like have no clue what's going on when it comes to that aspect of the law, because there's so many hats these guys have to wear, depending on what. So.
And it has 2 magistrate judges, and I prefer, obviously we don't want judges. We just
want judges. You want judges. See, that's what's funny. In this country, we call the folks in the black robe a judge. If you go over to England, they're all called magistrates. Mm-hmm. And when you say, I don't want a judge in England, then they say, okay, you don't want a jury. Because the jury in England is called the judges.
Oh, I see. Okay.
For some reason, our schools and the legal society are double speaking us. They're messing with us. I'm trying to keep from cursing. They know the proper term is the man in the personnel and the court officers of the black robe magistrates. They're there to keep the courts running smoothly, say, wait, it's not your turn to speak, it's his turn to speak, you're out of order, you're going to be held in contempt of court, I'm the referee here. That's all the folks in the black robes are supposed to do.
Mm-hmm.
They're supposed to be the jury, if you wish them to be your judges. So see, that's what I'm saying. I think I hope shows like this is going to start having people understand this simple concept that the judges in England is what we call the jury. And the magistrates in England is what we call the judges. So they're messing with us. They are really just messing with us. And they're just laughing. They're like, these folks have no clue what they're talking about. But they're trying.
Yeah, in the prologue, I put, we now present and move our case into this venue to have our suit tried on, before, and by a jury for the judges, the jury of our peers, to render their verdict based upon the merits of our case. That's good. That's really good. It's an awful lot to say, I wish, order, and demand trial by jury. That's it. Don't go funny on them. Don't start it. So with order, command, trial by jury? Just wish, order, demand. It's like whichever flavor you want. Do you want to wish that you can grant me? I don't like anybody granting me anything. But you know what? I'm being polite the first time. You want to grant me? Grant me. If you don't, guess what? I'm ordering you. And guess what? You don't accept that order, well, now I'm demanding it. So I just put all 3 there. I wish, order, and demand. Instead of just saying, I demand, which is totally proper. They're not going to hurt their feelings, but they're human beings, like I said, and you don't want to make them seem like you're an arrogant SOB. Mm-hmm. So I just say, well, I wish, order, and demand. Because honestly, it's I demand. Because they're your servants, but like I said, I've been a boss at times, and I've had subordinates work for me. And I'm certainly not going to say to somebody, hey, I demand you go do that right now. I'll say, hey, you know what? I wish you'd get off your butt and stop drinking so much coffee, and I wish that you'd go back to work. And if he says, well, I said, look, now I'm ordering you. Get off your butt and get back on the ball. It's like, look, now I'm telling you, I'm demanding. You get off your butt, we'll get the hell out of here. if someone does a complaint against you as the defendant, then what you need to do is turn around and make a claim as the prosecutor claimant in the same court and move it over to common law?
What you first do is you try to settle a matter on a private side out of court. You say, hey, why did you jump right to filing a claim or a complaint against me? Why didn't you allow this to be settled on a private side and keep it out of the public venue? Why? And then if they have like a date to appear in 30 days, you could just tell the person in a black robe who's hearing the matter, say, hey, we did not exhaust administrative remedies. I'm still working on this thing on a private side, and I want to keep my business between that party. I don't want a third-party interloper, like a man in a black robe, in my personal affairs with that person who believes they're in a contract and agreement with me. This is private. I don't want my dirty laundry aired out in the public. Give me time to work on the private side with these folks. And the judge can't move because, like I said, a simple one, if you folks want to see it, but what I'm saying, you could go look under the Virginia Supreme Court rules. It's VSCR 7B, like Bravo, colon, and the number 4. And in a civil matter, unless all parties are ready to proceed, the matter cannot be moved through a court. It's that simple. So if you're not ready to proceed, you just say to your judge, I'm sure you can find that local rule and local something in your state, stylize it like, look at the Virginia Code of 1950 under the Virginia Supreme Court rules 7B, colon 4, in a civil matter. If the parties are not ready to be moved, they're not ready to move, you can't force them to move. So the judge can't say, well, it's 9:03. Are you ready to move? We're moving now. It's like, okay, you realize I'm relying upon this basic civil rule because we're civilized people. You can't force me to fight in the open public court. If I don't want to do dueling and dawn, I still think I have a remedy on a private side. Let me work it out with this man. And the judge will probably be the guy in the black robe. So I say, how much more time do you need? But you did it all in writing. You don't wait until you get in front of him and ask him for more time. I mean, technically you can, but put it in writing. And find the law or the rule that you're relying upon in your state. It says, I have time in a civil matter. Until all parties are ready to move, you can't force somebody to move. You can't force somebody to do something just because you have a contract with them. A husband can't force a wife to go to bed with her just because he's got a marriage contract. You can't say, hey, get your ass in bed, it's 9 o'clock, it's ready to move. Rock and roll, let's get this on. He's like, no, until I'm ready to move, you can't force me to move. We live in a civilized society. We're not caveman. You can't just drag her and make her do it. Same thing with the court. They can't just drag you in and make you do it. You can't do it. There's a land of consent. You can't do it. No man can force you to do something that you're not ready to do. It's like, okay, you want it your way. That's fine. I'll do it your way, but I'm also doing it my way.
Okay.
My way, it's like I say to folks, it's for ease of filing purposes only. This does not negate the claim. This does no impact on what's inside my case.
Wonderful.
See what I'm saying?
Yeah.
Oh, they hate that. Oh,
yeah.
Because it's true law. It's this for ease of filing purposes only. This is not to negate the claim or any documents or evidence or testimony or affidavits attached within this case. But for ease of filing purposes, I'll be more than glad to file it any way you wish.
Right.
I'll use purple ink. Do you want green ink? You want purple ink? Whatever it takes to help me get back my kids. You know what? I don't want to mess up your machine.
That's right.
Let's keep this thing rolling.
Exactly. Well, that's exactly what we were thinking. We were just kind of wanted to make sure we were trying to tread lightly at this point. We don't want to traverse too deep into the corrupt world of the people in the black robes.
If they want all uppercase, all uppercase. If they want all lowercase, do not stress, because there's a lot of folks up there in Canada that believe that something magical power or control or authority over a human being has something to do with how they spell their name.
Right.
So the way I like to use examples is like, well, look at the guy Prince, the guy from Minnesota, Milwaukee, the singer guy.
Yes.
He got tired of being screwed around with his name. So what did he do? He put some chicken scratch symbol, and he said, hey, write the check out to this. Crazy chicken dance mark. I don't even remember what it looked like. I think it was upside down question mark or something like that. I don't really remember.
Like that, yeah.
And believe me, his check got cashed. You know what I'm saying? So it's just a symbol. It's just a hieroglyphic. Just because we spell it with, like my name is KRL, it's a hieroglyphic. It's just a symbol. It's just, okay. It's like, okay, that's my name. It's like, yeah, and so my name is just what I use for convenience to intercourse in commerce with those of the public, just like I use my car. It's just a tool. It's just what I claim is proper to my person, my property, like my car is. But my car has nothing to do with me as the flesh and blood, nor does it have to do with my children, nor does my name. I'm making the claim in open court. Whether it's spelled, you know, like I said, you can look at a lot of the United States Supreme Court rulings. I'm not sure how many folks you have up there in Canada, but there's a lot of cases where it's anonymous versus anonymous, or what's that famous Roe versus Wade, because the lady didn't want to use her name. She went under Roe. So the court couldn't possibly care less what the name is before them. They need to see a flesh and blood entity, or well, this is common law. This is if you choose to use common law. The court does see Coca-Cola and Pepsi, but that's in a different venue and a different style of law. All the court cares less is about, if in common law, is there's a man or woman who's stating a claim and under oath of affirmation, like swearing it on a Bible, pointing across the room and said, that person did me wrong. That's all the court cares about. They don't care what your name is. Your name could be John Jacob Jingleheimer Schmidt. They don't care.
Exactly.
They just need to know that some man or woman came into court and they pointed across the room and said, that man did me wrong. And his name would be Rumpelstiltskin. They don't care. They say, did you do him wrong? Yes. Okay, well, you know, you're going to compensate him, or we're going to have to bring the sheriff's department down there to your property, and we're going to have to do a writ of attachment and drag your property out and hand it to this guy. How do you want to work this? It's like I'll willingly give the man compensation for the damages that are due, based on my wrong found by this, you know, honorable jury in court. Do you know what habeas corpus basically means?
To bring forth the body, right?
Yeah. Now, see, a lot of people get this big problem when they used to see back in the 1860, 1861, England combined law with equity. Okay? And in this country, we did in 1938. Okay? Then they combined law with equity. It doesn't mean law disappeared. It doesn't mean equity disappeared. What it was defendants were playing with these judges big time, and their lawyers were. They're like, hey, he belongs over to the equity side of the court. Release him from your jail, release him from your jurisdiction, and I want to drag him back over here to the law side. That was habeas corpus. They were fighting over the body. Which court does he belong in? Does he belong in the equity side, or does he belong in the law side? So they said, you know what? Enough of this habeas corpus nonsense. We're going to merge law with equity. So where this guy is, he sits. Okay? So that explains to everybody the difference between law and equity and when they merged. It has nothing to do with the common law disappeared. It has nothing to do with equity disappeared. It has nothing to do with it. They got tired of playing this habeas corpus nonsense. Chase the body around. You know, oh, let's move him here, let's move him here. They got tired of it. So all you had to do, what you forgot to mention, is you believe that nobody has jurisdiction over that property. Say, that is my property, and nobody has jurisdiction over it. That property belongs back in my jurisdiction. See, because that's what it used to be. People would claim, you have no right to hear this matter in an equitable jurisdiction. Bring it back over to law jurisdiction. I hope you're starting to get it, because it's really beyond simple. This is really cool.
That is pretty simple. Now, how do we basically show them the basic proof of, you know...
Hang on, because this is really simple. I'm trying to get everybody to understand this stuff. It's really simple. So nobody should have to ask me this again. What does jurisdiction mean to you?
My standing.
No. That's why I don't want you to get past there. What does jurisdiction mean? You believe it means standing, right?
Yeah, like I stand in my own rights, my own rights in my own original jurisdiction.
There you go. I'm trying to get you to work on it, because I'm sure you're going to get the answer. You did pretty good. I don't want to step on people's toes and seem like Mr. Know-It-All here. You're doing good. Jurisdiction, jurisdiction means who has control over that property. So you're claiming jurisdiction. You're claiming that property is in the improper jurisdiction.
Right.
That property belongs in this jurisdiction, known as 106 Apple Street, New Brunswick, Canada.
Right.
That's where that property belongs.
Now, is there any paperwork that we would need or any type of material evidence that we would need to support the fact that these are definitely our children? Their birth certificates, live birth records, nothing like that?
You can throw a live birth record in there for laughs. Yeah, sure. Why not? It ain't going to hurt.
No.
It ain't going to hurt. It's certainly not going to hurt to put a live birth record in there. That'd be pretty good. Because the whole trick with court is as long as you're making a claim, as long as the claim stands unrebutted, it's true.
Right.
So as long as you're making a claim for habeas corpus, you demand, okay? But when you do this habeas corpus, like I always tell people, judges hate it. Well, the folks in the black robes hate this. Because they love, if you forget to try to remember this, I always tell people, just remember these little acronyms like FOF and COL. That's how I always remember it. So I tell people, findings of facts, conclusions of law. You force the guy in the black robe, the hearing officer, because that's all they are. The hearing officer is administrative right now. There's no person judging anything. It's all administrative, back and forth, trying to, settle things, administratively. You tell the administrative officer, I'm going to need your findings of facts and your conclusions of law if you deny my change of jurisdiction over this property. I demand this property be returned to this proper jurisdiction.
Okay.
And if they love just stamping denied. But if you say, if this is denied, which you have no standing and no right to deny, if you believe you do, Mr. Bob, hearing officer over this matter, you don't call him Magistrate Bob, you don't call him Judge Bob, you call him Bob. I believe you're the magistrate over this matter. The magistrate is just an administrator, he's just your waiter. So Bob, the waiter, don't tell me you ain't going to fill up my wine glass or water glass. If you think you're going to do that, you better give me a damn good reason. And it's called findings of facts and conclusions of law. I'm going to hold you liable. But don't say I'm going to hold you liable right now. Be polite. Just ask him, he's going to need your finding of facts and conclusions of law. And he's going to swallow a pickle. I'm serious. He's going to be like, oh, I see where she's going. She's trying to get me liable. So you say Bob. You don't say Mr. Bob Jones. You say Bob. I believe your name is Bob Jones. I believe you're the hearing officer over this matter. I believe this matter is before you. There you go. I believe. But start off with just Bob. Did you ever hear me explain about my mom? That my mom was an IRS tax. Okay. So, like I said to you guys, you guys know that all you have to do is ask the person who's assessing you, who's sitting across the table from you, is to sign that piece of paper and say, I owe it, and I'll be more than glad to pay it. But all I needed to do is have you sign it, so that way if you're wrong, I can hold you liable.
In my thing, they've never come face-to-face with me, and they switch people all the time. They never put anybody with their signature on the line. I guess the only thing I could do is...
Of course you could demand it. Of course you could say if somebody's making a claim against your property, if somebody's demanding that you relinquish something, somebody has to have the right to do that. Nobody could do it unless they have the right to do it.
Right.
You see what I'm saying? And they could provide some statutory code and stuff to say, okay, that's fine, that's special. Now I'm going to hold somebody personally liable if they do it in error, and it causes me harm. I'm going to need some man or woman to compare John Hancock on that document. And I'll be more than glad to pay the assessment.
Mm-hmm.
Or if I believe the assessment's in error, I'll be more than glad to take that man or woman into a common law court of record, and I will dispute the claim in front of a jury. And they'll be popping out pickles.
Yep. I guess I got to flush them out.
There you go. That's the whole thing, man. You gotta talk extremely nice and extremely simple. And like I said, I know the Dean style, and my style is just sweeter than pie. You just go in there and just this. I'd be more than glad to do it. That'd be a lovely thing to do. Just show me, can I please have somebody's autograph on here? Can somebody please sign this and claim that I'm liable? Somebody please make a claim. I love settling claims. I will not argue with the fact. I will not make complaints. I'm not going to argue, stand here and listen to complaints. I will answer all claims tended to my person. You say nonsense like that, and the attorney will curl his toes. So just download this recording. I'm going to save it for you folks. So That way I don't have to repeat it again because, boy, that was sweet.
That's good.
Like I said, it'll curl his toes. So thank God I figured out how to do this talk show thing, and you guys who just listened to the past episodes, I already did an episode to try it out earlier. Before
I'm glad you did it, because that Charles guy, what an obnoxious. And then he brought Colin on. Boy, I wanted to hang them both, strangle them.
Well, what it was is I wanted him to be the host. I wanted to just be a guest. And I just wanted to go around and ask people like Dean, hey, I got a show called The Uncommon Law. I said, now I'm going to try to get a host like a Charles or somebody to be the host, because I really don't want to be a host. I'd like to take a time out from talking so damn much, and I'd like to be the guest. Or have 2 or 3 guests on. That'd be great. Like I said, somebody called me up the other day from Oregon or Washington State. I hope he listens to this call. And he was talking to me about the Lieber Code. And he's like, wow, you really like the Lieber Code? And you told him, I said, of course, it's wonderful. The Lieber Code's a wonderful process in military law. I said, I love it. He said, but I thought you were all common law. I said, sir, look, all types of different jurisdictions you're going to run into. I said, when I try to use international, like maritime law, if I'm dealing with citizens of France, my common law bullshit goes out the window. I'm going to have to adjust my claim, depending on the jurisdiction, the property. So believe me, I'm not one of these knuckleheads who just say common law is the only thing, everything, and nothing else. Oh, I'm going to maybe have to move in different jurisdictions and deal with people, maybe who want to move their claim into their jurisdiction. And I'm going to have to adapt to it. So I said, he's like, wow, well, you really know the Lieber Code, and I'm really surprised you didn't jump on me and make fun of me. I said, no. I said, it's a wonderful thing. I said, and anytime you want to come on, I'll start a show, and we'll just go around and around about the Lieber Code, why it's good or why we could use it and how we could use it, where we could use it, and where we shouldn't use it. You don't want to start going gold fringe on the people and start going too much Lieber Code on these guys. Mm-hmm. But sometimes, throw it in there, it might actually come in handy. It's nice to know it. So, it's just nice to know. It's just nice to have, and especially if you hear them coming at you with something silly like that, you're like, oh, I see where this is going. He's going to leave a code on me. Aha. You know what? I'm going to drag this around. We're going back common law. But that was cute. I liked how you tried to jump jurisdiction on me. Because like I said, when I got around and around with the governor's attorney, I said to him, you notice the order that the magistrate passed in the federal court under my case? He was like, yeah, did you notice in the first paragraph, how many jurisdictions did he basically state? He said 4. I said, yeah, he noticed that too. He was bouncing me from like maritime, admiralty, common law. He was bouncing me all over the place. And he even threw his own personal jurisdiction in there. He believed that this was his case and he was going to move it. I said, did you notice that? That was pretty sharp how the guy did it. I said, I really enjoyed it. He's like, yeah, I was trying to figure out, the man's name was Franklin Johnson. He was the governor's attorney. He was like, yeah, I kind of trying to figure out where he was going with that too. I was like, maybe he didn't think I realized that he was trying to move it out of the common law side of the court and try one of these other 3 options. I'm not going to let him do that. I'm dragging him right back to my side of the court. But I guess he's going to think I'm going to not notice that he just whipped out 3 entirely different jurisdictions in one paragraph, and I'm just going to let him get away with it. So once you realize the different jurisdictions that these courts are ordering you to abide by or move under, you say, no. No California Code 1234. No ordinance this. No rule of civil procedure this. No. We're moving it back over here. But they're going to try. And like I said, when attorneys talk in court and judges talk in court to each other, they will move the jurisdiction so fast it'll be like lightning. You say, excuse me, guys, I object. He's like, what? Get it back to this side of the court. None of that nonsense. You can't bring none of that nonsense. That's not the law before this court. What's the law before this court? The common law. This is the law that I've moved because this is my claim. Don't try to drag it under some other jurisdiction. That's why I tell people, your claim has got to be 1 sentence long because that's common law. If you do not say it exactly the same way all the time, like I say, you uttered a forged instrument in which had interfered with my right to property. There you go. And that's all I keep saying. It's like, well, what are you here about? Oh, I'm here because utterance of a forged instrument has interfered with my rights to property. And the judge will say, well, is there anything more to your claim? No, it's just they uttered a forged instrument which interfered with the rights of my property. And the judge will say, oh, okay. And I'm done. And then the other side will go. The other side will say, well, we don't believe we uttered a forged instrument to interfere with my rights of property. They say, okay, well, would you like me to expand on it? Would you like me to present the evidence to the court now? Is this court ready to see my exhibits and take my testimony and have the witnesses appear before it? And the judge will say, well, okay, well, sure, let's see it. But you state your claim. If you make your claim in the very beginning anything other than your simple sentence, you just lost common law jurisdiction.
Sure.
You start bringing in all kinds of different examples. You say, well, under they uttered a forged instrument and interfered with my rights to property. And under California Code 1234, that's illegal. It's like, well, okay, which code? Where are you moving this call? Is this common law call? Or are you moving under California Code of 1950? Which one are you doing, call? And if the other side doesn't object, then the other side will start whipping out all kinds of nonsense on their side, too. And it'll be a free-for-all. There could be 4, 5, 6 different jurisdictions going on, different codes going on. So you got to stop everybody and say, whoa, 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 get rid of that. No. This is my claim. This is my law before the court. The court's to determine whether my law is good law, not his law. He can't bring that law into this court. He can't bring that code nonsense. I don't know where she got that code from. I didn't like that code. That's not what's before this court at this time. The interpretation of my law is before this court at this time. Not his interpretation, my interpretation of the law. This is what I say the law says, and this is how he interfered with my right under this law. And they have to drag him back. It's like, well, answer the man's law. Did you or did you not interfere with his rights according to his law that he brought to the court? The right to be left alone, or the right not to be trespassed. But everything's basically a trespass. So did you trespass upon this man? Yes or no? Which means the right to be let alone, or tons of rights. Almost every single thing that they could possibly do to you is a trespass. So that's why I always make my claims in common law trespass. And then under that, I'll say forgery. And that's basically what my lawsuit said. It said on the front cover, it said trespass and forgery. That's all. What type of trespass? Forgery. What is forgery? You create a false document in which led to somebody's home. Somebody believed in it, and they found out later on it wasn't true. That's all. And that's what I say to folks. You got to get in and out of court so fast, it's scary.
I notice when you do your notices or your documents here, you're signing at the bottom, but I don't see any kind of a jurat or, if you're going to verify, you say you like to verify what you do.
That's all I say.
You put some kind of wording?
Yeah. Well, you say I verify. Well, I say it at the very beginning. At the very beginning of the document, I say I verify it be true. And at the bottom, you can say at the very top where you do the caption, you could state it as well. You could say verified claim or verifiable claim at the very top, like where you do trespass, and then you do the colon, and then you write forgery, and then you make another space, and you can say verified claim. And there you go. If you want to do it at the very bottom, don't ever do that nonsense the lawyers do. If you see something that comes back saying, I certify, blah, 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 that's a lawyer.
Under penalty of perjury and all that?
That's a lawyer. A certification means zero. There is no way you could be held for perjury or for a crime or for false or lying or for anything just because you say you're certified. Verified is where you get them. You say to them, when you answer my claim, I will only accept verifiable answers. I will not accept certified answers. I will only accept verifiable answers because you're just wasting my time if no man's going to appear. Anybody can certify anything. I mean, like a notary, she could certify anything. She doesn't know what's on that paper. You go to the bank lady, she's making, $5 an hour, $10 an hour. You say, hey, who does a notary here in this bank? Oh, she does. You say, okay, can I see your driver's license? Yeah, okay. Okay, that looks like you. Okay, boom, boom, she stamps and hands it back. And now, can she go to open court under oath of affirmation and verify anything in that document is true?
Nope.
No, she doesn't know what the hell you wrote. You could have basically handed her a blank piece of paper. You could have put a big X on it, and she would have signed a stamp and said, well, that's kind of weird. Okay, but you pay me $5, I'll do it for you, or your bank customer, I'll do it for free. Okay. Kind of seems goofy, but okay. I'll say that this piece of paper was before me on this date, March 28, 2013. Okay. And that's it. That doesn't mean anything on it's true. So when an attorney says, well, this is certified and notified and notarized, I don't give a damn. Notarized and certified, big deal. So that piece of paper existed in front of somebody other than you. Wow, whoopee-doo. Is somebody going to verify any of this nonsense on this paper? That's all I want to know. Is somebody going to come to court and answer any of this crap verbally, open their mouth, in viva voce, and swear under oath of affirmation that all in there be true? No, well, then you're wasting my time. Because this is going to be over in 2 minutes. If nobody's going to come to court and verify any of this nonsense, I win. I'll verify it in court, yeah. The other side will say, are you going to verify any of this stuff? Oh, hell no. Attorney will say, oh, hell no. He's going to say, I know what the word verified means. I ain't going to open my mouth and say shit. And that's whenever we say to people, look at that Richard Cornsworth's video about Trinity versus Pagliaro. That's where I learned it from. No attorney can motion a court or order a court to make summary judgment because it did not come through oath of affirmation with any first-hand knowledge from any competent witness. Competent, because the attorney can't testify in a common law court. He's not competent. So it's kind of funny hearing that an attorney's not competent. Is that attorney competent? No. So they say, well, look, we're just Joe Sixpack, Joe Normals. We're not competent. Bingo. We're not. And be happy you're not competent. Because you're not competent to stand in a statutory court. That's right. That's why they provide you with a decipher code reader for you, an attorney. They'll decipher the code for you. I don't want one. I want to take it to a common law court where I don't need no stupid code enforcement officer to decipher my stuff. Plus, I get to block every attorney. Was an attorney, you a competent witness here? No, you're incompetent to testify, right? Yeah, I'm incompetent to testify. What, so should I demand the court take him to a psychological evaluation until they rule him competent? That's ridiculous. Could be pretty funny. Say the judge, well, I move this court to hold him for an incompetency hearing until he can prove to the court that he's competent to answer in this court. Yeah, take him away until he can prove he's a normal six-pack man and he stops talking this legalese gibberish. Yeah, then let him come back and stand and testify. That's all they're doing when they're saying it's a competency thing, and which is even sillier because the people they send you to for competency, they're psychologists. They didn't go to law school. They didn't pass the bar.
Right.
Now, what kind of questions are they going to ask you? They're going to ask you, well, what was the ruling in Hale versus Hinkle? Or what was the impact of Fuller versus Johnson, 1947? They're not going to ask you that stuff. So what do they mean by competent? You have to know what they mean by competent. Do you understand the nonsense, this code that this man's saying? No. Is there any law that requires me to know? No. It's just that simple. I'm glad I'm incompetent because I don't have to stand here and speak to any of you.
Right.
And you can't.
What does it take to rescind this or revoke this contract? The short little statement you made in there that I got, and then to finish it, you just would sign it yourself, or would you have to get it?
I'd say to people, be incredibly polite. Say, oh, if I was sorry for any inconvenience, but I was incompetent. I'm incompetent to stand, or I'm incompetent to engage in any intercourse and commerce with you folks. Just be really sweet about it, and just say I'm not competent to enter into such a form of an agreement. That way you have no standing because you have no status, because you have absolutely no idea, because you're not the person who wrote the code, you're not the person who wrote the contract up, you have no capacity to understand any of this nonsense because you don't know who even created this damn thing. You just say, it's not my wish, to be engaged in this, in this endeavor. You can say it as nicely as you want to. Say, I did not create this. I have no idea who this person who's trying to contract with me is. I'm not competent in this code. There's nothing in law that requires me to be competent. And I just can't accept this wonderful benefit of this gift at this time because I perceive that it was going to cause me harm. That's what I try to say to people. Just because you get a presentment or a gift doesn't or benefit, they might think it's a benefit, but you don't have you have to accept it, but then you could send it back and say, you know what, I thought it was a great gift at that time. I thought I could really handle it, but you know what? It's overwhelming. It's actually causing me great harm and stress, and it's actually causing a lot of, and I just can't do it. And I know you, good, kindly person on the other end of this letter, certainly doesn't want to cause harm to man, because your agency or your government was created by man, and it's not to be the source of harm to man. It's supposed to be a source of benefit to man. So however you want to spice it up to try to make it sound, palatable.
It's like you explained earlier, where an administrative agency, it's the rule of law is on their side, 51%.
Yeah. Oh, yeah. When you're standing in their jurisdiction,
right,
before an administrating hearing officer, because if it's not a trial, it's a hearing, and he's just a hearing officer, and he's not bound by no constitution. He's not bound by any set of rules other than the law that administrative agency is running under. He's bound by their rules, and like I said, rules are the most ridiculous. On a pyramid, the rules are at the bottom. The laws customs are at the top, and then laws under customs. If you're looking at a pyramid, rules are at the bottom. Because, like I said, my sister was his school teacher, and one day she said to the kids, we're bored with playing kickball. Let's run third base, second base, first base. Let's break the rules, because rules are made to be broken, to just spice it up and just, jazz it up a little bit. But the customs are the customs. The law is a little bit, can be modified or interpreted, but the customs of the people, that's what always prevails. In this nation, customs are at the top, and then laws underneath.
So that being true, that means that's how they get you, because you say, I don't consent. Well, you don't get the right not to consent, because it's 51% on their side that they believe you consented.
You say, like I said to Dean, this is very simple. I require leave of court so I could properly answer the claim before this court. And I know there is a proper claim been submitted to this court. Is that not true, Judge? And he knows it's not true. There is no claim. It's a complaint. He knows the difference between a claim and a complaint. Only a man can make a claim. So he'll be like, see, and that's what Dean's keeps jumping up and down, because I said that to Dean back in November. I said that to him. I said, Dean, I watched your videos. You're a nice man, but, I think you're going to get it, but you're a little angry. I said, what you really need to do is stop using their acts, stop using the Canadian Constitution stuff, stop using the Canadian law, stop using their precedents. He's like, well, I said, Dean, first of all, that's intellectual property theft. You can't do it. And two, you automatically lose your common law jurisdiction by citing their code. You're dragging your claim into their code world. So they have the right to answer in a code. Like I say to people, it's like, oh, you want to write pro se on your paperwork? You want to write in Latin? You know what I'm saying? You've seen people write proper pro se, right? Right?
Right.
So now, do you think that's a legitimate thing to do, like write proper persona or something?
Hell no.
Why not?
Well, because that's something they dream up, the attorneys.
Well, no. It's Latin. It's Latin. It's
you
problem.
did explain that is the, I don't remember what you said about it, but you did explain it.
It's Latin. It's Latin. It's a proper language. But say I write proper persona on there. And say then somewhere else I'm going to use this big YouTube video PhD degree I got from watching YouTube videos, and I'm going to throw another Latin word in there somewhere. And then somewhere along the line I'm going to say non pro tunc, and I'm going to throw a couple more Latin words in there, right? Mm-hmm. Because I got this PhD from watching YouTube videos, right?
Right.
How would you like it if their answer was 100% in Latin? Because you spoke Latin.
Right.
Who's to limit them from making the whole entire complete answer in Latin?
Right.
If that's what you wish to speak in Latin, you wish to speak in Latin. That's why I tell people, stop your big 3-syllable words, $2 words, stop being a Philadelphia lawyer. Speak in 1 syllable, syllables, 2-syllable, plain language, English, simple, common law, nation, the words that we use. Because like I just went around with some guy on the phone, I said to him, stop writing a writ of habeas corpus. I said, just order for the property be returned to the proper jurisdiction. And he said, well, writ of habeas corpus. I said, that's a legalese term of art. Let me put it this way. I said, you walk into McDonald's, you say to anybody behind the counter, oh, I'd like to place a writ with you right now. And they'd be like, you'd like to do what? Oh, I'd like to place my writ now. And the lady in the window would be like, what the hell you'd want? We don't serve writs. Yes, you do, ma'am. You take writs all the time. That's all you do all day. If you don't take writs, you don't make money. And they'd say, sir, can you just please drive through and come to the window? Because I don't understand what the fuck you're saying. I said, well, you can say to the man at McDonald's or the woman at McDonald's, I'd like to place my order now. They say, oh, bingo. I know what you want. You want to place an order. So maybe the manager will walk out of the back and say, what does he want? He wants to place a writ. She wants to place an order with you. Just take his freaking order. It's like, buddy, why you got to talk all silly shit like that? You know she's just a common lady. Just say, I want to place an order. I said, that's how you make your writing before the courts. You just make it in simple, plain language. None of these big words, because if you want to go big words, they're going to go big words. If you want to rely upon Hale versus Hinkle, they're going to use the Feldman-Roker doctrine on you. And then that's only, it only takes like 6 semesters for a typical law student to understand the Feldman doctrine. But if you want to say, well, I'm going to rely upon the Erie doctrine or Hale versus Hinkle, well, they'll throw the old Roker-Feldman doctrine on you as an answer. Now go ahead and decipher that nonsense. Do you see what I'm saying about keep it simple?
Sure. Yeah.
It's like magic. Stop using YouTube PhDs that everybody's getting online and keep it simple. And we can move through these courts like lightning. One sentence, done. Does anybody got a claim? No, I'm done. I require leave of court. Is there a proper claim before this court so I can properly answer it? Yes or no? Look over the other side. You got a proper claim so I can answer it? No? Huh. Judge, what are we doing here? Is he making a false claim before this court? What's he doing? You know what? Now I'm going to need to leave a court to make a claim against his false claim. I'll be right back. Give me about 20 minutes. I'll have a claim written for you. It'll take me 1 sentence. I'll be done. Well, no, that won't be necessary, Mr. Lentz. That's all the dean had to do in court. Not jump up and down and get mad and angry. I know my rights, and you are a free man, and you spell my name in all uppercase. And these, I don't give a rat's behind if a chicken tap dance is on my paperwork. I say, that's my name. That's my name. But it looks like a symbol for the artist known lately as Prince. Yeah, it kind of looks like his nonsense. All our letters are just a form of hieroglyphics. All our letters is just a form of a symbol in which we interpret to mean a certain thing. So space aliens are going to come down and read us gibberish and go, oh boy, that's English hieroglyphics from the 19th century. Then they're going to try to decipher our nonsense. It's just symbols. That's all it is. See, this name nonsense, that's what I tell people. I said, boy, man, I wish I really was on this name kick, because I could really waste everybody's time for 2-3 hours on all this bullshit I've learned over the years of what the name means this, and uppercase, boy, I should sure waste your time on stuff that has absolutely nothing to do in this nation. In this nation, it doesn't matter. Like I said, any simple person could go before a court and point their finger and say, that man owes me $50 and he won't pay me back. That's a claim. There's the injury, there's the wrong, there's the harm, there's the loss, there's the breach of contract. Hey, I got it. The man doesn't have to know how to sign his name. The man doesn't have to write his name. This is a nice, simple country. Because everybody who moved to this country, like my dad, he couldn't read or write English. He spoke German, and he could read a little German. But he certainly couldn't read or write English. But you better believe if he had to go to court, he could hold his own. That's how this country was made, because people from all over the world were coming here. And they just said, okay, you know what? What's the custom of the people? How do you Italians do it? This Italian did this. I have no idea what you guys are doing. Eskimo did this to another Eskimo. Is that a proper thing to do to another Eskimo? You know, it's like, yeah, that's what we do all the time. We rub noses to each other. It's like, okay, fine, that's what we do. Or this is what we do with a polar bear. I didn't know. I thought that was pretty bizarre. But no, it's a custom of our people. That's not unlawful. Okay, but, you try to do that in New York City to somebody, they'll punch you in the face. They say, oh, no, we rub noses here all the time. No, I don't know. You rub a nose with a polar bear? Yeah, we rub a nose with a polar bear. Oh, you're pretty crazy. You rub a nose with a complete stranger? Oh, yeah, complete stranger. Well, you can't just grab somebody walking down 42nd Street by the ears and rub their nose. That's a crime. That's assault. You can't do that nonsense.
So the real trick is going to be able to, once you give them your simple notice, to be able to back it up by taking them to court, to common law court.
Yeah.
Be able to pull that off.
You don't even have to say common law court. That's what I'm saying. You just file your claim in court. And like I said, it's based on what you're writing. If you're saying the action is a trespass, and the trespass is, administering property without a right, that's pretty well says it all. Trespass, you're not using any kind of California statute code for trespass under Section 1234, because I'm sure there's a trespass code in California. Okay. As long as your paperwork has absolutely no codes, it's not relying upon any precedents based on some code that happened in the past or any of their, because you don't know how they moved Hale versus Hinkle. I don't know what jurisdiction they moved under. I believe it was under some sort of commercial law. And I know Hale versus Hinkle had something to do with an accountant of a fruit and vegetable company in New York, and the state attorney general from New York State was trying to acquire all the records from the company, and Hale said, no, you're just going to get the, what do you think we didn't pay taxes on? The import of what? Bananas. And all the paperwork you're going to get is for the bananas. We're not going to give you the apples and oranges and watermelons and everything else. And New York State said, no, we chartered you, we created you. If we want all these damn records, you're going to give it to us. The United States Supreme Court said no. The corporation has can use the Fourth Amendment, Fifth Amendment, the right to self-incrimination. They don't have to testify against themselves, and they could be secure in their paper and property just like a man who's sovereign. So everybody says, oh, Hale versus Hinkle, Supreme Court said man is sovereign. Well, basically had to do with an import-export company for fruits and vegetables. Now, if you want to say your case on Hale versus Hinkle, okay. You know, you're just trying to stretch it and saying, well, a fruit and vegetable company has rights. Well, so do I. Why? Just say I'm a man. Just by saying I'm a man, there you go. They know you have rights. It's self-explanatory because only man has rights. Everybody else has a duty or an obligation or chartered or privileges or something, but only man has rights. You just say I'm a man. There you go. When I enter course in commerce, my name is Bill. And there you go. And that's about it. You don't have to do uppercase, lowercase. You can make this. So when I enter course in commerce, I use the symbol formerly known as the artist known as Prince. Believe me, I'm sure when Prince went into a bank with that crazy question mark, whatever symbol he had, I'm sure his check cleared. I'm sure they said, oh, yeah, I didn't recognize that symbol mark. Oh, yeah, yeah. That's what he uses to enter course in commerce in the public. There you go. Doesn't make anybody have control over him because he uses that symbol. Nobody could get into his personal affairs. Only person that he engaged with is the person that he put the paperwork to and said, I will willingly now consent to sign this piece of paper, and now I'm joined with you on a within this document, within the terms and conditions set forth in this contract. That doesn't mean a person can swing his body around. It doesn't mean he owns his body now. He sold his soul. If somebody's saying that they don't like how you do in your yard, like you're not raking your leaves or something like that and not mowing your lawn, you just have to say to them, who's making a claim that because my yard is a certain, looks a certain way, you have a claim that's been filed in a proper jurisdiction in which somebody's compelling me to perform and order me to do something or modify my lifestyle or make me work on my lawn without somebody going to compensate me for maintaining my property in a manner that they order or they demand of me. Because that's everybody forgets the 13th Amendment is like the involuntary servitude is unlawful. Nobody could order you or demand from you to perform, go to work, or clean up, or scrub a toilet without fair and just compensation. So, yeah, that's my current photo on the website. That's me, and that's my cats, and that's the mountain I live on. So, yeah, back to the code enforcement. All you have to do is say who's making the claim. And obviously they're going to give you something called a complaint form. Some county official is going to file a complaint form, not a claim form. So you say to the man, when you get this complaint, it's like, well, there's a complaint, that you're in violation. So they interfere with your rights, but you violate a code. So you don't violate somebody's rights. You don't infringe on somebody's rights. You interfere with somebody's rights, because rights mean like to exercise. Like you exercise your right to free speech, you exercise your right to vote, or you exercise your right to move your left arm or your left leg. You exercise that. So if I come sit on your leg so you can't move, and I'm interfering with your right to exercise, I'm not infringing and I'm not violating, I'm interfering with it. I'm physically somehow restraining you from, enjoying the right. So back to the leaves, raking leaves or something like that, all you basically have to say to them, oh, would somebody like me to rake my leaves? It's like, oh, yes, the county or the city would really love for you to rake your leaves. It's like, okay, send me a proposal. Send me an offer. And I'll be more than glad to consider the order. Like attorneys only propose orders. See, we're a man. In a common law court, we create the orders. if you ever go to a federal website, it'll say, and you click on the attorney's forms, it'll say order proposals. So attorneys propose orders, and they pray for remedy or they pray for relief. They're praying to the man in the black robe. We don't pray for relief. We create the order. And we say, we order X, Y, and Z. We don't propose an order. We're not proposing anybody to marry him. We're not trying to court the guy in the black robe. But the attorneys are trying to court the man in the black robe. He's trying to, win him over. I'm not trying to win the guy over. I'm just saying, hey, I order this. I'm a man, and this is what I order. So when a county personnel comes over by you, says, rake those leaves, it's like, oh, do you have an offer for me? What do you offer? What's your offer? They'll say, well, I'm ordering you to rake those leaves, and if you don't rake those leaves, I'm going to charge you $5,000 a day. Oh, wonderful. Can I see that order? It's like, would you like to order me to do that? And are you saying it's $5,000 value, for raked leaves? It's like, what? If I don't rake them, somebody's going to come here and rake them, and you're going to charge me $5,000? Well, absolutely. We'll say, well, that's lovely. Let me see that, write me a proposal and sign it. Well, if you want him to sign it, then that way you're dragging him personally into the court. But you can just let him sign it as a county code enforcement officer, and that way you could hold his department liable for the bill. So then you rake your leaves, and then you hand it back to them and say, here you go. I raked the leaves, and you said that if somebody had to come rake the leaves, it would be $5,000. Well, I raked the leaves. Now I'm asking for compensation because I was ordered to rake the leaves. If I don't rake the leaves, this is the order that I rake the leaves. Somebody's going to come here and rake them for me, and we'll charge you $5,000. And then you just tender the bill back to the agency that presented you with the bill. And if they don't want to pay you, then you just file a claim in common law court that you like under the 13th Amendment, you were ordered to perform, and involuntary servitude is not permitted in this country. It's not allowed, not tolerated, and that you performed under the order of the county, and now you want compensation. They can't order you to do something. Like they can't order you to wash windows. They can't order you to wash all the fire trucks in the city without compensation. Like you can't order me to mow your lawn. You can't order me to babysit your kids without me or expecting me to demand compensation. So they could say, well, you're a resident, or you're a citizen of the city, and it's like, oh, you're presuming an awful lot. That's an awfully big leap of faith, presuming that I'm a citizen or that I'm a resident here. Are you going to be able to swear to that under oath of affirmation in open court? Do you know for a fact? Because like an attorney for the county can't come and swear under oath of affirmation in open court. Only a man can swear and have first-hand knowledge. So you can say to the man who's making a claim against you, he said, yeah, I'll take you to court. I'm the code enforcement officer, and I'll swear to it. I say, okay, good. When you get him on a witness stand, it's like, are you competent? How long have I lived here? Are you sure I live here? How do you know I live here? Just because you see me, how do you know I'm not a guest? How do you know I'm not a visitor? How do you know that I'm liable for the property? How do you know I'm the owner of that house? All you did is you ordered me to do something. Now, you're going to have to compensate me for that order. I carried out your order. When one man orders another man to do something, I carried out your order. Now I want compensation. What I said to him is, good, so when you won, and the judge said, enjoy your sofa, what did you do next? He said, we left. I said, why didn't you tell the judge, I am an honorable man. I cover all my debts, in which I know be true. I know I still owe $300. Please allow me to offer Rent-A-Center just one more time before we leave today and business is concluded, $30 a month for the next 10 months. Did you do that? He's like, no. And I said to my sister, this is a dishonorable man, and so is he. Even though they're a couple years older than us, that's dishonorable. When you know there's a legitimate debt in which you accrued, and you've got a service or a product, regardless of who it is, even if it's a little 3-year-old and you know you can chip them and get away with it, even though it's Rent-A-Center and you know that they're a fictional entity and you know they got more money than God, whatever, and they screw a lot of people, right is right and wrong is wrong. You always have to be an honorable person. So I said, what's going to happen now, Mr. Hostad? I said, you have a lot of children, and they get into a lot of trouble. So I said, you guys are coming here asking me for legal help all the time. I said, so what's going to happen is the next time they see one of the hostages in front of his court, he's going to say the apple doesn't fall very far from the tree. And he's just going to presume all your sons are dishonorable, like they're old man. And he's not going to cut you guys any slack. So I said to my sister, I said, so you understand? You're not getting over on Renaissance. You're not getting over on Bank of America. You're not getting over on anybody. You're showing your reputation in court as a dishonorable person. And it's going to reflect on your credit report. Because you got the nature of the man, you got the characteristics of the man, and you got the reputation of the man standing before the court at all times. Now, if I wanted to sue him, I would have made a counterclaim. I would have made a counter-complaint. I would have just flat out made a claim that somebody is trying to compel me to perform, and somebody's filing a false claim before the court. And somebody's going to try to besmirch my good name and try to administrate my property, take green dollars out of my pocket, and he has no right to do so. Because I'm in no breach of a contract, and I didn't break the law. I never said I didn't violate a statutory code. You're damn right I did. But when you move under the common law, the only thing you care about, did you break the law or did you breach the contract? And since there was no contract between me and the Department of Motor Vehicle before the court that day, there's the contract. There is no contract. So where did I break the law? There has to be harm or an injured party. Where's the harm or injured party? There ain't none. So the judge realized when I threw him the law, he's like, oh my God, case dismissed. He said, I didn't realize that. He's like, yeah. I said, I can only imagine how many people that you found guilty throughout the years, and you don't know the difference between legal and lawful. And that was the very first question I asked you. I said, do you know the difference between legal and lawful? He said, well, absolutely. I said, then you could dismiss the jury because I'm not going to need one. If you're competent in law, I'll take your word on it. So he actually started with me at the end. He started to read that I was guilty. He said, whoa. He says, my turn to talk. I said, oh, no. I said, I've never sat down. I'm still standing in common law. I said, I've never relinquished control of this court over to anybody. And I said, if you believe I did, I said, believe me, I'll appeal it, and I'll be back in 30 days, or you're going to let me present the law to the court. He said, what law? I said, your law. What law? Your law. I'm pulling it right out of the code of 1950, Virginia Code. What does it say? He starts reading the legal definition of what I did. I said, now read the law. He says, it's lawful to drive in reverse in the Commonwealth of Virginia if, and he's like, da-da-da-da-da. He said, wow. He said, case dismissed. I said, no, it's discharged. I said, but dismissed. I said, okay, you could bundle it up and use it as a securitized instrument to collect and trade on the open market and, help for the benefit of the county, generate funds. That's fine. I said, but nobody better drag my ass in this court ever again under that ticket, under that claim. They better not do it. I'm going to sue you. I said, right now? Yeah, it's dismissed. I said, that's fine. I said, now, I said to him, what he read was, he read the code. He says it's unlawful. He says it's lawful to drive in reverse in the Commonwealth of Virginia as long as there's no harm to man or injury to property. I was like, huh. But when he read the legal section up on top, he's like, oh, it's illegal to travel in reverse in the Commonwealth of Virginia. First time it's $1. It's a 1 point off your license, $100 fine. Second time it's 3 points on your license, $300 fine. Third time it's $500 license. Points on your license, 5 points on your license, $500 fine, or 6 months suspended license. There's a long section. Let's not get down to the law where it's one sentence long. Read the law. He read the law. It's like, it's lawful to drive in the Commonwealth of Virginia if, Wow. Okay. Case dismissed. Says discharge. I said, I'm not going to explain the difference to you. He said, buddy, I got to go. I'm really pissed right now. I thought I was going to be in and out here in 2 minutes. I was just going to throw the law before the court. I was going to go home. Because the only thing I asked you folks, are we here because you believe Mr. Policeman, I looked over him because I broke the law. He said, absolutely. I said, the prosecutor said, are we here because you believe I broke the law? Absolutely. I said, Judge, do you believe that are you here because, you folks, you believe I broke the law? He said, well, yes, that's the claim before the court. I said, wonderful. Because I got them all in their individual capacity. Because he believed. And only a man has a belief. So now I got them all under their personal, and they're all liable now to me. And they made a claim. And I said, did I break the law? He said, yes. And when I showed the judge the difference between the law and legal in his own black and white book, he was like, holy crap. He didn't break the law. That's right. But you said I did, you said I did, and you said I did. So now I got 3 years who made a false claim before this court. 3 years said I broke the law. I got you within the first 20 seconds of walking in saying, oh, I could come back and sue you all for libel and slander. on my good name. Because in open court in front of all these good godly people, they heard you say I broke the law, where it clearly shows I didn't. I could get just all for malicious prosecution and filing a false claim against me. I said, have a good day, folks. Okay, what you're doing is, like I said, the defendant has no rights. You can have rights if the prosecutor wrote it into the script. Because when you go on to court, you're basically going on to a stage. And whatever law establishes your rights, or what you can and cannot say, or what you can and cannot do, that's the law that you're moving under, is who brought the law into the court. Now, if it's under an administrative code, well, obviously you can't use the Constitution of Mexico, Canada, or the United States. You can't use anything because you're operating under a code. In the United States, there's an written in code, so don't bring this code in. Or if you're there to deal with an administrative code for, say, family law, you can't bring code that has to do with maritime jurisdiction code. You can't mix and match it. You gotta abide by the law that's before the court. And the judge will say, that's irrelevant. That has nothing to do with the law that's before this court. Well, he'll say, the matter before this court. This has absolutely nothing. It's totally irrelevant. Keep it for something else. Now, if you wanted to establish a case and you wanted to bring in all these, you could bring in a Bible, you could bring in maritime law, you could bring any kind of nonsense. You could bring Ralph the Cabbage as your fearless God. You could bring every damn law according to Ralph the Cabbage into your court. The big trick is convincing that jury that you're not just totally freaking nuts, that this is the most ridiculous law I've ever heard. And he's just going to toss the win to the other side. But this is what I'm trying to say. It's not that defendants don't have rights. When you're operating under an administrative code, like as a U.S. citizen, that's a citizen or person established by code. When anything operates under a code, there's no such thing as rights in code. There's duties, obligations, privileges, and responsibilities. There's no such thing as a right. Only a man has a right. Everything else has duties, obligations, and privileges because everything else is established by a code. See what I'm saying?
Yeah, I understand that.
Allow you to drag you in under some sort of a code, well, there you go. It's whatever rights that they established for you. Expressly those rights, not implied. They better specifically say what you can and cannot say. If it says that you can't say that, and you deviate one line from that script, you're an actor on that stage in their court. And if you get your line wrong, the judge will say, what the hell are you doing? You know what you can and cannot say. It clearly is expressly written in the code what you can and cannot do. And you're jumping out of your role as the defendant the way your script was written for you to perform under. You try to do that again, you're going to be in contempt of court. You got to maintain, the rules of the court, and you're not doing it. That's why I say to everybody, you say to them, look, I require leave of court to properly file a claim, to answer the claim before the court. Now, there is a claim before this court, right? And the judge will well, yes. I said, well, may I please see the claim so I can provide an answer to the court? And then he's going to have to give you a complaint. I said, that's not a claim, that's a criminal complaint. I want a claim, a verifiable claim. Where's a verifiable claim? Who's the lady who's going to sit across that in a box and point across the room and say, she seen me chop off O.J. Simpson's wife's head? Who's going to be the little lady who's going to point and say, I did wrong? You don't have somebody, then you don't have a case.
So the most important words in the English language pertaining to common law, pertaining to anything, and pertaining to law in the legal system are the 2 letters and 3 letters and 4-letter words like in, at, on, for, up, on, things having to do with location. And I made for an example, I've got a coffee cup in front of me, and I know that the coffee is in the cup. Now, if I am in the United States as the coffee is in my cup, that means I'm surrounded on the bottom, the top, and the sides and everything, and I'm contained, all right? It means I'm contained, all right? And now, I don't feel contained. I'm a free man, so I don't think that I'm in anything except my body. I mean, I'm willing to accept the fact that God put my spirit and my mind in my body, and I'm stuck there. So I'll accept that one for being in something. But besides being in my body, I don't think I've ever been in anything except trouble. That's a joke. Anyway, so I started thinking about all these usages of these words. Being, if you are on something and it doesn't belong to you, you are committing trespass. You're stepping on somebody's foot. If you are in something, you are subject to whoever is the owner of the thing that you're in. If you are at something, you are simply saying that you're near to it, close to it, but not trespassing upon it. Okay? If you are saying you're upon something, it implies that you have taken an aggressive approach to not just be on, but up on. And you're actually in a form of attack. So when you start thinking about all of these words which specify the localization of you, however you define yourself, as a man, as a piece of flesh, as a spirit, whatever it is, when you start thinking about these little bitty words in the course of a sentence, and you give them really important weight, you start writing things differently. You start thinking differently because you realize that those words really imply much more than you might imagine. Okay? And I know that it sounds esoteric, but, you know, in terms of linguistics and in terms of function, I believe that it is very, very important. Now, if somebody can say that it's not important, that's fine too. I don't care, but I spent a lot of time trying to figure out how to express myself more accurately, and that's what I came up with. So I hope that that's useful.
Yeah, you did real good. I'm just writing on a board that when I do all my one-page stuff, I go around with you at quite length just to get a couple of words tight. Because if you could just say everything in a sentence or two, that keeps them from being able to move you out of your jurisdiction, out of your control. So,
right. And the other thing that we talk about, that's important for everybody to think about is whenever there are two or more words involved in the description of a thing, you have to remember that the last word is the actual thing, and the words that precede it are the modifiers. So if I say a jury trial, I'm talking about a trial modified by a jury. If I say a trial by jury, I'm talking about a jury event modified by a trial. All right? The last word is the critical word. So you have to always keep that in mind. If you want to say the United States, the most important word is states. And then it's United.
Greg, I unblocked Mr. Free 1776 in South Nevada, so if you folks want to jump in and ask Greg a question, feel free to do so. Or anybody else who wants to ask Greg, because if you have a question on how you should structure a sentence or how you should structure a cover, your caption, this is going to ask. So if you don't have a question, you know, like I love common law and I love simple stuff, but this man loves messing around with research in words and their meanings. So if anybody's got a question, man, feel glad to do it. And Mr. Porterman Jeff, I said, if you email me right now, I'll give you my phone number and I'll patch you through my cell phone to this call so everybody can hear you asking me to call. So yeah, Greg, is there anything else that you and I talk about that you think is valuable to these people? But you got a lot of people listening here.
One of the things that you mentioned earlier that should never, it really, in my opinion, it needs to be reiterated. And that is, when you are stating a, okay, actually, there's two things. Number one, I'll do it short and fast. There is usually when some action happens against you, they have made a complaint in a statutory process, an administrative hearing. You know, they took you to the Walmart Department of Human Resources to complain about you. All right, and you're not part of Walmart, but that's where they took you. So what you're going to do is turn around and file a claim in common law saying, why are you dragging me in front of the judge at Walmart when I've got nothing to do with that? And that is not a counterclaim. People keep calling it counterclaims. It's not a counterclaim. A counterclaim is a statutory process that puts you back in the defendant role. You're just a defendant with an asterisk instead of just a defendant. You've got to file your own initial claim, and it's not a counterclaim. You also may never, ever, 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 and did I say ever, be a plaintiff. A plaintiff is a term of art. If you are a plaintiff, that means you are in their jurisdiction. You can only be a man. You can only be wrong. You can be an aggrieved party. You can be Ronald McDonald, but you can't be a plaintiff. If you accept the title of plaintiff, you've already lost the case. Period. 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 Next important thing. You may never appear pro se. Pro se is a term of art in the legal system which gives you a day license to be an attorney. It is to allow you to represent yourself as an attorney in their court and conforming to all their rules. The entire code of federal regulations and state regulations and local regulations, you are swearing as a pro se that you will abide by them and that you know them. And if you accept the title of pro se, you are saying, I am an attorney for the day. And I am a one-day bar card carrying son of a buck. And if you do that, you're toast. You can never be pro se. You can never be a plaintiff. Can I repeat that again? You can never be pro se. You can never be a plaintiff. If there's any paperwork that's generated in the court that lists you as pro se or plaintiff, you immediately file paperwork against the court saying, I never claimed to be those things. Who's calling me names? My mother never called me that. I'm not going to let you call me that either. There you go. Now, with all that done, going back to the claim and counterclaim, one must file their own initial claim. They may never be a counterclaimant. If you file a counterclaim, you once again fall into the statutory regulations, and you're just playing ping pong with the guy who served the first volley. What you're trying to do is not even acknowledge the fact that the guy started the game of ping pong. Okay? You heard about it. You're pissed about it because you don't play ping pong, you play tennis. And so what you're going to do is you're going to move the entire action off the ping pong table onto the tennis court. In other words, out of statutory law into common law. And you're going to move it there, you're going to you're going to keep it there, and you are going to resist every temptation and every bribe and every threat from everybody who's in the entire system and insist on that. And then when they continue to insist on that and threaten you, you're going to offer them the opportunity to pay you a lot of money if they want to continue with their game. Okay? You're going to say, or else. Okay? The other important thing that we always talk about is or else. All right? And everybody writes all this fantastic paperwork. Nobody puts in or else. Okay? You need when. You have to do this. Where you have to do this. And if you don't do this, what it's going to cost you. All right? And you are the man. You are the creator of government. You are the creator of everything. And the government cannot administer its creator. So, you just say, the king showed up. Sorry for the inconvenience, but get this damn flea off my ass.
the only other way that you guarantee that it get into the court is you mail it.
Mail it.
Yep.
Now, if we mail it, that will not get there in time before the pretrial. So.
Sure, you will. You just go across the street to the closest post office to the guy. You go to there.
Enough, yeah.
They'll have it mailed in one. They'll walk across the street and hand it to them. It'll be done.
Yeah, true enough.
And like I said, and just because you summons them to appear in court, all a summons means is somebody's granting you, giving you permission to control, to use their facility, like use their sheriff's department or their mounties to drag that person's body before that court in 22 days. That's what a summons is.
Right.
It's somebody's granting you power. Now, you don't have to wait for somebody to grant you power. You can say, I have the power to use this facility. I have the power to use this venue. My tax dollars built this building. This isn't a private boys club. This isn't the old good old boys club. This isn't a legal society club. This is a public building, like a public library. I have the right to access and check out books like everybody else. I have the right to submit my claim like anybody else. Just because you don't like the way I style my claim, like I said, one man was going around in this country who was an ex-lawyer who just smelled like, a dead animal walking into public libraries, so they would deny him access. So when they would deny him access, he'd sue him. And he was making a living going around suing libraries. Because you can't deny the public the right to access the library. You can't deny the public the right to access the courts. You can't do it.
So if they won't file our paperwork, we would basically say, well, we're going to sue you.
Well, no, there's two steps you got to do. First, you got to say to them, are you the court clerk? Because there's a different clerk of the court is just a subordinate officer of the court clerk. Court clerk is, to me, is the lady who really runs that show.
Right.
Not really the head judge because they come and go. But that court clerk lady, she'll be there for 20, 30, 40 years. She ain't going nowhere.
Right.
She runs the show. She's the one who's supposed to pay the judges. She's the one who's supposed to do all the accounting. She's the lady who's really in charge of everything. She makes the magic happen. So what happens is there's a case here in the United States, and a man did that. He said that he was locked up for failing to pay child support. His wife went into family court. He didn't appear. She won custody of the kids and moved like half a country away. And he said the clerk of the court wouldn't accept his paperwork, so I'm suing her for failing to accept my paperwork. So it went all the way to the Supreme Court. So what happened was the Supreme Court made a ruling, and you don't have to rely upon it, but this is what our courts believe, that he went and sued the court clerk. What he should have done is also, they said there's two branches of a court, the court clerk side and the judicial side. So what he should have done then is not only made the court clerk aware that she was interfering with his right to access the court, the people's court, but he should have went to the chief judge and said, well, technically the chief judge is the highest officer that's carrying the bond for everybody in that court, including the clerk. So he should have went and said, I've told the court clerk, if you interfere in my right to access this court, I'm going to have to sue you. And then you're going to have to also tell the chief judge, you have a subordinate officer called court clerk. This woman is interfering in my right to access a public court. If you do not control, train, monitor, and discipline your subordinate, I am also going to have to add you to my suit. So the Supreme Court of the United States said because he failed to let the chief judge know that his subordinates were acting out of order, he had no right to sue the court. So you got to keep going up and up and up. He's like, look, I got this all covered. I got the court clerk, and I got the chief judge. What more do you want me to do? And then the Supreme Court said, well, then we'd give you the right to, then we'd accept the belief that you can sue because you made the top dog aware of what is going on.
So we would serve, so basically we could use that pre-trial hearing to go in and we serve our own claim ourselves to respondent?
Well, the first thing is give them an order to cease and desist, and it is basically saying, prior to me filing a lawsuit, this is a perfect opportunity to give you a notice to cease and desist and to return our property immediately before we have to move this into a court and for the matter to be determined before a trial by jury, which is I'm going to vote as is my right. There you go. Nice little cease and desist thing. There you go. to try to get all your initial filings down to one sentence. You could always.
I just did a one-page claim and a one-page prologue, and I used.
Well, you get rid of the prologue, and you get your claim down to one sentence.
And the claim is that claimant holds quiet title established by verified court, public, and published records to the private lands and homes in controversy.
You don't have to put that stuff in. You just have to say, is they're interfering with my rights, or they're interfering with my property, or they're interfering with my access to property, or they're trespassing upon my property. Something very simple. And that's it. Let them ask you, would you like to embellish on that? Would you like to provide us a little more information? Because honestly, we really don't know who the hell you are. So like I said, initially, it's just like, if you ever seen like a warrant in debt, if you ever went to court, somebody owed you $500. The court clerk would say to you, what do you need? This guy owes me $499, $500, whatever they owe me. Fine. It's like, would you like to fill out a warrant of debt? It's like, what's that? And the court clerk will say, well, you put the dollar amount here, fill out the summons. They're either going to pay you in 21 days, or we're going to have them come before the judge or the jury, and they're going to explain why they should or should not pay you the $500. And that's it. So all you do on a warrant of debt is it looks like the size of a postcard. It says put down the dollar amount you owe, put the person's name and address, say he owes me $500. That's it. You know, if you want to say he owes me $500 of past rent, okay, you can say $500 of past rent. But you're just going to piss the court clerk off because she's going to be like, oh, well, we really don't get involved between landlords and tenants. We don't really do that. We don't like to do that. I'm sure there's a contract somewhere in there, and I'm sure there's a way that you could, charge the guy a fine or a penalty or a late fee. We don't really like doing that. Like I said, my sister got summons one time to court. The guy said, you owe me $1,500. $1,500 for what? So I said to her, right, ask the man for a bill of particulars. So she had to fill out a bill of particulars. It says, itemize the $1,500. But most people don't. They just say, you owe me $1,500? Okay. And they don't bother answering, and then you get a default judgment on. So make it just simple. You owe me $1,500. If they don't know who you are, believe me, I'm sure they know who you are. If they don't know who you are, well, thank God. The clerk of the court doesn't care. It's like, oh, my God, this was the greatest paperwork I've ever filed. One sentence done. I don't want to get involved. She don't want to get involved. Believe me. She wants to go get a cup of coffee and go smoke a cigarette. She doesn't want to get involved. Like, ma'am, can you make your claim easy here? What's that? They trespassed upon my property without right on a demand compensation out of $5,000. Oh, wonderful, lovely. Thank you. Boom, boom, boom. She's going to summons them to answer. They got 21 days to do it, appear in court on day 22. It's that simple.
When you ask them to issue the summons, do they give it back to you to serve it, or do they serve it themselves? Is that what you're asking them to do?
No, well, you hand them, like, that's what part of the filing fee is they, when you write out the summons there before them, like, who would you like us to drag into the bill?
I gave them 3 for the 3 wrongdoers, and when they did the case wrongly, they didn't give those back, so I reissued them when I made the correction. So do they issue the summons? I was under the impression that we have to actually serve the summons to the people.
No, you go to the court clerk. That's part of the filing fee process. That's why if you want to have them serve a summons upon 1,000 defendants, thank God you only pay the $50 filing fee because, a subpoena is different than a summons. So when you summon these people to appear, the court clerk, what she will do is she will put it in like the box that goes to the sheriff's department. The sheriff's department will come there first thing in the morning, 6, 7 o'clock in the morning. He'll pick up all the summonses, and he'll give them out to the deputies and say, okay, you know where this person lives, you know where this person, this part of the state or this county, you go take care of this. And then the sheriffs and the deputies run around and they just deliver the summonses.
Do they deliver the summons and a copy of the case, or just the summons itself?
Well, I kind of figured everybody knows. All you do is you make an envelope with a copy of the claim to the wrongdoing. You stick it in a manila envelope, like a nice 8x11 envelope, whatever they call those, and you staple the summons onto the manila envelope. So when the sheriff gets it, all he's doing is holding a manila envelope in his hand. That's got a summons staple.
Now,
Right.
what if some of these people are not local? Like one of them is back in Washington, D.C. in Fannie Mae's office, and one is, 400 miles away.
Well, it depends. If they have offices, like if you're suing like somebody who, like an insurance company, like you're suing somebody who hit you with a car in their insurance, like State Farm or Allstate, you could sue them in your local court because they have agents all over the state, so they will answer the claim anywhere. So it's the same thing, I guess you could say, with Fannie Mae and Freddie Mac. They will answer the claim wherever they conduct business. So if they conduct business in your county, well, then they have to understand they're going to have to be obligated to settle matters in your county.
Well, I'm naming the individual who is the president CEO of Fannie Mae back in Washington, D.C.
He'll answer you. He'll give you an answer. He'll say, you know what, that's I can't come, or whatever, it's too far, or she's going to have to serve me in my local jurisdiction. I'll be glad to answer, but I can't, I believe that, she's outside of the jurisdiction in which she has any control. That court has any control. That court can't drag him back in. If he, like I said, if he says, well, you have to, if I did you wrong, you have to sue, like me, I have to sue Alabama in Alabama. I can't sue Alabama in Virginia. Even though it's convenient for me, I can. But if they had an insurance company that was indemnifying them and I was going after them and their insurance company, then I could sue it, make a lawsuit down here in Virginia because they have an insurance company and insurance companies have to answer anywhere in which they provide coverage. So if they were covered by the Travelers Insurance Group out of Hartford, I was like, Travelers has everywhere in this country. Great, that's lovely. I'm just going to sue Travelers and let them, worry about how the defendants are going to get down here or whatever. But like I said, I don't know why. Like you said, you're going after Fannie Mae and Freddie Mac and personal people. I don't know. That's an awfully big. That sounds like an awfully complicated lawsuit. Where you're trying to go after those.
Well, they're trying to take our land and our home, and on a false foreclosure sale, and so that's why I'm doing the suit. And it was all done wrong, and they're still trying. I've shown them it's done wrong. I have the quiet title through different courts, and they're still trying to get it. So,
somebody who's claiming the property is theirs?
Fannie Mae.
Okay, so all you have to do is send this Fannie Mae to answer, how they believe.
I did, and I did the fair warning notice, and they've received that. And
so what did they do?
Gave them the affidavit of publication of quiet title, and another court where there was quiet title, a rescission of the deed of trust, so that the sale was based on a false premise. So things done. So
what did they say?
What did they say? They're just basing this on a trustee's deed that was obtained fraudulently, and that's the only thing they're looking at. Even though there's other things in the public record.
I'm saying you really got to go back and listen to how I do things, because what you're doing is way too complicated, and this stuff is so simple it's scary. All you have to say is who's making a claim for this property. Don't get cute. Just say who's making a claim for this property. Who's ever making a claim for this property? Let them speak now, forever hold their peace. Come to court under oath of affirmation and verify your claim to be true. Or any claim to any claim or interest that you have in this property will be deemed void from here on for the rest of eternity. Just make it simple. None of this ma'am, I'm telling you, I'm not who does this show? John Stewart. John Stewart does like an Angela call on Sunday, and he will talk to you for hours about how to do quiet title, and I go around with him and stuff, and I make it beyond simple, and he doesn't like it simple. He likes it complicated, and he likes to act like an attorney, and he likes to do quiet title and sesticate deed trust. He likes to do all this silly nonsense. And I'm saying there is no man from Fannie Mae or Freddie Mac who will ever appear in any court to testify in the oath of affirmation that Freddie Mae or Freddie Mac has any claim to that property that you claim is yours. They will never do it. So make that one sentence to Freddie Mae and say, I believe that no man, Freddie Mae, Freddie Mac will ever come to court under oath of affirmation verify that any claim to that property is true. So I order you to cease and desist any action in which is interfering with my right to that property. It's simple. Now, if you want to talk like a lawyer and you want to do these 500 books, like I said, like Mr. Stewart, nice man. We talk nice and pleasant to each other. But it's insane. I am not spending my life studying how to be a lawyer and acting like a lawyer and talking like a lawyer and submitting paperwork like a lawyer. I'm not a lawyer. I'm a man. This is my property. Does anybody have a claim to this? Listen now. Come to court under oath of affirmation. We're doing it on Tuesday. Put your hand on the Bible, swear to it, and prove to that jury that that land is yours. Do it.
I did that in fair warning notice. I said no man will make a claim saying our claim is untrue. And we gave the right to administrate it.
And you made that one sentence thing, and you were done, right? No, you've got to keep putting paperwork attached. You're attaching all kinds of exhibits. You're attaching all kinds of nonsense. You just make a simple claim to them and say you got 21 days to respond. You got 21 days to answer. I'm taking you to court, and I'm going to take you before a court of record. And you're going to have to come here because a court of record is the Supreme Court of this land. And that's what I'm saying, literally, this land. It doesn't mean dirt. It means the supreme law of the people. The Supreme Court of the government is the Supreme Court of the United States. That's the Supreme Court of the government, of one of the three branches of the government. They determine controversies between the executive branch and the legislative branch. That's what the Supreme Court of the United States does. It doesn't get involved with the people. We have a court for the people. It's called a court of record. And we move by trial by jury. That's the supreme law of the land. Not the dirt, the land. The people. It's that simple. So all you do is you say to them, I'm going to move you before a court of record. A trial by jury. They know Article 7. They know that Article 7 of the Bill of Rights of the Constitution, what you call the 7th Amendment. They know it. They know exactly what it means. And once a trial by jury in a court of record, and it only moves under the common law, and only a man can testify before a common law court of record. You better bring a man forward, and he could prove, beyond a shadow of a doubt, that that's his land. Oh, I'm claiming on behalf of Freddie Mae and Freddie Mac. Well, Mr. Freddie Mae or Freddie Mac, Mr. or Mrs. Freddie, because I'm not really sure if it's male or female, they better appear, and they better make their claim. Let them make their claim. I was like, well, you know and I know they can't. Well, I don't know. Maybe there really is somebody called Freddie Mae. Maybe there really is somebody called Fannie Mac. I don't know. I'm just some stupid schmo out here in the middle of nowhere land. I don't know. All I know is somebody named Fannie keeps saying that I'm on her land. Let her come forward and make a claim, or forever hold the peace. It's that simple. Now, if you want to talk like a lawyer, John Stewart's show on Sunday, he's awesome. He will do all this nonsense with you for hours. I won't. I'll just say, look, this is very simple. If you don't want to use the court of record, if you don't want to use or that this is a common law nation, if you don't understand that the supreme law, the Supreme Court of this land is a court of record, and the people and the jury makes the laws of this land and establishes whether they're true or not, okay, don't. If you believe that the legal society and all their code books and all their rules and their Supreme Courts make the rules for you to live under, well, God bless you. That's like a two-dimensional world. If you want to live in a two-dimensional paper world, you just do it. If you believe a piece of paper can control you, God bless you. To me, only a man can control me. Only another man could touch me and force me to do something if I'm causing him harm. A piece of paper can't say, well, you're causing me harm. I'm going to take you over. Oh, really? I'd like to see you do that, piece of paper. I'd really like to see you touch my body and force me into a cage. I'd like to see you do it. Like I explained a little earlier, that old man in England said to the bailiff, touch me and I'm going to sue you. I don't care what that judge said. I don't care what his order says. I don't care what his piece of paper says. You touch me, you're the one I'm going to sue. You're the one who I'm going to own. You're the one who I'm going to sue and take his pension. Just because Adolf Hitler told everybody to throw all these women and children and kill them, those German soldiers who did it after the war, they were killed. It's like, because you know right from wrong. You know not to kill. And you know if you kill, you're going to be killed. Well, I was ordered to do so, and I had a piece of paper, and it said, I don't care what your two-dimensional silly piece of paper said. You know it, I know. If Adolf Hitler told you to kill your mama and your children, you wouldn't have done it. But since they weren't your mama, and since that wasn't your child, well, okay, I'll kill them. If it was your mama and child, you'd figure out a way to get them out of the country. So what made you think your mama and child was any better than that man's mama or child? So it was a wonderful thing, those Nuremberg trials. It was lovely. That way you folks can understand the difference between a two-dimensional world and a three-dimensional world. You can't be controlled by a two-dimensional piece of paper. And if you choose to hold your loyalty in your two-dimensional world, the three-dimensional world is going to come down on you someday. So I think this stuff is super simple. And you guys, if you want to play pro se's and you want to play attorneys, this is just what's going to happen. You guys are going to get run over like a freight train. Because you are not going to beat them at their own game. You're not going to beat them at their, well, I got a land patent. You're not going to beat them at their own verbiage. You ain't going to beat them at their own game. The clerk at Renison is going to tell you go pound salt. The contract says $51.12. You will pay me $51.12, or I'm going to have the Rockbridge County Sheriff's Department come to your house with a warrant in debt, and they're going to come in, and they're going to have a writ of attachment, and they're going to drag that sulfur out of your house. So now, are you going to pay the $51.17 you owe, or what? He said, well, all I could do is $30. He says, well, you know what? We'll see you in court in 21 days. We'll come up with the money. And he said, well, exactly what he said, Carl. And they're going to drag me into court. I said, you're going to win. Just relax. I said, who did you call to be your witness? I said, I got James Best. I said, okay, that's good. He's a nice guy. I know who he is. So when I went before the court, I said, me and my sister came down the road, and him and his buddy stopped us and handed us a watermelon. I guess that was his payment for me helping him win.
Mm-hmm.
He said, well, it worked exactly like you said, Carl. It's like, what? He says, well, we got in front of the judge, and he said, yep, the little redheaded lady was the attorney for the Renaissance. I said, oh, yeah, she's a mean one. I said, she'll take the 90-year-old lady's sofa or her bed right from under her butt. She don't care. I said, yep, I know how she was going to move in court. So I said, what happened? She said, the Reynolds said, a lady said, presented the contract, presented like 10 copies of it, had all kinds of secure documents and everything else attached to this. Beyond a shadow of a doubt, there was no doubt about it. I owed $50.17. Had all kinds of proof and thousands of documents to back up her claim that sulfur should be brought back to Renaissance immediately. I said, so then what happened? He said, I told the judge what you told me. Tell him. I said, well, I tendered her, the boy at the desk, his name was, Charles, $30, and he told me, you will pay what it says, or we are going to come and take it away. So he said, well, what's this guy? He said, well, he's my witness. He heard me say it to the clerk. He said, did you witness this man say to the clerk? What did the clerk say to him? He said, you bring us back the damn sulfur, or we're going to drag your ass into court. So then he said to the Renaissance lady, will you accept $30 payment a month for the next 10 months until he pays us off? She said, no. He said, case dismissed. Enjoy your sofa. Simple. He didn't bring in no documents. He didn't write no grand manifesto that you folks are doing. He didn't do no studying. He didn't talk to any freaking lawyer. He didn't read any freaking books. I said, this is the law of the land. Whoever brings the controversy into the public has already got a strike against them. So Renaissance did, because this man was willing to settle a matter on a private side. It said that he's moving into his best faith because he was tight on money. And until he could come back on his feet and get back to paying $50 a month, the best he could do is $30. And then the judge did in open court say, will he accept the $30 and accept this man his word that he doesn't really have a job right now, can't afford it? Will he accept his partial payment to settle the debt? She said no. He said case dismissed.
The best way I can explain this is the most simple sentence that you teach.
Oh, that's a good one.
I love you. I love you. Okay?
Yeah.
In the sentence, I love you, you got the subject, the predicate, and the direct object. Okay? Each one is totally unencumbered by any modification. Each one has no temporal limitation to it. It has no circumstantial limitation to it. The sentence, I love you, says, I, from the beginning of time to the end of time, love, the verb, the action, you, the direct object, with no limitation whatsoever. Now, and if I say, I love you more today than I did yesterday, oh my God, no, I really got myself in trouble.
I see.
If I say, I love you more than anybody else, that really chops to pieces. How about I say, I, in my present capacity, in my newfound knowledge of who I really am, love you. You know, every time I try to throw something else onto that simple sentence, it can only make it less than the absolute.
Hmm.
All right?
Yeah, I get it.
It can only make it less than the absolute.
Right.
So whenever we say something, we want to choose, even if it sounds like pig Latin, even if it sounds almost like non-good English, if our grammar teachers would come back and spank us, you know, it's better. It's better to be succinct and plain in absolute in our terms and not modify things. Adverbs and adjectives will destroy your claim. So if you can talk to the judge like a 3-year-old saying to his mom, I love you, you can get more work done than if you try to sound like a fancy attorney.
You always have the right to move it before a jury, because I'm trying to remember that, who was that, Alec Baldwin and Kim Basinger, they had their divorce in a trial by jury up in New York, up in Long Island. So I don't want to hear...
He talked about parental alienation, but did he win? Because I didn't know they had a jury. But here in Canada, I asked the judge, I said, I want a jury. And he said, you can't have one. It's a civil court.
That's right, because you didn't invoke it. You didn't know that you had, hey, look, there's a matter of controversy here. I have the common law right to have this matter of controversy moved before a trial by jury. And he says, well, you got a marriage license. Well, you know what? I could supersede that by saying, you know what, I'm still evoking my right. Just because there's a privilege or a license that says that I am married to this man, that does not negate the right to a trial by jury over any controversy between me and any other man. So like I said...
Because every jurisdiction recognizes that there are multiple layers of marriage, okay? There is a common law layer of marriage, there is a church layer of marriage, and there is a civil layer of marriage. And this judge was only speaking on the civil issue, okay? But if you pulled out your trump card and threw it at him, he would have gone, oh, shit, she did that.
But you have to know how to throw the card. This is what I'm trying to teach people, how to throw the card.
Yeah.
But you got to do it in writing. You can't do it verbally. You can't be a lazy piece of whatever and just wait until you get before the judge and say, well, I'm going to throw this trump card and see if this works. I'm going to throw it and see if it works. No, you have to do it in writing. So this judge says, holy cow, here we go. This woman threw a one-sentence word at me, a one-sentence phrase. I'm bound by what she says. There's nothing I could do. I'm stuck.
What's that phrase?
It's just, like I said, I was lucky. Like I said, every case is like a little bit different, but like I said, how I taught my sister when she went through her divorce, I just said to her, I said, look, she was cursing at me, my mom and dad, because nobody gave her $20,000 to retain an attorney. So I just said to her, look, you don't need one. And everybody said, you don't need one. Just do what your brother tells you to do. And she's like, but wait a second, you didn't graduate 10th grade. I got Look, when you walk in there, since you're the prosecutor, she always goes in as a prosecutor. You never go in as a defendant. You always go in as a prosecutor. And I just said, just say, I, Karen, and my case are now at court. I present I and case to court.
My case? My case?
Yeah, I and my case are now at court. I present
I and my case.
Yeah.
And you write that first?
Yeah, I said, I and my case are at court. I now present my case, I and my case to court. And that was it. And the judge said, well, do you need a representative? And she's like, I, Karen, I'm going to tell you your last name, I, Karen, I'll say Lentz because that's a different last name she has.
Yeah.
Karen Lentz and case are at, I present at court. I present I and my case to court. And the judge lady says, well, if you can't afford a legal competent counsel, we will provide one for you because you're going up against 3 attorneys and your ex-husband. And are you sure that you are representing yourself? Are you sure you don't need our help? Are you sure you don't want somebody here to do this for you? She says, I, Karen Lentz, and case are now before this court. At court. I now present my case to court. And
I hear what you're saying. Yeah, present is the word, not represent. Present.
Well, I don't get into semantics, with you guys. You guys have your own beliefs on these words because there's other guys who do these shows that crucify uppercase, lowercase nonsense because in Canada they do use uppercase, lowercase on birth certificates, so I don't want to even go uppercase, lowercase. That's nonsense. I'm not dealing with words.
Okay.
The judge sees that you're making a claim, Now, whatever words you use, she's trying to interpret the words you're saying, but she has no right to interpret it. The judge is just saying, okay, this woman is stating a claim. She made her claim. She said it 3 times. This is her word. This is a bond. I cannot break it. She did not break it. She is moving.
The whole thing is 3 times.
Well, okay, it could be 100 times. It could be 1,000 times. The judge could ask her 1,000 times. What she's doing is my sister is showing that it's etched in stone. What my sister is showing is she's giving her word. She is making her word. This is her bond. It's not one word is being taken away, not one word is being added. Now, you could Google that on the Bible, and you'll find it where it comes out of the Bible. Take no word, add no word. And you'll actually find it's in the Bible. That's how you present yourself to court. You have to say the same thing like a broken freaking record because that's what you're doing. You're pressing your word onto the record. So when they play back the record, it's always going to say the same damn thing. So that's the whole trick when you move in common law. Because, it's, like I said, the poor Dean guy, I said, you realize when you changed your claim.
Clifford?
Well, whoever.
Oh.
When I'm going to put what I told him on his show on my webpage. You could hear. He's like, "Oh my God, I see what I did. That's lovely. I'll never do that again." I said, "That's right." He pulled you out of common law, and he protected you. He brought you over to the civil rules.
Mhm. Who did?
Because you broke your word. And in biblical times, when you changed your word, or you modified your claim in court, you were killed. They don't have time. The king didn't have time to listen to this nonsense. Is this your word? Are you saying it's true? Wait a second. You just said this. Now you said this. Now you said this.
Oh.
Just kill this guy. Just get this guy out of my court. Kill him.
Oh my God. So this is what you're saying is that's why it's really important that it just be a few lines, really simple, just repeating yourself.
Well, that's one of the 10 commandments. It's like, what, 613 commandments? But the big one is bear no false witness against thy neighbor, because whatever you bared against him, if it was found out that you bared false witness and you filed a false claim, it was death. Or whatever you wished harm to your opponent, if you wanted 10 camels, then you had to pay him back 10 camels. That's what.
And that's the purpose. And that's the purpose of a bond.
Right.
The bond is, you know, when they do commercial bonds or lawyer bonds or judge bonds, it's like, if this guy wants 10 camels and I screw up, I've got to give him 10 camels.
And that's your word.
Same thing.
Well, that's for the expense.
Right. Your word is your bond.
Right, and it's the reason why you make sure the other side has a bond before they file a claim against you is because if they have a false claim, like you see this on TV movies all the time, so, well, great, now this Marsha Clark just destroyed my life. I'm poor little Mr. O.J. Simpson. It just cost me $15 million to defend myself. She filed a false claim. I'm bankrupt. My name is destroyed. My children have been taken away from me for years. I've been sitting in a jail cell. She filed a false claim, obviously, because the jury found me not guilty. Where is her bond so I can recoup my $15 million in lawyer's fees? He didn't ever ask, Judge, when I win, I want my money back. He could have got every freaking dime back, but somehow somebody forgot to tell him what law is. So Mr. or Mrs. City of XYZ is going to appear in court under oath of affirmation and going to take the stand and testify, and so I can cross-examine the harmed and injured party. Because I've been trying to compensate Mr. or Mrs. City of XYZ, and they never, you know, I'm tendering them all kinds of offers, but they're never accepting anything. And I'm trying to settle a matter on the private side, but they refuse to respond. How do you want me to settle a matter if they refuse to respond to any of my offers for compensation of any harm or any injury I've caused Mr. or Mrs. City of XYZ? There you go. Yeah. Have you tried to settle a matter on a private side? Did you tender an offer to City of XYZ?
Well, isn't that the letter that I was just talking about that I'd like to get from you?
Well, that is more of that is not a settlement on the private side. First, you tender an offer to the party that's claimed that's doing you harm. You say, greetings, Mr. or Mrs. City of XYZ. I've never been formally introduced, so I'm just, Mr/Mrs. XYZ, City XYZ. I believe that there's a claim before the court that I've caused you harm or injury. May you please tender me a bill of particulars and itemize the damages that my acts did or did not do to your person. Thank you. Sincerely, Mr. and I forgot your name.
Robert. Okay.
There you go, Robert. There you go. Now you recorded the show. I'm recording it. Whatever. You just don't ask me to repeat it because I probably do it wrong. But when I say it, sometimes, boy, it comes out good. And then just
so you submit this letter with the bill of particulars first.
Yep, you demand the bill of particulars, right? Exactly.
And then they're probably not going to respond, and then that's when you come out with the letter of the fair warning.
Like the cease and desist. I said, since I still see that it's on the docket that Mr. or Mrs. City of XYZ is still trying to believe that they're going to move a claim, and I tried to settle on our private side. Obviously, that you have no intent on settling this matter, honorably, under good faith, under negotiation with me. So, any further communications with me would I be deemed as harmful to my person.
Okay.
And if you insist on, I see it on the docket tomorrow, I'm going to file a claim against you, filing a false claim. But there is no injured party. Nobody will testify in the open court under oath of affirmation. And like I said, in the way you stylize it, you make sure you make your own claim. And I always show people how to keep common law. Don't use silly stuff. Don't just say plaintiff and your name. No, just say, hey, man, put your name in there, prosecutor. That's all.
Yeah.
Just say, hey, man, Robert. You want to put your last name in there? Put your last name in there. If you don't want to, you don't have to. Just say, hey, man, Robert, prosecutor, versus, or just a straight line and put, City of XYZ, wrongdoer. Make your claim. I tried to, they're trying to administrate my property without rights, which means they're trying to take money away from you or order you to do so and put you in a cage. They're trying to personally, take your possession of your property, which is your body. And there's no claim before the court. There's a false claim, in a traffic court, and there you go. And you file it in your local district court.
But we basically replied to his, send us a letter in writing as to, your legal basis. So we wrote back, well, thank you for reviewing our documents.
Right. And I think I told you, don't do legal basis. You could attach a legal.
Yes, that's right. We put, we apologize for any confusion. As the aggrieved, our lawful basis is that we require the use of this venue as a court of record to seat a jury in which we move our claim before. So
there you go.
Determine and render a verdict as to who has the lawful right to tender or administrate our property.
That's a good letter. Did you send that to me? See, now you're starting to get it.
We, the aggrieved, or the defendants. And immediately, as soon as he received this, within an hour, he opened up a court of record for us. The court stenographer and the court clerk, and he basically brought us right in. He had the habeas and he had the claim. And
do you know why?
He basically said...
know why? They opened it up. Do you know why they opened it up?
Why is that?
Because you're considered like a king or a queen. You're considered a sovereign, and when you want to convene court, it's open to you 24/7. Like, if you ever watch an old movie, like a Queen of England, Elizabeth II or whatever, Elizabeth I, and all of a sudden she wakes up at 3 o'clock in the morning and she says, round up my court. Get my court. It's like, Queen, it's 3 o'clock in the morning. Well, I'm convening court. Get everybody into my court now.
Right.
Right. You do. And the judge realizes, like, holy crap, we got a queen or a king present before the court. We got to convene.
Yesterday.
That was kind of our feeling about it. We're like, oh, finally, they got the memo. Everyone started to change their attitude completely. There was no more mocking, and there was no more, no, we won't take this paperwork. It was, yes, right away, sir. Yes, right away, ma'am. Please just be one moment, and we'll be right back with your original copies. And, it was a complete, utter turnaround, complete 180 from Wednesday when we tried the same thing.
What I'm saying to you, folks, So what I'm saying to you folks is this talk making a little bit of sense. Hang on a second. So what I'm saying to you folks, start to understand that when you're in a common law nation, these people in the black robes do understand their role.
Yes.
Yeah. See, this is what I'm trying to tell you folks. These These judges aren't stupid. The court clerk isn't stupid. The clerks of the courts might be, you know, a little bit in a shadow still. They might not know the whole picture. If you go to the chief judge, he knows what court is. He knows exactly what's going on.
Right.
He's not stupid by a long shot, but like I said, he's trying to throw that little hook in there to keep you one side of being totally what you folks would call free of their control.
Right.
So they're trying to keep one foot in the door. They're trying to do it, and he's got to do it on their side. He's trying to help his society, his legal society, his government. He's trying to make sure that you're not going to both break away. It's like, you know, Canada's like considered not like, well, maybe it is now, but you know, like England or the UK has dozens of like satellite countries that aren't fully sovereign. You know, there's like 120 countries like still under the control of England or the UK. But they go keep that one foot door, and they don't truly let those countries break away. You see what I'm saying?
Yeah.
That's what they're trying to do to you. They're trying to let you break away to a point, but they still want to make sure they maintain some sort of control and authority over you by stylizing your order in a certain manner.
Another control mechanism.
Just that's all I'm trying to say. They're smart. This guy is smart. Like I said, that's why I got asked to be a judge plenty of times, because I know how to throw that little hook in there to keep you under my control.
Wow.
Yeah, it's that simple. It's very simple. This is very simple how they master the mastery of the words. And you'd think that they're being kind and, you know, but they're trying to keep one foot in the door, because if this stuff breaks loose, what you're going to do, like I try to say to you, what I do, if this stuff breaks loose, it's going to be unbelievable what could happen. Tell you what they're going to do is somebody in the government's point of view is now going to propose to you and offer a condition to surrender or conditional acceptance of let's see if we could just, let's just all kumbaya this and give each other a big hug and say, let bygones be bygones. And you know what? As long as you let us come to the house once a year and stick our foot in the door and take a look, make sure everything's okay, and you're not smoking pot no more, and you come down for a drug test maybe every random time, well, we'll be more glad to turn your kids back. That's exactly what they're going to try to propose.
Right.
But if you didn't do this crazy stuff that I told you to do, they totally ignore you for years. These people are evil. They're just freaking evil. Yeah. But they're going to try to come and bring the nice woman or the nice man with a nice hat, nice pocketbook, nice pair of shoes, nice dress, the nice man with cologne and shaved tight, tight trim haircut. They're just evil. They couldn't care less if you sat in a box in a cage for the rest of your life and your children watched you through a plastic screen. They couldn't care less.
Oh, not at all.
So as long as you always remember to be extremely polite to these people, extremely courteous, yes sir, no sir, yes ma'am, hi ma'am, being fairly polite, but just realize that you're trying to make a deal with the devil. And I don't care how tempting the offer is and how sweet it sounds and kumbaya it's going to end, I am telling you, you're still dancing with the devil, and you're going to get burned. Whether you believe it or not, you're going to get burned by these people. They always have a way of backtracking, double-speaking, and making you believe.
In there somewhere.
Yeah, there's something in there. Like I said, that judge was nice and sweet. And when Greg told me that, I went bananas. I said, he did what? Well, don't claim it as property. Do human beings. What? No. Hey, stop. Greg, they didn't do that, did they? And I was like, you know what? Let me talk to this lady. Tell the lady to be off. We'll do a show at 8:30. Tell her to get on, and let me see if I can get her to understand this a little more clearly, because this is going to take a little bit of a whacking with a hammer in people's heads to start to make them understand. Stop this. You're the king, you're the queen, you're convening court. They jump through the hoops. They do what you order. If nobody appears before that court that day with a superior claim to the possession of that property, the property is being held in naked possession, which means without right, by some foreign entity. And you order it to cease and desist immediately, and for that property to be transferred back to its proper place of jurisdiction, which is 106 Apple Street, New Brunswick, wherever you happen to live.
Right.
And that's it. And if they don't do it, then you sue them.
That's right. And
that's
basically where we're sitting right now. It's like, here you go. Bring your superior claim, and if you don't do it, And it's essentially what the judge is. It almost seems like he's trying to help us do. He's like, I know, yeah, I completely understand where you're coming from. I know that you guys know what you're talking about. You're very articulate. You're very sharp. You're very bright.
Yeah, get rid of superior claim. Get rid of superior. Just claim. Stop diminishing the capacity of the subject or the noun. Yeah. It's a claim. Bring a claim before this court. And this court is the court of Jesse and whatever your husband's name is. This court.
Right, Jonathan. Yeah.
Right, not family court, not civil court. Bring it before the Jesse Jonathan court. Because if you look in the United States Supreme Court rulings, it'll say in the Roe case, or the Hibble case, or the Terry case. And that's what they'll say. And then if you read, like, say, it's or they'll say it's like the Hale versus Hinkle. They'll say in the Hinkle court. Or if it was Sanford versus Jones, it'll say in the Sanford court. They don't say in the Middle District Court of Kentucky, where the trial was held, and now it's up here in the Supreme Court. They'll say the Sanford court, or the Hibble court, or the Terry court. It's your court now. So you stylize it. The summons them to appear in the Jesse, what's your husband's name again?
Jonathan.
The Jesse Jonathan court. The Jonathan Jesse court is going to convene on, and anybody who wants to bring a claim forth to the Jesse Jonathan court, when the judge sees that, he's going to work out a pickle. I am telling you, he is going to know, well, now you know, but you didn't know 10 seconds ago, that you know law like nobody else knows. He's going to think you're a rocket scientist. He's like, how the hell do these people know this? He's like, well, tell him some clown from Virginia told you. But they're going to say, holy Jesus, how does this lady know this? How does she know to say that the Jonathan Jesse court is going to convene on the 10th? If anybody wants to address court and come with a claim, this is the time to make their claim known to court. There you go. Or said court. Oh, that's even worse. S-A-I-D court, said court. Because you're already established as a Jonathan Jesse court. Or you use your last name, which is even better. A Livermore court, whatever you guys go by. What's your last names?
Little and Arsenault.
What? Arsenault?
Little and Arsenault, yeah.
There you go. Little Arsenault court. There you go. Or if you're the mom, I'd put it under the mom's name. These kids are young, right?
That's right. They're young.
Yeah. Who's the Arsenal, the woman?
The Arsenault is me. That's my maiden name, and all the children go by little, other than one who's from my previous relationship.
Then what I'm saying is I would make it the Arsenal court if you're the mother. The Arsenal, and then the next person's name.
Yeah.
Because you want the mother to be in total control of little ones, because she's got the capacity to deal with that, not a man. I don't care. I'm sorry, guys. I'm not on your team on this one. I'm sorry, but it's the mom's property. She did 9 months. I explained that yesterday. Like I say to people, I said, if me and Greg, we get along great, I chop down a tree. It took me 10 minutes to chop the tree and drag it down here. I did 10 minutes work. Greg whittled that chair for the next 9 months. Now, I could say, well, I gave Greg the ability to whittle that chair because he was in my house using my electricity while I was feeding him and while I was providing everything for him. It's like, you know what? I could sue him for the electricity he used then. I could sue him for the food he ate. I could sue him for the rent, but I can't sue him for the chair. That's his chair. He produced it. He labored it. That's his chair. He's the creator. He's the laborer of that chair. All I do is put 1% into that chair. He has, to my belief, he has the right to totally claim and possess 99% of that chair. It's Greg's chair. I sue him for, because he occupied my house. It's the same thing with a wife. It's her child. Can you sue her for the electricity by housing her for 9 months? Sure. Can you sue her for eating 9 months worth of food? Sure. But don't dare think for a second you're going to sue her for that child. You only put 10 minutes into it.
Yeah.
So, see, that's how I look at it. So I'm not trying to bash men, and I'm not trying to, glorify women, but I'm just trying to say this is the way I would look at it when somebody produces anything, whether it's a chair or a child. Like I said, my dad, my grandfather were from Germany. They did not speak or read right English. They never read a book in their lifetime. These men can hold themselves in court. That's how this country was established, because people were coming over from Portugal, Siberia. They would come from Russia. They were coming over. They were coming from all over the planet. So we did not have a homogeneous society like England did, where it was an English common law. we had to learn to adapt to many different customs and people who had their own beliefs, and we couldn't say your beliefs are no longer good. Or when this country was established in, what do you say, 1783, when the Constitution was, whatever, we already existed, say 1800. We already existed. This country, this nation, what we call the United States, existed for 300 years prior to the Constitution. So people forget that we had people living here in 1500, 1600, 1700. So when the Constitution came around in 1800, that did not negate the fact that there was customs of the people who already inhabited this land that still stood true. The Constitution didn't wipe out all those people's customs, beliefs, or practices and said, no, you will only have one set of beliefs. Like what happened over in England. You will only have one church. It will only be the Church of England. And if anybody dares to do anything other than what the Church of England says, off with your head. No. In this country, they said, whatever you people believed in, God bless you, just keep going at it. There's 516 different religions in this country, 10,000, 1,200 different customs and beliefs. God bless you. Do whatever the hell makes you happy. Just remember the golden rule, don't hurt anybody else while you're doing it. Don't cross into one society and hurt another society. That's all. If you people want to hurt each other within your own society, go for it. It's like a legal society. If they're going to do whatever they want to do, that's fine. Don't cross into the common law society, our common law, and think you're going to bring your legal society into our society and cause us harm. You're not going to do it. We're not subscribing to your beliefs. We're not held under your codes. We're not going to appear in court as a pro se or a temporary attorney. We're not going to appear with an attorney so you could enforce your legal societal beliefs onto us. We're not going to do it. We have the right not to believe what you people believe. We have the right to have our own separate beliefs, even with the only ones on the planet who believe this. We have the right to do this. And it drives them totally insane when you realize what nation, what form of nation that we have over here.